Good morning, ladies and gentlemen. Thank you very much for coming at 9 a.m. After yesterday's very intense session. I fully understand the heroic gesture you make to arrive early morning. I had the same feeling. However, we have a very intense session today. As you saw, that we have 4 sessions which are focusing on different aspects of the issues of the access to effective remedy, the humanitarian impact of unilateral coercive measures, as well as the issues of the responsibility. Yesterday, we were discussing the impacts and the challenges faced by humanitarian actors. So eventually, we are able to identify the existence of the problem and some of the challenges. But now the important element is to identify how we can protect human rights, how we can protect the interests of states in the case if international obligations are affected. Unfortunately, we will have to speak about the ways to protect the interests of businesses, because quite often they are very much affected by overcompliance and enforcement. And proper functioning of the business area is necessary to ensure proper delivery of humanitarian assistance, to ensure that the economic development of the country is happening in the proper way, and I will have to address the issue already mentioned by one of the speakers as regards the ability of states to ensure that the social development and social support is available for the countries. So today we start to discuss elements which will be more focused on the access to effective remedy and in the same way on the issues of responsibility. I had a feeling that my task as a special rapporteur was to identify and to propose the ways for states and individuals to bring international law back at the table and to protect their rights. So with all that in mind, our morning session will focus on humanitarian action in sanctions environment. And we have 5 panelists, so 2 of them online, and I hope our last panelist is coming. I have been lost in this building again in the morning, so Professor Strauss saved me and brought me to the necessary room, because otherwise the moderator will not be here yet. So I believe that it might be the same situation with our last panelist, because the building is very complicated. So without further delays, I just want to remind you that we have now the academic and expert discussion with the good opportunity to ask questions and to get good answers. So the panelists will have around 10, maximum 12 minutes to present, and after they are done, there will be opportunity to ask questions or to do some shorter comments, both for those participating in the room and participating online. And our first panelist is Professor Xianhe Yi from the Chinese University of International Relations, who will address the issues of the conflict of norm considerations surrounding humanitarian actions and unilateral sanctions, inspirations from the ICJ advisory opinion on presence and activities of the UN and others. And I believe that what we can consider for the future, I'm coming back to the question which has been asked very frequently, shall we request for the advisory opinion of ICJ to decide about the legality of unilateral coercive measures or not, but we will see. Professor Xianhe Yi is addressing via video statement.
Good morning, Madam Special Rapporteur. I thank you very much for this opportunity to speak to the conference. I would like to congratulate you and the mandate for holding this conference. I would like to clarify that I am from the China Foreign Affairs University. Okay. I would like to make some remarks on some conflict of norms considerations surrounding humanitarian action and unilateral sanctions, inspirations from the ICJ advisory opinion on presence and activities of the UN and others, Humanitarian action is a big topic. Unilateral sanctions is a big topic. Conflict of norms is also a big topic. To talk about all of them in one place is a difficult task. My ambition in this short presentation is thus inevitably limited. I will just briefly highlight the relevant parts of the ICJ advisory opinion on presence and activities of the UN and others in and in relation to the occupied Palestinian territory delivered in October 2025 and draw some inspirations from what I consider to be 3 conflict of norms scenarios present in that opinion, though not expressly discussed as such. In that advisory opinion, the court answered this question presented by the General Assembly. What are the obligations of Israel as an occupying power and as a member of the United Nations in relation to the presence and activities of the United Nations, including its agencies and bodies, other international organizations and third states, in and in relation to the occupied Palestinian territory, including to ensure and facilitate the unhindered provision of urgently needed supplies essential to the survival of the Palestinian civilian population, as well as of basic services and humanitarian and development assistance for the benefit of the Palestinian civilian population and in support of the Palestinian people's right to self-determination. The question is thus about humanitarian action, but not expressly about unilateral sanctions or any conflict of norms, much less how to resolve them. However, the court's answer to the GA's question contains inspirations for us to explore these issues and the connections between and among them in 3 scenarios. The first scenario can be considered one of conflicts resolved, to some extent at least, in specific obligations. In addressing Israel's obligations as the occupying power, the court recalled that significant emphasis was placed on the security concerns of Israel as justification for its conduct, both in general terms and in relation to some of the specific obligations as an occupying power. The court replied that the court is conscious of Israel's security concerns. The court observes that while certain provisions of the 4th Geneva Convention and other rules of customary international law allow the occupying power to take considerations of security and military necessity into account, the protection of security interests is not a freestanding exception, permitting a state to depart from the otherwise applicable rules of international humanitarian law. Any limitations on Israel's obligations under international humanitarian law based on its security concerns must be grounded in a specific rule. Thus, the court does not consider Israel's security concerns limit the scope of Israel's obligations as an occupying power. The court underscores that reliance upon such concerns must be exercised in accordance with the principle of good faith. Further, the court emphasizes that when states take measures to combat terrorism, they must comply with their obligations under international law, in particular, their obligations to respect international humanitarian law and international human rights law. The court's view here can be applied by analogy to the unilateral sanctions situation. Conceivably, if a state attempts to use its own unilateral sanctions as a basis for limiting its obligations for humanitarian action, the same kind of considerations and the same kind of resolutions would seem to apply, most likely to favor humanitarian action. The second scenario is the more general conflict of norms situation, which can be considered addressed in the rules reflected in Article 30 of the Vienna Convention on the Law of Treaties and also perhaps Article 38 of the ICJ statute. Here I have in mind the Court's view on Israel's obligations as a member of the United Nations. After noting the United Nations' permanent responsibility towards the question of Palestine and the work of the United Nations and its entities have conducted in and in relation to Palestine, the Court concluded that Israel, as a member of the United Nations, is under an obligation to cooperate in good faith with the United Nations, in particular by virtue of Article 2, Paragraph 2 and 5 of the Charter. Pursuant to this obligation, Israel may not obstruct the functions of the United Nations and must provide every assistance in any action taken by the organization in accordance with the Charter in any relation to the occupied Palestinian territory. If unilateral sanctions are used as a basis for not providing assistance to or not cooperating with the United Nations, perhaps one can draw two tentative conclusions from the Court's opinion. Above all, the member imposing sanctions cannot do so without violating its obligations. Secondly, if the member refusing assistance or cooperation is not the sanction-imposing state, then potentially there is a conflict between sanctions and the obligation to assist and cooperate with the United Nations. Under Article 103 of the Charter, the obligation under the Charter shall prevail. If the humanitarian action is not undertaken by the UN and its entities, the conflict may become a more generalized one, which is to be resolved under the rules reflected in Article 30 of the Vienna Convention on the Law of Treaties and perhaps Article 38 of the ICJ statute, as mentioned earlier. It is difficult to say more in the abstract, but I would like to know that in some treaties there is a provision that gives priority to international humanitarian law and therefore humanitarian action. For example, Article 21 of the ICSFT, the International Convention for the Suppression of the Financing for Terrorism, provides that nothing in this convention shall affect other rights, obligations, and responsibilities of states and individuals under international law. In particular, the purposes of the Charter of the United Nations, international humanitarian law, and other relevant conventions. Here, humanitarian action is apparently covered. In light of the Superman character of an obligation under the United Nations Charter and of Article 103, if humanitarian action is undertaken under a UN mandate, it would receive a boost and become more effective in the face of potential obstacles that can come as a result of conflict of norms. Thus, as a matter of strategy, it would be a good idea to involve the UN in humanitarian actions. The third scenario in the conflict between sanctions and use co-organised, or perhaps an ego omnis norm, or just a fundamental norm. Addressing the issue of the presence and activities of the UN in support of the right of the Palestinian people to self-determination, the Court concluded that respect for the right to self-determination of the Palestinian people requires Israel not to prevent the fulfillment of the basic needs of the Palestinian people in the Gaza Strip, including by the United Nations, its entities, other international organizations, and third states, and that Israel is under an obligation not to impede the operations of the United Nations entities, other international organizations, and third states, and to cooperate in good faith with the United Nations to ensure respect for the right of the Palestinian people to self-determination. The Court did not expressly resort to the use co-organised status of the right to self-determination in its analysis here. Usually it prefers ego omnis here, but one can sense a certain use co-organised or ego omnis norm or a fundamental norm at work here, a sort of application of Article 53 of the Vienna Convention on the Law of Treaties, writ large. Applying by analogy what the court said here to the unilateral sanctions situation where the right to self-determination is in play, one may say that unilateral sanctions may not be used to prevent the fulfillment of the basic needs of a people in a humanitarian crisis, nor to impede the humanitarian operations to ensure respect for the right of self-determination of a people in such a crisis. Finally, humanitarian assistance, at least in some circumstances, has a good claim to the status of jus cogens, which one can see a glimpse of that in the ILC list of jus cogens norms in its conclusions on jus cogens. If so, the priority status of humanitarian action in a conflict with unilateral sanctions will be even more secure. Those are the inspirations I can draw from the ICJ's advisory opinion under discussion, and I will stop here and will be very delighted to answer any questions and to learn from all of you. Thank you very much. Thank you.
Thank you very much, Sianho, for a very inspiring presentation. Indeed, when we start to talk about the use of unilateral coercive measures from the perspective of international law, we get so many aspects to be addressed that, as I told yesterday very honestly, during 6 years of my work, I was only able to scrub the surface of international legal regulations. So I already have a few questions, so I'm looking forward to a very fruitful discussion. And without further delays, I'm happy to give the floor to Professor Daria Boklan with the presentation, Could Unilateral Sanctions Be Justified under the WTO Security Exceptions? And that is the case where, upon my knowledge, we already have some practice, which is a bit inconsistent upon my view. However, it shall be addressed. Please, the floor is yours.
Thank you very much, Elena. First of all, I would like to thank you for this invitation and giving me opportunity to deliver my presentation in this high-level conference. And also, Elena is saying that she, during these 6 years, she was scrubbing the surface. I would say that she was scrubbing the surface of the other side of the moon. And she showed us the existence of this other side of the moon. Most of us even didn't know about the existence of this side. Now it's not only scrubbing the surface, but it's like opening the side which we didn't even know that exists. So thank you very much, and that is a new field for us to research and to assess. May I kindly ask you to switch on the presentation. So as you might know, most of so-called unilateral sanctions are at the same time trade restrictive measures. Therefore, compatibility between these unilateral sanctions, these trade restrictive measures, and WTO law is on top of the agenda. And as we discussed yesterday, in most instances, such unilateral trade restrictive measures would be considered as inconsistent with the WTO law. Therefore, my presentation is focused on the question, in case such unilateral trade restrictive measures are inconsistent with the WTO law, is it possible to justify them under so-called security exception? The next slide, please. So I'm going to address briefly two first questions. First is, and please, yes, where does the term sanctions come from? The second is, could sanctions be unilateral? And third is the main point which I'm going to discuss. Is it possible to justify such trade restrictive unilateral measures under security exception? The next slide, please. So where does the term sanctions come from? It is worth noting that there is no word sanction or sanctions in the UN Charter. You never find it in the text of the Charter. Could you please move on? There are different, yes, please move. Yes, there are different notions in the relevant articles of the UN Charter, but there is no word sanctions. you can see these notions on the slide. The next, please. So this term has come from the practice of the UN Security Council and first appeared in resolutions of the Security Council, one of the examples you can see on the slide. And then, next slide please, it appeared in the names or titles of the relevant sanctions committees. And the next slide please, and then it appeared in so-called sanctions regimes. Therefore, again, we have to acknowledge that that is the invention of UN Security Council, the very notion of sanctions. Therefore, to be legitimate, they should be considered as such only under the auspices of the UN Security Council. As a result, the next slide, please, the answer to the question whether sanctions could be unilateral, the next one, please, should be negative. They cannot be unilateral, and this also can be supported by the Charter of Economic Rights and Development and Duties of the States, which says that no state may use measures to coerce another state in order to obtain from the subordination of the exercise of the sovereign rights. And also the next slide, please, it could be supported by the UN Human Rights Council, which says that such coercive measures are contrary to the United Nations Charter. And the next slide, please. So, coming to the most important point of my presentation, the security exception within the WTO. It is a very specific one, and as you can see from the text of this provision, this exception permits any WTO member to take any action which it considers necessary to protect its essential security interests in time of war or other emergency in international relations. So from this text you can see that this provision is not about trade, it's about politics. And that is the only provision in the WTO law which is not about trade, but the provision which is closely connected with the policy and politics. And this provision was never applied till 2019. Can you please move on? On the other hand, we have this provision in all three main WTO agreements. The GATT, which is on trade in goods, the GATS, which is on trade in services, and the TRIPS, which is on trade-related intellectual property rights. And WTO members, as well as the parties to the GATT, were very cautious with respect to this provision. The next slide, please. This is due to the fact that they were, yes, move on, please. Yes. That they were afraid to address and to interpret this security exception. The next slide, please. Due to the fact that they agreed to undertook individually and jointly to abstain from taking restrictive trade measures for reasons of non-economic character not consistent with the GATT. And the next slide, please. However, this Pandora box, as Elena said, was opened, and we now have a set of disputes. You can see them on the slide. Yes, move on, please. Where this exception was invoked and interpreted. Russia traffic and transit case, Saudi Arabia IP rights case, and several cases on US steel and aluminum products. The next slide, please. So what is the problem, and move on please, with this provision? You can see that the wording is very specific. It says that the WTO, please be back, yes. The WTO member can take any action which it considers necessary. What does it mean? It looks like total discretion of the WTO member, right, which it considers. Meaning that it is possible to interpret this provision only in a way the WTO member which invokes this provision likes to. That there is no jurisdiction of the panel to interpret this provision. And on the one hand, it's clear because you can understand that there is no WTO member which would agree to empower any international body, including WTO dispute settlement body, to interpret essential security interests. It's a very sensitive issue. Can you imagine that, for instance, the US, China, or any other WTO member would agree that someone would interpret its essential security interests. On the other hand, does it mean that there is a provision in all three agreements of the WTO which cannot be interpreted by its dispute settlement body and its total discretion of a member to interpret this provision and to justify anything under the sun? So the question which was the panel was facing in the very first dispute, is it possible even to establish its jurisdiction to resolve this dispute? Are there any grounds for establishing this jurisdiction? And the panel was addressing the issue, is it possible to separate these words which it considers necessary from the paragraphs of this article, namely emergency in international relations? Is it possible to interpret objectively the term emergency in international relations? The next slide, please. There are two approaches in this respect to interpret this provision. First is so-called self-judging or non-justiciable or subjective, meaning that there is no jurisdiction of the panel or any other dispute settlement body to interpret the provision. It's total discretion of the invoking state in our case. And second, classical objective approach when provision is considered non-self-judging, justiciable, and it is possible to interpret this provision. Next slide, please. So the panel, yes, and move on, please, decided in this case that at least subparagraph 3, where we see these words emergency in international relations, no, it's too fast, please be back. Yes, could be separated from words which it considers. The context of interpretation is given in all three paragraphs, and the panel concluded that fissionable materials, traffic in arms, and even war are objective notions, together with emergency in international relations, that it is possible to interpret objectively emergency in international relations. It is possible to separate this notion from the words which it considers. And that is how the panel established its jurisdiction and started resolving the dispute, interpreting term emergency in international relations. The next slide, please. And the panel interpreted this notion, emergency in international relations, in a very narrow way. First, the panel concluded about the character of the emergency and said that it could be only of a military character. The panel excluded all other types of emergency, political, economic, environmental, or any other types, saying that under this security exception, only military type of emergency is meant. The next slide, please. And then the panel concluded that only bilateral international relations should be assessed in this case, saying that invoking this exception state must be affected by the emergency, it should be involved in this emergency, and there should be a common border between two disputing states, and which shows existence of such emergency. So you see that the panel applied very narrow approach interpreting term emergency in international relations, saying that this emergency only of a military character and that in international relations should be taken into account as bilateral between two disputing parties. Let's move further. The next slide, please. So this means that the panel applied objective approach and interpreted emergency in international relations objectively. Yes, move on, please. Objectively, using narrow approach. Then the panel moved to the first part of the article, interpreting, and the next slide, please, essential security interests. In this case, the panel agreed with the United States that it is necessary to use so-called subjective approach, that it's total discretion of the WTO member to define its essential security interests. The panel said that it is left to every member to define what it considers to be its essential security interests, and limited this discretion by principle of good faith and by obligation to show connection between the measure and protection of essential security interests. The next slide, please. Therefore, it's a unique situation. Yes, and the next slide, please. When the panel, the next please, used combined approach, it actually part of the provision, part of the norm was interpreted objectively, namely emergency and international relations, and the other part of the provision was interpreted subjectively, essential security interests. This is how panel tried to find this very delicate and difficult balance between free trade and essential security interests. So this seems like more or less wise approach of the panel. The next slide, please. However, in the recent dispute, US origin marking requirement, the panel decided for some reasons not to use this delicate and well-balanced approach, and for some reasons, instead of relying on previous cases, it relied on Oxford Online Dictionary when interpreting international relations. Of course, Oxford Dictionary defines international relations in a very broad sense, including political, economic, social, and even cultural exchanges. In addition, the panel said that such relations should be not exclusively bilateral relations between the invoking member and the member affected by the action. What does it mean? It means very broad interpretation. It means that now, using such interpretation, WTO member could justify by this provision anything under the sun, using any types of international relations. This actually crushes the WTO system as such, because it's possible to violate WTO rules and then justify it by such a broad interpretation. Moreover, and the next slide, please, the panel used, in my opinion, very strange logic. Look, what does panel say? Just as with respect to other inherently subjective human experiences, for example, how we experience whether it is warm or cold, there are parameters to establish when a situation constitutes an emergency in international relations, in the same way that thermometer does for measuring temperature. Dear colleagues, do you agree that thermometer measures subjective human experiences of warm and cold? What does thermometer measure? Temperature, right? Concrete figure. For instance, and the next slide, please. If it is 0 degrees, for me, being from Russia, it's a warm weather to walk around. Right? And for some of you from southern part of the world, it's a terrible, absolutely weather, which is not possible even to go outside. So thermometer doesn't measure our subjective human experiences, right, of warm and cold. It measures objective temperature. But the panel decided to measure by the thermometer subjective experiences with respect to emergency in international relations. So in my opinion, it confused everything, trying to show that the assessment was objective, but in fact, the interpretation was very broad, and actually it covers, by saying that, yes, I am using objective approach, it covered very subjective approach. So this is very dangerous and bears a risk of manipulation and abusing and misusing of this security exception. The next slide, please. So to conclude, I would like to say that first, unilateral sanctions lack binding multilateral authority that attaches to sanctions authorized by the UN Security Council under the UN Charter. Second, unilateral sanctions operate as instruments of foreign policy to exert coercive pressure on target states with the objective of influencing their behavior. Third, it is necessary to apply exclusively narrow approach to interpreting term emergency in international relations adopted by the panel in Russia traffic in transit case in the context of national security exception provision within the WTO. And finally, any other approach would lead to a situation where WTO law is observed on a selective basis, where WTO members could invoke any situation invoking tensions in any international relations as a justification for protectionist, trade restrictive unilateral sanctions. Thank you very much for your attention, and I'm ready to answer the questions.
Thank you very much, Daria. Indeed, the practice of the WTO, Dispute Settlement Body, in this case raises so many elements. Some are similar to the exceptions as regards environment or healthcare. Some are very specific, and I'm looking forward to a very fruitful discussion. And now we are moving to our other panelist, Professor Aslan Abashidze, who is the member of the Committee on Economic, Social, and Cultural Rights, and he will reflect on the position of the Committee on Unilateral Measures. So, Professor, the floor is yours.
Thank you very much. Good morning, dear colleagues. At the beginning of my statement, I would like to set out the key points which already were touched by Professor Daria Baklan. Any unilateral coercive measures are contrary to the fundamental principles and spirit of the United Charter. Any unilateral restrictive measures are run counter to the core international human rights treaties, including the International Covenant on Economic, Social, and Cultural Rights, the international monitoring of which is carried out by the Committee on Economic, Social, and Cultural Rights, of which I have been member since 2010, and which 2 days ago re-elected me for another term until 2031. In 1990, my committee adopted two general comments. General comment number 2, international technical assistance measures, it's Article 22 of the Covenant, and general comment number 3, 1990, the nature of state parties' obligations, it's Article 2, paragraph 1 of the Covenant. In the general comment number 2, among this issue, in respect of which the committee expressed the concern, were such matters as the adverse impact of the debt burden and of the relevant adjustment measures. Unfortunately, in this general comment, the committee did not deem it necessary to identify among such matters of concern the negative consequences of unilateral restrictive measures for the population of the affected state, especially for its vulnerable groups. In general comment number 3, now unfortunately there was not even any mention of the negative consequences of unilateral restrictive measures for the vulnerable groups of the population of the affected states. What this means in practice, let me give an example. The head of the government delegation of the Belarus, in the opening statement at the 74th session of the Committee on Economic, Social, Cultural Rights during the consideration of the 7th periodic report of the Belarusian in March 2020, draw the committee's members' attentions to new challenges, such as, quote, the illegal unilateral coercive measures of economic sanctions, blackmail actively employed by Western countries. I quote the appeal. It is impossible not to touch upon the subject of the sanctions that were unlawfully imposed by Western countries against Belarus. We very much hope that the committee will not remain silent about the problem of counterproductive sanctions and will call upon the collective West to abandon them in favor of dialogue. And what was the committee's reaction to this appeal? Let me quote the relevant response in concluding observations of the report of Belarus. The committee notes the statement by the delegation that it intends to continue to provide decent standards of living and social security for its entire population, despite the challenges it faces, including the unilateral coercive measures imposed. In 1997, the committee adopted General Comment number 8, entitled The Relationship Between Economic Sanctions and Respect for Economic, Social, and Cultural Rights. In it, the committee identified two sets of obligations. With regard to the first set of obligation, it states, while sanctions will inevitably diminish the capacity of the affected state to fund or support some of the necessary measures, the state remains under an obligation to ensure the absence of discrimination in relation to the enjoyment of these rights and to take all possible measures, including negotiations with other states and the international community, to reduce to a minimum the negative impact upon the rights of vulnerable groups within the society. The second set of obligations relates to the party or parties possible for the imposition, maintenance, or implementation of the sanctions. They are the international community, an international or regional organization, and a state or a group of states. When listed these parties responsible for the imposition of the sanction, the committee makes no distinction between them or their power. In paragraph 1 of this general comment, it says that economic sanctions are being imposed with the increasing frequency for internationally, regionally, and unilaterally. The purpose of this general comment, it means number 8, is to emphasize that whatever the circumstances, such sanctions should already take full account of the provisions of the International Covenant on Economic, Social, and Cultural Rights. As we can see, the committee does not distinguish between the lawfulness of these types of sanctions. Moreover, paragraph 1 says following: the committee does not in any way call into question the necessity for the imposition of sanctions in appropriate cases in accordance with Charter 7 of the Charter of the United Nations or other applicable international law, but those provisions of the Charter that relates to human rights, Article 1, 55 and 56, must still be considered to be fully applicable in such cases. The committee stated in paragraph 7 of the general comment number 8 to answer to the main issue as an amendment. I am quote, although the committee has no role to play in relation to decision to impose or not to impose sanctions, it does, however, have a responsibility to monitor compliance by all state parties with the covenant. When measures are taken which inhibit the ability of the state party to meet its obligation under the covenant, the terms of sanctions and the manner in which they are implemented become appropriate matters for concern for the committee. The committee said these words almost 30 years ago. Today, this issue is one of the most difficult to contemporary international law. If the committee continues to avoid qualifying unilateral coercive restrictive measures as unlawful acts from the point of view of the UN Charter and as destructive foundations for the world order, all such appeal of the committee will amount to no more than good intentions. Unfortunately, nothing is changing so far in the committee's activities on the issue. I have been observing this question for 16 years, and all my attempt to change something have no produced tangible success. But I would like to give one example. If you remember, I sought to provide an adequate response to the statement made by the head of the delegation of Belarus and to reflect the relevant provisions in the concluding observations. However, my colleagues did not support in my position. This was partially achieved during the consideration of the periodic report of Lithuania. In the concluding observation of the third report of the Lithuania, adopted on March 13, 2023, under the section on extraterritorial obligations, it is said, I quote, paragraph 20, the committee remains concerned by recent measures taken by the state party that prevented the transportation of potash from Belarus distinct for third countries in Africa and Latin America, leading to the shortage of fertilizer and adversely affect food security in the countries. And 21 paragraph says that the committee recommends the state party of Lithuania review the recent measures that have had an adverse effect on the price of fertilizer and on food security in said countries. And in conclusion, I would like to say that even during the COVID-19 pandemic, when many weakness in the human rights sphere was laid bare, the committee was unable to demonstrate character and adequate qualify unilateral coercive restrictive measures as contrary to the key provisions of the International Covenant on Economic, Social and Cultural Rights and destructive of national systems of security, of social security, healthcare and education. In statement on the coronavirus disease, COVID-19 pandemic and economic, social and cultural rights adopted by the committee on 6 April 2020, it merely states the following in this regard in paragraph 20. Let me quote: state parties have extraterritorial obligations related to global efforts to combat COVID-19. In particular, developed countries should avoid taking decisions such as imposing limits on the export of medical equipment that result in obstructing access to vital equipment for the world's poorest victims of the pandemic. Moreover, state parties should make sure that unilateral border measures don't hinder the flow of necessary and essential goods, particularly staples and health equipment. Any restrictions based on the good of securing a national supply must be proportionate and take into consideration the urgent needs of other countries. And in article paragraph 22, it says that unilateral sanctions of any economic and financial nature weaken healthcare systems and could undermine efforts to combat COVID-19, especially in the context of the procurement of medical equipment and supplies. Such sanctions should be lifted to enable affected countries to have access to the resources they need to effective COVID-19 pandemic. If the committee wishes to demonstrate its usefulness, it must radically change its position regarding any coercive restrictive measures unilateral as contradicting the spirit and letter of the International Covenant on Economic, Social, Cultural Rights. Thank you very much for attention.
Thank you very much, Professor Abashidze. Indeed, during 6 years as a mandate holder, I repeatedly tried to have a good discussion with the committee. We had a very good relations with Professor Abashidze, and we tried to discuss with one of previous chairs of the committee, but unfortunately, the committee was not much willing to talk to me as a mandate holder about the impact of UCMs, but I hope that in the future the situation might hopefully start to change. With all that in mind, I'm happy to give the floor to Professor Ali Razdbin, who will speak about the unilateral sanctions as a political tool, replacing judicial processes. So, Professor, the floor is yours.
Bonjour. Merci beaucoup. Je remercie Madame Douane et ses collaborateurs qui m'ont permis d'insister auprès de vous, intervenir sur le unilateral sanction, over-compliance and the fragmentation of the international legal order. Since the beginning of the 21st century, unilateral sanctions have become a central instrument of international regulation, reflecting a gradual shift from multilateral governance toward a logic of power projection, initially embedded within the normative framework of the United Nations Charter. they increasingly operate as autonomous mechanisms with expanding extraterritorial reach, thereby challenging the principles of sovereignty and non-interference. Their effectiveness relies on the control of key global financial infrastructures, particularly payment systems, the dominance of the US dollar, and transnational banking networks transforming economic interdependence into a tool of coercion. This dynamic is further reinforced by the phenomenon of compliance, which has become a structural feature of the system. Private actors seeking to mitigate legal and reputation risk frequently apply restrictions that exceed formal legal requirements. As a result, sanctions regimes expand informally beyond their legal basis, giving rise to a form of privatized regulation in which decisions with significant political consequences are taken without democratic legitimacy of effective judicial oversight. The interaction between unilateral sanctions and our compliance thus accelerates the fragmentation of the international legal order. At the normative level, it generates a proliferation of competing and sometimes conflicting legal regimes, undermining coherence and creating structural uncertainty for economic actors. Institutionally, it contributes to the marginalization of multilateral mechanisms, particularly those of the United Nations, in favor of unilateral initiatives driven by strategic interests. Judicial response, especially within European jurisdictions, have introduced certain safeguards, notably concerning the protection of fundamental rights. However, their impact remains limited when confronted with the transnational, diffuse, and indirect nature of sanctions, as well as their increasing implementation by private actors. This mismatch between the global scope of sanction and the territorial jurisdiction of courts sustains of persistent regulatory gap. Moreover, sanctions contribute to a broader geoeconomic reconfiguration of the international system, the emergence of alternative financial circuits, no-dollar payment mechanisms, and circumvention strategic reflect less a coordinated adaptation than a reaction of the growing politicization of interdependence. This trend reinforces system polarization and the consolidation of competing economic and legal blocks. The implications for access to justice are particularly concerning. Financial restriction and our compliance practices singularly hinder the ability of individuals and entities to assert their right, leading to indirect forms of denial of justice. This development undermines the foundational principle of the rule of law at the international level. Unilateral sanctions, amplified by our compliance, are no longer merely instruments of foreign policy, but structural drivers reshaping the international legal order. While they may produce short-term strategic effects, they simultaneously order a coherence, predictability, and legitimacy of international law. The resulting system increasingly fragmented, asymmetric, and influenced by power rather than normative. However, this transformation, it's not irreversible. Emerging counter dynamics, such as the development of alternative financial architectures, growing judicial security, and needed calls of strengthening multilateral governance indicated an ongoing process of systematic adjustment. The future of international law will depend on the capacity of global actors to reconcile power with legitimacy, of re-anchor regulatory practices when accountable institutional framework, and ensure effective oversight of increasing privatized mechanisms. Absent such rebalancing, the current trajectory risks leading of the institutionalization of the international law, in which legal norms are proximity subordinate to strategic interests, and the universalist ambition of the international legal order of fundamentally compromised. Thank you very much.
Thank you very much, Professor Rozdebin. Dear colleagues, we were supposed to have another panelist, Professor Maria Keshner from Kazan State University, but we just received a notification that there is a rocket burning for the third time in the city starting from the last evening. So therefore, no normal access to internet, and she unfortunately is not able to join in the emergency alert situation. So therefore, our list of panelists is over at the moment, and I'm opening the floor for questions and comments. And the first person who asked to make a comment and ask questions is Professor Alfred de Zayed. So please, the floor is yours.
Reading the advisory opinion, which and the separate opinion of the Chinese judge Hu, which was super interesting. Now, my question is to Professor Xiando Zhe, who spoke on the conflicting norms, etc. What I find it interesting is that he has addressed that one issue which I have been hammering for at least 10 years since my time as an independent expert, that the General Assembly should finally adopt a resolution under Article 96 of the UN Charter asking for an advisory opinion on the legal questions of the continued imposition and disregard by the UMC imposing countries. What are the legal consequences for those states? Finally, we should have, on the basis of all of your reports and the reports of Idris Yazairi and the thematic report of Navi Pillay back in 2013, the thematic report of Marc Passoit in 2000 at the Subcommission on Promotion and Protection of Human Rights, etc., establishing all the violations of all the treaties that unilateral coercive measures entail, putting down also the consequences for those states and the consequences for those states who are complicit. Because part of the problem is that some states impose sanctions and others allow the sanctions to be implemented in their countries instead of using, and I will be speaking of that in the next panel, using diplomatic protection on behalf of their citizens who have been targeted, on behalf of their corporations that cannot properly function as corporations, their banks, etc. To give a clear example, if the UBS refuses to transfer money to Cuba on a humanitarian matter, actually the UBS is being complicit in the deaths that ensue from not transferring that money. And the Swiss government should make the UBS liable under Swiss law for failing to help people in distress. So rescue legislation that exists in Switzerland could well be used in that case, but then the Swiss government should protect the UBS from any kind of penalties imposed by the United States, and then the whole package should be brought to the International Court of Justice. And now my request direct to Professor Yi, why not China? China could organize the BRICS countries, the Shanghai Cooperation Organization, and others, the non-aligned movement, to get a clear majority in the UN General Assembly so as to request the International Court of Justice finally for clarification of all the legal issues, which of course have been best clarified by you yourself, Elena Dohan. Thank you.
Thank you very much, Alfred. I just think that would just like to remind that Professor Yi is not a state official. Professor Yi is a professor at the university, so he's not responsible for actions taken by China. So we shall keep it in mind. And with all that, I'm giving the floor for remarks or questions to Ali Pustizadeh, International Justice and Human Rights Clinic at the University of British Columbia. Please, the floor is yours.
To intervene in the fourth session. So there must have been a mistake there. My apologies.
Much. It's truly fascinating for somebody who works in tax, debt, and illicit financial flows to sort of, walk into the UCM area and try to understand things. And one of the things that keeps resonating with me, and I think if there's any question, it would be for Ali, but it's more of a reflection as well. It's the formality of financial systems vis-a-vis the informality of financial systems. And if I explain it, the accounting board in the UK is the one that decides on how accountants set out their balance sheet statements and their profit and loss statements. If you move across to what I consider a potential UCM, which is the use of FATF, the Financial Action Task Force, that creates this sort of grey listing, blacklisting, and white listing of countries based on how opaque or transparent allegedly their financial systems are, then you start to see, again, this is a body that isn't a government-authorized body, it isn't an international law system, it is a recommending entity, but member states are picking it up. And if I take a credit rating agency, again, a private company in one country, picked up again, being implemented through the IMF. So I see this sort of formal and informal sort of split across the world. But I also see fear in it. And this risk appetite that we talk about and the risk assessment seem to be playing off back to back with fear. And so I guess the question I keep having in my mind is this increased informality, and I guess this is for Ali really, is this increased informality part of this replacement of judicial process that you're thinking about? Which means that if I come into the area of UCMs from this financial perspective, then it isn't even an increased in informality, but literally a gatekeeping and maintenance of continued informality and opaqueness, so that there's almost like a backdoor into UCMs to avoid law and regulation. Thank you very much.
Atiya, I see that there is a request to take the floor via Zoom by Pavel Tikhonov. Please, the floor is yours.
Thanks a lot for giving me the floor. My name is Pavel Tikhonov. Currently, I am a teaching assistant at the University of Bologna. And before, in my past, I was also a student of High School of Economics and attended lectures of Professor Boklan. And my question is actually to her. First of all, thank you to Professor Dolben for organizing this conference, and thank you to Professor Boklan for her wonderful presentation. I would like to ask about, let's say, the power of WTO in clear sanction process, because it is also always, I think it was always quite a controversial question. And in 1996, for example, when it was a claim against the United States because of sanctions against Cuba, Bill Clinton administration simply said that they refused to show up on the process because it's a political and not commercial question. And I would like to ask your opinion, maybe personal opinion, why Russia currently doesn't submit a claim against sanction-given states like European Union, or maybe Canada, or maybe United Kingdom, to the WTO. Does Russia admit inefficiency of the WTO, or does Russia consider the case 512 and already know the result? And with that, when the WTO is so reluctant in giving the certain position on sanctions, as you noticed in your presentation, what role can be given to the WTO, and which possible reforms should be made, if any reforms should be made? Thank you.
Thank you very much. Does anyone else want to ask a question? I do not see any indications. I have a few questions. The question which I have to Professor Sienhui, you have mentioned the possibility to apply international humanitarian law in the current situation. What we are facing, I have some concerns, and probably I do not understand some of nuances, because what I see, especially when it comes to the delivery of humanitarian assistance, is that states imposing sanctions insists that humanitarian assistance and the whole understanding of that from the UN perspective can only be delivered in the military conflict, not in the situation of sanctions. And therefore, do you see any risks to talk about international humanitarian law in the face of UCMs, which might end up in the situation that people in need of humanitarian assistance will be deprived of that due to the references to international humanitarian law? I also have a question to Professor Boklan. Take into account that the emergency is used as the qualifying criteria. What is your opinion? Shall we probably additionally somehow recommend the WTO dispute settlement body to take into account the content of the state of emergency from the perspective of international human rights law? Because it's very specific, and basically from my experience of country visits, I could say that in some countries like during the moment of my visit to Venezuela, when people were deprived of nearly everything, situation of Cuba, yes, they have been facing the Hurricane Melissa 2 weeks before my visit, and it was also already the state of emergency, but nevertheless all the pressure they work on can end up in the survival mode for the state and for people. So therefore, shall we probably also recommend WTO to take into account? I know that WTO dispute settlement body cannot apply other treaties, but it can take it into account. So this understanding of the state of emergency. And my second question refers to the possibility of enforcement. Upon my knowledge, the appeal body has not been formed. It has been blocked by the United States since 2021. So what shall be the possible solution in the face of the situation that states cannot appeal? And those who lose cases basically quite often say there is no appeal body, therefore we shall not implement the decision finally. I also have a question to Professor Abashidze. It's probably a sort of addenda to the question which have been asked by Professor Desayets concerning the businesses and states being accomplices in committing human rights violations. There is a number of general comments developed by the Committee on Economic, Social and Cultural Rights which explicitly say that if a state hasn't exercised due diligence to make sure that right to health, right to life, and a number, right to housing, if I'm not mistaken, is properly implemented by private actors, a state is equally responsible for consequent human rights violations. Could you please comment somehow, what are your ideas? How the committee could develop this approach, which I fully support, to address the issue of unilateral coercive measures and to help us to find a way to get access to effective remedy and to hold the perpetrators responsible. Does anyone else? Professor Strauss, please ask the question.
Sanctioning to the trouble of making any correlation between invoking Article 21. Do they also invoke Article 4 of the ICCPR? And do they also declare national emergencies that don't necessarily meet the criteria of Article 4, like for example, in the IEPA of the United States? As a justification for its sanctions, they declare national emergencies, but they're not as a reason for sanctions, but they don't necessarily fall into the category of emergencies that Article 4 is looking at.
Thank you very much, Professor Strauss. As I do not see any additional requests, I'm giving the floor to our panelists in the same order they are listed in our session today. And as I'm expected to be a timekeeper, we have 12 minutes until the end of the session. Would appreciate if you keep your comments within 4 minutes. So I'm giving the floor to Professor Xianhe to answer the questions and for some final remarks.
Thank you very much, Madam. On the first question about whether it would be a good idea to ask the ICJ for an advisory opinion from the perspective of an academic, researcher, because there are so many uncertainties relating to UCM and all that. It would be a good idea in my view, right? But the political leaders may have a better idea on this than what I can offer. And as an academic, I would not want to go over my role to say more. Just as the Special Rapporteur already reminded us earlier. On the second question, the question that the Special Rapporteur asked, indeed, I am not sure how to answer your question yet. I thought that the advisory opinion is very interesting and it offers many inspirations for us to consider these issues. To the extent that in the advisory opinion, the court focused, quite a bit of attention on the idea of restricting the provision of humanitarian assistance in an armed conflict situation. We can perhaps, by analogy, to say that the same kind of ideas on restrictions may also apply to other types of situations like humanitarian assistance in an emergency situation. This will also depend on where the obligation comes from and all that. It will be quite complicated to work out all these questions. And that has to be done in detail, not in the abstract as what I have tried to highlight, to outline only. Maybe we can consider what I just presented as some kind of agenda for research. And that's all I have to say. Thank you very much.
Thank you very much, Professor Yi. And now I'm giving the floor to Professor Bocklan.
Thank you very much. Thank you so much. So, you know, I'm benefiting from teaching the students now. They're asking me questions during international conference, which is kind of interesting. First the time in my life when my student asked me a question abroad during international conference. So thank you very much for your question. I'm glad that you are participating in the conference. Yes, answering why WTO doesn't express any position with respect to sanctions would be the following. WTO tries to avoid any political involvement, and the main approach which is used in the WTO is so-called case-by-case approach. So there is no power for advisory opinions, for instance, of the WTO dispute settlement body. Therefore, it expresses its opinion specifically with respect to concrete case. That's it. Why does Russia not submitting its position within the WTO and doesn't go to the dispute settlement body to challenge trade restrictive measures and sanctions? One of the answers could be specifically due to this security exception provision, because it would have risk to open this Pandora box again, and interpretation of this security exception indeed bears the risk to justify any unilateral trade restrictive measures within the WTO. So Russia tries to keep WTO safe, although it's in crisis, also due to the blockage of the appellate body. And if we add here broad interpretation of security exception, there will be no WTO as such. However, Russia submitted its claim against EU in 2025 in spring, like a year ago, on CBAM, you know, this carbon border adjustment mechanism, which is a very complicated issue. I don't know whether Russia wins the case because it's very complicated, but still Russia tries to, let's say, be active in defending its trade interests using the WTO dispute settlement mechanism. Also, it is in crisis, and as Elena absolutely correctly pointed out, that without a functioning WTO appellate body, there is a real possibility to abuse from the side of the respondents this situation, filing the appeal into the void. Even if a complainant wins the case, now respondent may submit the appeal to the void and nothing happens. That is the problem of this crisis. With respect to two questions, is it possible to use human rights law within the WTO system? You're absolutely correct that directly no, because it's not possible to apply non-WTO law, but indirectly using it as an interpretative tool, it is possible, and we have rather interesting examples in terms of using environmental international law. And recently, WTO dispute settlement body used, I would say, not evolutionary, but a revolutionary approach to interpret exhaustible natural resources. And last year, forests, peatlands, and wetlands were recognized as exhaustible natural resources, not being under threat of extinction. So it's due to the context of climate change. I wouldn't go into details, but can you imagine, like 20 years ago or even 70 years ago when the GATT was drafted, that forests will be recognized as exhaustible natural resources? In no way. Therefore, it is possible to use human rights law theoretically to interpret emergency, but here we have to take into account that too broad interpretation, again, could lead to a situation of abusing this security exception, saying, yes, I am taking care about people in Venezuela, but I'm far away from Venezuela. Also, I'm not involved in this situation, but I will restrict trade with Venezuela because on their territory happens something wrong. There is a situation with human rights. So we have, it's very delicate balance that WTO should take into account between, for instance, human rights and free trade. Because sometimes, unfortunately, WTO members, they use coverage of human rights or environmental protection for indeed protectionist purposes, saying that I'm in favor of human rights, I'm in favor of environmental protection, and that is the reason why I'm blocking trade with the state for protectionist purposes, truthfully speaking. So thank you very much for your questions.
Thank you very much. Indeed, it's an interesting issue concerning the interpretation of the state of emergency. The US is using it in the broadest way, and it's always criticized by the Human Rights Committee and during UPR because it's much broader than what is set forth in Article 4 of the Covenant on Civil and Political Rights. And now I'm giving the floor to Professor Abashidze. Please, the floor is yours.
Thank you. You know that this year we are going to celebrate 60 years of two covenants. And unfortunately, our committee started to work at the end of the 19th. And as I mentioned, all key general comments, including number 3 about the nature of obligation, was adopted in 1990. And you know that after that happened a lot. We have a lot of questions which must be reflected in the general comments. But unfortunately, my committee from one side has no any support, I mean financial support. Now we have in our pipeline only one general comment dealing with armed conflict and international it's economic, social, cultural rights. And many times I was tried to update existing general comments, including general comments number 3, and to reflect new nuance which deals with the unilateral coercive measures, what you ask me about the private sectors and their influence and so on. We are trying something to do within the concluding observations, for example, extraterritorial obligations of states dealing with their private companies which are acting outside of the states and so on. But all this practice needs some kind of summarization and to reflect, in the general comments. Unfortunately, I would like to say that in the future, I have not seen any possibility, to follow which by what we are facing as the new challenges dealing with the economic, social, and cultural rights. But we are trying within our, mandate to do something. That the main question for the committee is availability of the resources. And these resources depend from one side on the national possibility, and national possibility based on the right to freely dispose of their national wealth and resources. And another, it's an international assistance and cooperation. But any unilateral coercive measures, it's against international cooperation. That's why in my speech, I was trying to mention key issues why unilateral coercive measures are contradictory, not only with the United Nations provisions, but also international covenant on economic, social, cultural rights, which is a part of the core systems of the human rights.
Thank you very much, Professor. And Professor Razbin, please have the floor.
Yes, the unilateral sanction, especially when reinforced by our compliance, significantly weaken the functioning and legitimacy of international law, but they do not irreversibly destroy it. These measures shift the legal order from a system based on cooperation and consent toward one driven by coercion and power asymmetric, thereby undermining its universal credibility. Our compliance further exacerbate the trend by delegation enforcement to private actor operation outside traditional legal accountability, leading to increased uncertainty and fragmentation of legal norms. However, this transformation remains reversible. Emerging countermeasures such as alternative financial system legal changes and need call for multilateralism demonstrated ongoing resistance to the origin. In sum, international law is undergoing a phase of critical recomposition, and its future as a universal normative order will depend on restoring a balance between power and legitimacy, strengthening multilateral framework and regulating increasing private enforcement mechanisms.
Thank you very much, Professor Razbin. Indeed, it's very good that we are able to look at the problem from different perspectives, including the political one. As soon as our time has expired for this session, I would like to thank all panelists, both in the room and online, for the amazing contributions and responding to the questions. I believe that what we have heard today shall probably give rise to all of us, including panelists, it might be still amending the articles they have submitted or are submitting. And I'm reminding that we are planning to publish a book. And if someone has already submitted an article and think that something else can be added as a result of our discussion or questions being asked today, all that is very much welcomed until the end of April and probably even the first week of May. So thank you very much. We shall have a coffee break outside of the room, and let's restart at 10:50. Thank you very much. So everything goes well. Dear colleagues, let's move to our next session. I understand that the discussion is very intense, but that was the objective of the conference. And we could have a few extra days for in-depth discussion, but we shall limit ourselves to what we have at the moment. We are moving now to the session which will start to discuss the issue of the effective remedy in unilateral sanctions environment. And that is one of the ways which can help individuals to protect their human rights, which might help businesses to protect their interests in the environment when unilateral sanctions is used as a sort of the universal excuse not to perform contractual obligations, and which can help states to protect their interests and rights in accordance with international law. So besides moderating this session, I'm also the first speaker, and I will try to address some of the elements which have already been touched upon since a few days, and in particular, how can we use the UN system as a means of effective remedy to promote and protect human rights in the face of unilateral coercive measures. We all agree that due to the political discrepancy existing currently in the world and due to the attempts to present unilateral coercive measures as something which is imposed by good guys against bad guys, which is, as it was told yesterday by sanctioning states, very targeted, nice, and not affecting people, reality is totally different. And I strongly believe that it's still the place for the United Nations and for the United Nations instruments which can be used as a means of effective remedy. I will not address the impacts of unilateral coercive measures. You all have heard about that yesterday during the whole day, in selective, especially when applied with the means to enforce unilateral sanctions. We see the extraterritorial application, we see the issues of secondary sanctions, criminal cases, civil charges, and many other elements. And naturally, as everyone becomes scared, including businesses become scared, we see lots of cases of overcompliance. And we cannot differentiate between direct impact of sanctions enforcement, and overcompliance. We can only assess this overall impact. And before I start, we also need to take into account that it's not only those who are directly designated who need protection. On the opposite, it's general population which needs protection. We appear to live in this situation when many people have not been mentioned in sanctions list, but they are suffering the most. The examples we have heard yesterday is about these people are dying because of absence of medicine. These people are dying of hunger. These people are losing their chances for developing, having good education, good job, chances to have to live a diligent life and to have a good future. When I was doing my country visit to Syria, one of the phrases I have heard was that war was killing people. Sanctions are killing hope. We are talking about generation gaps and many other elements, what the UN can do. Well, I have to admit that at the moment, the perspective of the UN involvement are not so high. And 6 years ago, I was really frustrated when I have just been appointed as a special rapporteur and realized that it's only one person, one mandate, which has any authority to do something about these unilateral coercive measures. Moreover, as we all understand, the special rapporteur is not a staff, it's just an independent expert who alone cannot change the world and can only demonstrate the consequences and propose solutions from the perspective of law, of policy, or anything else. So naturally, we need to have more mechanisms. These mechanisms, these mandates shall continue to exist because I hope that I managed to change at least the understanding, to start showing facts, and even to do instruments which are considered to be like mission impossible, like development of the monitoring tool or drafting the documents. And I hope that my successor will continue working in the same direction. But as a person who has been nearly done with the term of mandate holder, I can admit that it's very hard to be the only instrument, one human being, in charge of changing everything and drawing attention to the problem. I can say that I did my best to raise awareness and to involve all UN organs and all UN specialized agencies, which at the very beginning were saying it's not in our agenda, and that's a problem. Step number one, to protect human rights and to grant people chance for effective remedy, is to include the issue of UCMs to the agenda of the UN specialized agencies and many organs, because their mandates include issues which have been affected by unilateral coercive measures. The issue of health, we were talking about WHO yesterday. The issue of food and food security, we were talking about FAO, WFP. The issue of cultural rights, we were talking about UNICEF and UNESCO. The issue of, for example, fertilizers, and we are talking about International Fertilizer Association. The issue of safety of civil aviation, and we are talking about the International Civil Aviation Organization. International Maritime Organization, when I did a country visit to Cuba, the ships and vessels are not allowed to enter Cuban ports because if they do, they will not be able to enter US ports for 6 months, which is the death to the majority of vessels and private companies. Although there is a convention concluded within International Maritime Organization which allows to do it because there are bilateral obligations between the United States and Cuba on that regard, and many, many other of specialized agencies. So therefore, I believe that the specialized agencies can provide an effective remedy. I'm very happy to see that after 6 years of my work and they start to open. They haven't opened yet, but I see the positive movement. Very slow, very small, but it starts. And the number of agencies which I have mentioned is not exhaustive. We can talk about UNCTAD, we can talk about UNIDO, we can talk about many institutions, including, for example, the UN Office on Drugs and Crime, because unilateral sanctions create conditions conducive to involvement into transboundary crime due to poverty, due to hunger, due to food insecurity. UN Committee on Terrorism, UN Security Council seeking to suppress international terrorism. And the list of institutions is very, very broad. So therefore, as soon as organs will not start thinking on their own, I'm encouraging states to keep on pushing. It's not fast and it's not easy, to keep on pushing, to make these organs to start addressing the issues. Another element which I believe is extremely important has already been mentioned in the presentation of Professor Abashidze. He was talking about challenges which he is facing as a member of the Committee on Economic, Social and Cultural Rights, trying to raise issues of the impact of UCMs in the work of the committee. Although I believe that this committee is among those which can address it, not only in the specific general comment. He was referring to the general comment dating back to 1997, when it was mostly focusing on the impact of sanctions of the UN Security Council. Every single comment to the article relevant to the right to food, housing, labor rights, economic rights, right to health, and many other, they all are affected, and it shall be included. I believe that the UN treaty bodies, in general, can be a very useful instrument. The Human Rights Committee is basically also a good platform which can be used, because unilateral sanctions quite often result in death of people. Right to life is the primary right inherent in the International Covenant on Civil and Political Rights. Freedom from torture. If people do not get necessary medicine, and they are dying first of all, and they are dying in terrible pain, it can be qualified as torture. Prohibition of discrimination. And here it's mutually relevant to the Committee on Prohibition of all forms of racial discrimination. Discrimination on the ground of nationality, or ethnic origin, or being born in the country under sanctions, or living in the country under sanctions, is the issue which can easily be addressed in this committee. Coming back to the Human Rights Committee, we can talk about, for example, violation of the access to justice. There is a commentary done by the committee which doesn't even mention unilateral sanctions. We need to ensure access to effective remedy and access to justice as a right which guarantees the enjoyment of all human rights. I presented a report about the impact on the access to justice, and there is a number of recommendations, and committee has not been addressed. And what's interesting that during 6 years of my work, Human Rights Committee was the only one who refused to meet me and to talk to me at all. In the Committee on Economic, Social and Cultural Rights, we had discussions with some of members and some officials. No one from the Human Rights Committee was ready to talk to me. And there is a space where it's necessary to work. I also met Committee on the Rights of Child. Children is a vulnerable group. They shall be protected. Women is a vulnerable group because the Rim Asalim addressed this issue partially, but women are affected in many other dimensions as well, starting from reproductive health, up to labor rights, up to prohibition of discrimination, home violence, and many other elements. Committee against torture is also a reasonable place. So at the moment, what I can mention as a sort of the instruments to be dealt with when we are talking about treaty bodies is, first of all, using the reporting mechanism. Every convention provides for the possibility for states submitting a report to report about impediments it faces to make sure that proper reasonable human rights are properly implemented. There were only a few cases in a few of committees when states were saying that, yes, there are unilateral sanctions, they impede the achievement. But that's just a general statement. I'm encouraging states to provide detailed information, to do monitoring, and to demonstrate what exactly prevented them from getting proper medicine, food, and so forth. Because otherwise it will be a state blamed that the population is dying without medicine. Although it cannot import this medicine, it cannot ensure food sustainability, and it's doing its best, but it's not able to make sure that people get good education without pens, without pencils, without any equipment, and without even paper for children to study. That's why I believe it's a good instrument. The second part is general comments. I believe the approach shall be changed. And the third one is something what has never been done before, but we always have like someone doing it for the first time. I believe it's necessary to start dealing with individual communications. In that specific case, it's very risky, but and I'm sure that several first cases will be lost.
Yeah.
But that was the same what has happened when we started to talk about the right to favorable environment.
Yeah.
First 8 cases lost, and then it's already properly considered via other human rights. And that is the opportunity which can provide effective remedy not only to those who are directly designated, but to those whose rights are affected by enforcement and overcompliance. I'm very well aware, and we shall be prepared to the challenges arising from, for example, the element of the shifting responsibility when sanctioning states, enforcing states, and other sanctioning states, implementing states, and businesses will try to shift responsibility towards each other. But I believe it's a high time for the committee to say, to say no. We are recognizing that a state is responsible for human rights violations which are done by business. And we have proper grounds in that from the perspective of the due diligence. There could be an issue about the requirement to exhaust domestic remedies. But again, there is a practice in committees when the committee recognizes that it's not possible physically to exhaust domestic remedy, and that's the case of sanctions. Another element, which I'm already above the time, but I will try to summarize, judicial institutions. We have discussed in the moment the use of the WTO dispute settlement body and opportunity to use International Court of Justice. I personally believe that bringing a request for the advisory opinion to ICJ is not a good idea, because I'm afraid that we cannot formulate a question in the way when the court will address it properly. Asking whether UCMs are illegal, the response will be there is no treaty definition of UCMs. Asking whether states are entitled to apply unilateral measures, the response will be they can do retortions, countermeasures, and implement resolutions of the UN Security Council. At least I was not able to figure out how the question shall sound, but there are higher risks. At the same time, I believe that the practice of Iran bringing cases to International Court of Justice is very positive. And ICJ shall not stay the single body. There are different bodies. Naturally, it's necessary to be careful. There was a very bad example of cases brought by Venezuela to the British courts and European Court of Justice when it was attempted to tune the public law court to private law court and to deprive a state of immunities. But we already have learned these lessons about the risks. So therefore, if we are not doing, nothing will do it instead of us. Besides that, I believe that other UN organs, for example, those which are in charge for cooperation in criminal matters or struggle against terrorism, shall be actively involved. There was an area formula meeting which was discussing how much the possibility of struggle against terrorism or implementation of counterterrorism convention has been affected, and that's the case. And I believe it's also a good platform which can prevent people from involvement into terrorism because they will not live in poverty. UCMs result in poverty, hunger, and health insecurity. And that's explicitly a condition conducive to terrorism. Human rights violations is another condition conducive to terrorism. And I believe that's another very good platform. I also believe that it's necessary to involve OCHA and EASC as much as possible. I was very happy that the OHCHR did a statement for the first time during my 6 years of work, and I hope it will help us to involve OCHA and EASC. From my experience, when I was developing a monitoring tool, I invited them to participate. They came twice, said that the projects are too ambitious, and never participated again. I hope that they see that project is already implemented, it's real, so might be they will be more open. Therefore, I will stop here as soon as I'm already too long, and I will be happy to answer questions. And at the moment, I'm happy to give the floor to Professor Michael Strauss, who will address the issues of monitoring and impact assessment to ensure effective remedy for human rights. Professor Strauss, the floor is yours.
Thank you, Professor Duan, and thank you for the opportunity to be here more generally, because it's been a very fruitful session yesterday and so far today, and I'm looking forward to this afternoon as well. Yeah, that might help. And I hope the next few minutes will be fruitful also, because I'll be talking about monitoring and perhaps more specifically the absence of monitoring so far, because it's an interesting phenomenon. To have effective remedy for human rights violations, you have to assess the nature and the severity and the scope of the harm, and you have to identify the victims, individuals, groups of people, entire populations, whoever they are. These have to be identified and defined. Applying this to sanctions has always been problematic because of insufficient data. It's well documented that sanctions negatively affect the human rights of targeted and non-targeted persons, often inadvertently, but it's difficult to attribute specific types and degrees of harm to sanctions without methodical monitoring. This has been an obstacle until now to ensuring effective remedy for the victims. Sanctions imposed by the United Nations and unilaterally by individual states and groups of states contain usually no mechanism for systematically assessing their success relative to their political or other objectives, and they also contain no mechanism for systematically monitoring their impact on human rights. As Professor Huish said yesterday, UCMs need humanitarian review clauses built into them. But even sanctions that do require periodic reviews tend to get renewed, tend to get examined not too seriously. The renewals have a tendency to be almost automatic in many cases. So what the result of this is that the sanctioning party proceeds in the dark without a continuous flow of information about how its sanctions are performing politically or about the impact they're having on human rights. By not collecting timely data, it's impossible for the sanctioning party to take measures that are truly effective to eliminate or minimize the humanitarian harm while it's occurring. It cannot determine with precision what corrective action to take or when to take it, or even if any corrective action it does take is adequate, because that's also not monitored. Even official bodies established for the purpose of monitoring human rights do not systematically assess the impact of sanctions. I'm talking here about the UN human rights treaty bodies, for example. But the opposite is also true. Official bodies that are created to monitor sanctions do not systematically assess their impact on human rights. You have national bodies like the US Helsinki Commission, and at the level of UN sanctions, there's even something called the Sanctions Monitoring Team for the 1267 committee that oversees the Al-Qaeda sanctions. It has a mandate, and it says all sorts of things that it needs to track, but it doesn't include monitoring for any human rights problems that come up of it. It became clear that sanctions cause unintended human rights problems more than a quarter century ago. So the fact that sanctioning parties don't track the harm from their own sanctions cannot be attributed to a lack of awareness of the problem. Indeed, even the Security Council, after it mandated sanctions against Iraq in the 1990s, it failed to monitor the humanitarian impact of them while they were being implemented, even though other UN agencies consistently reported that they were causing this crisis. Since then, sanctioning parties, whether UN, whether it's states, they've demonstrated that they do know that sanctions harm human rights by introducing targeted sanctions and by incorporating humanitarian exemptions into their sanctions regimes. So they know. But the results of these corrective efforts also go unmonitored by the sanctioning parties in particular. And as we heard yesterday, they don't resolve the human rights problems that they're meant to address. So while sanctioning parties know that sanctions produced unintended harmful consequences, this has never aroused their curiosity to the point where they want to see what these consequences are in any coherent way. The failure to monitor the harm gives it a degree of invisibility outside of the immediate community of persons affected, because for the harm to become known, others must discover it, which may or may not happen, depending on its nature and scope, where it occurs, and the presence of outside entities that are in a position to become aware of it and report it. Any discovery of the human rights harm always occurs after it begins, and it may only happen after considerable harm has taken place. Even if the period of time between the harm and its discovery is brief, it acts as a window of opportunity for the sanctions to have further humanitarian consequences. Because sanctioning parties do not systematically monitor the human rights impact of their own sanctions, what knowledge exists comes from accounts in the news media, academic studies, the efforts of humanitarian NGOs, reports by the Special Rapporteur, and other outside sources. But reports and studies are often irregular in timing rather than ongoing and consistent. Some are one-time projects. There may be inconsistencies in the nature and integrity of the data that outside parties obtain and report as a result of their different methodologies and capabilities. And it's probable that much of the evidence of human rights harm that might be perceived through systematic monitoring by the parties involved especially is never detected. Calls for the parties responsible for sanctions to do this monitoring began as early as the 1990s with the UN Security Council sanctions. A General Assembly resolution in 1997 urged the Secretariat to get involved in coordinating assessments of humanitarian problems, quote, at the time of the imposition of sanctions and regularly thereafter. And yet it didn't happen. More than 2 decades later, the UN's monitoring and reporting of human rights problems arising from its own sanctions were described as, by one study, as reactive and ad hoc. So, not monitoring the humanitarian impact of sanctions is almost an old tradition by now. The fact that sanctioning parties also don't monitor the political results of their sanctions also has negative impacts for human rights, because it prevents a sanctioning party from knowing with any precision when its sanctions may warrant being lifted or eased under its own rules. This makes it more likely that the sanctions will stay in force or stay more onerous longer than necessary, and studies have shown that they do. It is easier to impose sanctions than to remove them. And the lack of systematic monitoring prevents situations in which partial success can be measured. It's true that systematic monitoring may never capture 100% of all of the human rights harm attributable to sanctions, but it can yield considerably more evidence than other means, and it can allow effective remedy to be designed with greater precision. For the process of monitoring to be effective in its own right, it has to look at various aspects. We heard about some of this yesterday. I divide these aspects as identifying the specific rights that are affected, as well as the breadth and severity of the harm, and the people who are the victims, including indirect victims. Another aspect of monitoring includes isolating the harm that the sanctions cause from other possible sources of harm to the same victims. This is especially appropriate when sanctions are imposed in an effort to improve human rights in some country or another. A third aspect is to collect the data at regular intervals because the harm can be variable depending on the sanctions and other factors. And finally, you have to assess the geographic reach of the harm. Sanctions have long been known to have unintended effects in third states, so you have to look there too, and especially with secondary sanctions, they can impact rights of people anywhere in the world. Sanctioning parties are the best place to systematically track how their sanctions affect human rights. They have the most direct interest in doing so in view of their international obligations. They can act earliest to address the problems that arise that the monitoring would reveal. And yet, because this doesn't occur, we can assume that the incentives to monitor are weak relative to the benefits of being ignorant. Why would a sanctioning state not want to know what its sanctions are really doing? It's really weird. Governments want to know everything. They make a lot of efforts to do it, but they don't want to know this. I don't know why, but I can guess a few reasons, and I suppose using the word guess in an academic setting isn't really the best vocabulary, but nobody actually says why they don't monitor. But you can deduce some things. Monitoring requires resources, and governments always complain that they don't have enough money, except maybe Monaco. Also, if you monitor the impact of sanctions, you might actually find something wrong with them, and that can be a political problem if the sanctions are popular. Also, the absence of data can allow a policy of sanctions to be unconstrained by the risk of being held accountable for specific harm they cause. Still, international law may offer a workaround. The very failure to monitor the sanctions' impact may itself be sufficient to give rise to responsibility. Almost done. Given the knowledge that sanctions harm human rights, imposing sanctions without procedures to assess their impact suggests that sanctioning parties engage in a form of willful blindness, that is, deliberately avoiding the knowledge of facts in an attempt to avoid responsibility or culpability, or possibly reckless disregard, a conscious lack of concern for the potential harm that they might cause. In some national legal systems, willful blindness is deemed equivalent to actual knowledge, and reckless disregard is equated with criminal negligence, exposing the party allegedly involved to prosecution and penalty. But these concepts are only sparsely used in public international law, and so far their only significant development has been with respect to war crimes in humanitarian law. With regard to sanctioning parties, the awareness that human rights harm occurs, together with the failure to monitor it, can be considered, in my judgment, an internationally wrongful act. The Articles of Responsibility of states and the Articles of Responsibility of international organizations for internationally wrongful acts both define such an act as, quote, conduct consisting of an act or omission that constitutes a breach of an international obligation. The lack of monitoring, in my view, is the omission that allows the harm to continue, and therefore it constitutes an integral component of that harm and of the breach of the obligation to protect human rights. The UN, OCHA, did publish a handbook in 2004 that proposed a comprehensive methodology for assessing the human rights impact of sanctions. There's no indication that it had prompted any large-scale or ongoing efforts to systematically monitor the effects of sanctions regimes. The Special Rapporteur did, through her mandate, develop a set of indicators to monitor the human rights impact, which led to the introduction of the impact monitoring tool that's already been mentioned several times. It's simpler, more accessible than the UN's 2004 methodology, and certainly more updated to reflect changes in what people are doing with sanctions. And maybe that can be a motivation. The monitoring tool makes possible a global system in which there can be regular and systematic reporting as well as assessments of the harm, including by sanctioning parties themselves, and hopefully by sanctioning parties themselves. We now have the guiding principles for effective remedy, which called on sanctioning parties to not only contribute information to the monitoring tool, but also to use it as a means of determining appropriate remediation based on the evidence collected. So there is hope. Every little thing that makes it more palatable and motivating to try to monitor, even by states that aren't interested in knowing, makes a difference. And I will stop here. Thank you.
Thank you very much, Michael. Indeed, the issue of qualification of emissions as the International Wrongful Act from that perspective is a very important element, and might be you will have a look at the draft commentary and will propose some text to be included. It will be very much appreciated. I fully understand that we have a panel of professors who can lecture about every single topic, but I have to be a timekeeper. So, Alfred, I beg you to stay within 12 minutes. And with all that in mind, I'm happy to give the floor to Professor Alfred de Zayed, who will talk about the potential of diplomatic protection as a foreign policy tool to counter economic sanctions, financial blockades, and other unilateral coercive measures. So please, the floor is yours.
Excelencias, hermanas, hermanos, colleagues, ladies and gentlemen. In the light of the proliferation of unilateral coercive measures and the adverse human rights impacts they generate worldwide, the question arises what measures states could and should adopt to counter them. Diplomatic protection on behalf of individuals and corporations harmed by UCMs is an underutilized foreign policy tool. Protection can be exercised through protest, retortion, countermeasures, arbitration, adjudication before international tribunals, declaring the ambassadors of the imposing states persona non grata. Bearing in mind that the UN General Assembly and the UN Human Rights Council adopt yearly resolutions condemning UCMs, and considering the growing number of scholarly studies and reports documenting the lethality of UCMs, it is hard to understand why affected states have not organized to push back against this lawlessness, why the BRICS countries, the Shanghai Cooperation Organization, the Global South countries have not joined forces to contest the legality of UCMs before the International Court of Justice, the International Criminal Court, as well as international and regional judicial and quasi-judicial instances, including the Human Rights Committee, the Committee on Economic, Social, and Cultural Rights, the European Court of Human Rights, the Inter-American Court of Human Rights, the African Court of Human and People's Rights, which provide for both interstate complaints procedures besides the individual petitions. Undoubtedly, states have the right to exercise diplomatic protection to defend the rights of their subjects and demand compensation on their behalf. Moreover, states should reaffirm the fundamental principle of sovereignty and demand reparation for the violation of the principle of non-intervention in their internal affairs through the extraterritorial application of foreign laws. The principle that a state has a right to protect its subjects vis-à-vis other states was already expressed in the 18th century by Émeric de Vattel in his treatise, The Law of Nations. Whoever uses a citizen ill indirectly offends the state, which is bound to protect this citizen, and the sovereign of the latter should avenge his wrongs, punish the aggressor, and, if possible, oblige him to make full reparation. The Permanent Court of International Justice and the International Court of Justice have concretized and expanded this doctrine. In its famous Mavromatis judgment of 1924, the Permanent Court of International Justice summarized diplomatic protection as follows: it is an elementary principle of international law that a state is entitled to protect its subjects when injured by acts contrary to international law committed by another state. By taking up the case of one of its subjects and by resorting to diplomatic action or international judicial proceedings on his behalf, a state is in reality asserting its own rights, its right to ensure in the person of its subjects respect for the rules of international law. In the 1927 Torso factory case, Germany espoused the rights of German subjects who had suffered discriminatory confiscations by Polish authorities. The PCIJ ruled that Poland owed compensation to the victims. The International Law Commission adopted draft articles on diplomatic protection in the year 2006. The rapporteur, John Dugard, has written extensively on it, and my chapter on diplomatic protection to be published in Alena's forthcoming book. You all know the book Sanctions, Business and Human Rights, and the book Humanitarian Impact of Unilateral Sanctions and Overcompliance. Now, a third book is coming out with some very powerful articles in it. The International Court of Justice expanded this principle in the Barcelona Traction case, ruling that diplomatic protection can be exercised on behalf of individuals and corporations. It also elaborated the notion of obligations owed erga omnes to the international community. Other significant cases concern human rights matters. For example, Lagrand against the United States case, the Avena against the United States case, both concerning failure of the U.S. to abide by the Vienna Convention on Consular Relations and the imposition of the death penalty on 2 German nationals and 51 Mexican nationals. Notwithstanding the provisional measures issued by the ICJ to prevent the execution of these German and Mexican citizens, the United States proceeded to execute the 4 nationals. In its 1980 judgment in the United States diplomatic and consular staff in Tehran case, the U.S. exercised diplomatic protection on behalf of its diplomats. The ICJ decided that the ruled that the Islamic Republic of Iran had violated, in several respects, a number of treaties. In the 2023 judgment, certain Iranian assets, that's Islamic Republic of Iran against the United States case, Iran represented the rights of its citizens, corporations, and banks affected by unilateral U.S. decrees. In its 2023 judgment, the court held that the United States of America had violated its obligations and owed compensation. In the 2012 case before the ICJ, Amadou Sadio Diallo, the Republic of Guinea, successfully defended the rights of its citizens in the Democratic Republic of the Congo before the court. In a separate opinion, the late Judge Cansado Trindade from Brazil notes, quote, that ours are the times of a new jus gentium focused on the rights of the human person individually or collectively, end of quote. There are concrete precedents that should encourage states to challenge the legality of UCMs before the ICJ, focusing on the obvious violations of multiple articles of the ICCPR, ICESC, CRC, European Convention on Human Rights, etc. The ICJ would have no option but to rely on its own precedents and explicitly condemn UCMs as contrary to the UN Charter and fundamental principles of international law. The European Court of Human Rights judgment of 10 May 2001 in the case Cyprus against Turkey can be used as a model for interstate complaints against European states that impose UCMs. In the Cyprus judgment, the court held that Turkey had violated Articles 2, 3, and 5 of the European Convention and a continuing violation of Article 1 of Protocol 1 by virtue of the fact that Greek Cypriot owners of property in northern Cyprus are being denied access to and control, use, and enjoyment of their property, as well as any compensation for the interference with their property rights. The Meng Wanzhou dispute concerning the application of United States UCMs against Iran and the alleged circumventing of these UCMs by Huawei. It's a case in point. In December 2018, Ms. Meng, deputy chairperson of Huawei, the Chinese multinational technology corporation, was detained in Vancouver for alleged violations of the U.S. sanctions. China deployed a variety of diplomatic and economic measures, resulting in her release in September 2021. The Huawei case would have been a perfect occasion to further develop the jurisprudence on diplomatic protection, but China chose to use other means, and rather muscled means at that. While diplomatic protection could be used in thousands of cases, states have failed to use this foreign policy tool effectively. Whenever a state brings a case before the ICJ, it should also consider asking for provisional measures under Article 41 of the statute. Such interim measures are binding. In numerous UCM cases, there would be irreparable damage unless the violation is immediately stopped. This is certainly the case with some US and EU sanctions that place the targeted person in legal limbo without recourse, and in cases of comprehensive UCMs, expose the population to hunger, disease, and ultimately to death. In some cases, it can be said that the failure of the state to assert the rights of its citizens amounts to a denial of justice, a separate and distinct violation of human rights committed by the state that fails to act on behalf of its aggrieved citizens. Among culpable omissions by states, we can think of Australia's inaction to protect the rights of its citizen Julian Assange when he was being subjected to persecution by the US and UK, a scandal of major proportions which the UN Special Rapporteur on Torture, Professor Niels Melzer, documented meticulously in his reports and in his book, Der Fall Julian Assange. Far worse than the Dreyfus affair in France in the 1890s, the Assange affair revealed a serious breakdown in the rule of law in the US, UK, Sweden, and Ecuador, and yet Australia did nothing until Prime Minister Anthony Albanese commenced negotiations with the US and UK in 2014 that led eventually to Assange's release. Yet Assange was not compensated for the humiliations and psychological torture he endured. Another scandalous failure was that of the US that did nothing to protect US journalist and filmmaker Gonzalo Lira, who died 2024 in a Ukrainian prison. The US could and should have used diplomatic protection on behalf of Gonzalo Lira, as many NGOs demanded, but the US deliberately failed to do so. Yet another example is the failure of the government of Switzerland, France, and Germany to effectively challenge the imposition of EU sanctions against their own citizens. The case of the retired Swiss colonel and intelligence officer Jacques Beau is emblematic. The Geneva International Peace Research Institute has filed a protest with the Council of the European Union, and yesterday we received a blah blah response. Pathetic. I am expanding on this issue of Jacques Beau in a long article that is to be published in Counterpunch later on this week. To this day, many governments maintain that the exercise of diplomatic protection is a political act and remains a discretionary matter. One of the many tools of foreign policy of every foreign state, sovereign state. Even if it has not yet coagulated into law and practice, an exception to the discretionary approach is emerging because of the erga omnes obligations of all states to promote and protect human rights, to prevent genocide and crimes against humanity. Genocide must not only be punished, it must be prevented. And states have an obligation to do so by every means available, including diplomatic protection. This entails proactive defense of persons threatened with extermination and punishment of those responsible for persecution and genocide. In other words, there is no discretion in the use of diplomatic protection when the violations of human rights entail crimes against humanity or genocide, e.g., when they cause tens of thousands of deaths, as they do in Cuba, Venezuela, etc. It is time for the International Law Commission to resume its work on diplomatic protection and to adopt a viable definition of the concept, even if some countries, including those imposing UCMs, are likely to oppose this initiative. I have a proposed longish definition, which I will spare you, and but you will be able to read about it in the book. In conclusion, diplomatic protection is a promising foreign policy tool. In the light of the proliferation of UCMs and their lethal consequences, it is imperative that states systematically counter this lawless development diplomatically, politically, and judicially. UCMs are demonstrably more damaging than the problems they are supposed to remedy. As the Roman poet Vergilius wrote, egrescit medendo. The cure is worse than the disease. Economic sanctions and blockades have been shown to take a yearly toll of hundreds of thousands of lives worldwide. They have been ineffective in achieving their true geopolitical aims of inducing regime change. UCMs remind me of the obsolete medical practice of bloodletting that over centuries contributed to the demise of King Charles II. George Washington, few people know that. He was bled to death. Lord Byron and others. In any event, these arguments are all expanded in the rather longish chapter I wrote on diplomatic protection, with everything concerning the International Law Commission and the definition of John Dugard, et cetera, et cetera. There's promise here. Thank you.
Alfred, indeed, there are lots of elements which you have addressed and which I'm sure are still to be addressed, and I'm looking forward to our final book. I'm sure it will be of high interest for everyone. And our next panelist is Innokenty Karandashov, who will talk about the impact of unilateral coercive measures on Russian law, who will do his presentation via video statement.
No, I'm here. Well, now I will share my presentation. Dear colleagues, can you see the presentation?
Yes, we can.
Okay. Ladies and gentlemen, good afternoon. Well, today I would like to present the report, which actually was prepared by my colleagues and I. So we are the group of scholars who actually have been studying the impact of the USCMs on Russian legal systems since 2022. However, first of all, I would like to express my gratitude to Special Rapporteur Alena Duhan and to Asana Rashidze. Thanks to them for the opportunity to take part in the conference. And I would also like to express my gratitude to all those people who helped me to tackle difficult technical issues, so I could participate in the event. So I mentioned something about our expertise. I would also like to add that most of us are engaged in Russian notariate assistance project implemented by our university, where we deal with difficult issues arising in notary practices, and in particular with issues of application of anti-sanction bylaws adopted in Russia. Mainly, this report is based on our study of more than 1,000 judgments delivered by Russian courts, and mostly from 2022 to present date, where so-called unfriendly factor was involved. So mainly, my presentation will be about Russian legal system and its transformations under the USCM's pressure, and in particular, it's about changes in jurisprudence of Russian courts that actually was caused by USCMs. So I would like to stop a little on some issues of terminology. In Russia, we have so-called arbitration courts. Actually, arbitration courts have nothing in common with arbitral tribunals and international commercial arbitration. Arbitration courts are those majoring in economic cases. It's cases where we have disputes arising from commercial activities. So when I mention arbitration courts, I mention state courts. And we also have special arbitration procedure code for the proceedings in these courts. Well, during my presentation, I will also refer to use the term unfriendly state. It's a state or territory that adopted USCMs against the Russian Federation. Well, in 2007, the high leader of Iran actually coined the term resistance economy. I think the same is true for legal systems because they also are transforming under the USCMs, and mostly anti-sanction norms emerge. In Russia, we have some laws that actually include anti-sanction norms, in particular Lugovoy's Act. I will tell about it later. And bylaws, they enact special anti-sanction measures. The overall system of anti-sanction norms is very sophisticated, and some norms might be interpreted broadly, but at the same time, it makes the overall system more adaptable. Actually, the fact that the system is sophisticated may be easily explained because all these decrees that establish special measures against the USCMs, they were adopted in times of emergency, and actually our authorities did not have much time to think about how they comply with each other and about some formulations. So that's why it's quite difficult issue to apply them. Well, as for Lugovoy's Act, it was adopted in 2020. I think the reasons for its adoption are understandable to all of you. And here I listed some of them. So in the situation when USCMs are adopted, well, it's prima facie impossible to guarantee a fair trial for Russian parties in the courts and arbitration tribunals when they are connected with jurisdictions adopted USCMs against Russia and its persons. Especially in these cases, however, it doesn't exclude possible troubles in neutral or even friendly jurisdictions because USCMs have extraterritorial effects. Well, Lugovoy's Act actually inserted two articles in our arbitration procedure code. It's Article 248.1 and 248.2. The first one has established the exclusive jurisdiction of Russian arbitration courts over disputes involving sanctioned persons or disputes arising from anti-Russian sanctions. And the second one actually granted to these persons the right to seek anti-suit injunctions to prohibit the initiation or continuation of proceedings in a foreign court of international commercial arbitration. Actually, this act was expected. It was planned that this act will allow courts, after scrutinizing every case, decide on whether these two articles should be applied. However, the jurisprudence actually went its own way, and Russian arbitration courts actually adopted a broader interpretation. The mere fact of being targeted by sanctions was deemed sufficient to invoke the court's exclusive jurisdiction. However, subsequently, this shift became a subject of scrutiny by the Constitutional Court of the Russian Federation, and the court actually concluded that these provisions, I mean the provisions of Lugovoy's Act, they should not be applied automatically. So I think that in future, our jurisprudence will come to the point from which it actually started. So I think that courts will start to scrutinize every case again. Actually, I think that adoption of this act was quite, I would say, quite effective decision, because recently the European Union has implemented a specific prohibition on the recognition of or enforcement of judgments issued by Russian arbitration courts on the grounds on that very provisions and Article 248. So actually it shows that such a tool actually works. Another interesting example of how anti-sanction norms might work, and this example also illustrates another danger, I would say, from the USAMs to the principle of the rule of law, is the jurisprudence concerning the application of Decree number 79. Actually, it was the first decree, first anti-sanction decree adopted after February 2022, and it provides for some provisions restricting currency operations. So it doesn't include the whole, the whole system of anti-sanction norms. Only some of them. Only those ones which were necessary at the beginning of all these troubles. However, this decree was referred to in more wider context by Russian parties to disputes. They frequently insisted that actually due to political situation and due to the fact that this decree was adopted, another party, a counterparty in the dispute, if it has some connections with unfriendly states and unfriendly jurisdictions, so the claims of the latter must be dismissed due to the very fact that it has these connections. So here we see that actually Russian parties, they offered purely political arguments wrapped up in in the letter of this decree. So in this case, hopefully, courts courts actually quashed these arguments, referring to the very letter of this decree and pointing out that actually the decree doesn't provide for the norms that would deprive the companies from unfriendly states their right to remedy. However, we see that actually, if the courts had adopted such an approach, that would have posed critical threats to the rule of law principle, because we see that in this situation, law arguments would be substituted with political ones. I'm sorry, the political arguments, yes, would be substituted with law ones. The UCMs greatly influence the Russian public policy, and we see that gradually Russian courts have come to the view that actions of private persons based on foreign legal acts which provide for the UCMs against Russian nationals and legal persons are to be assessed as unlawful from the point of Russian legal order, and that the law of state that adopted UCMs, even if this law was chosen by parties in the transaction, is not applicable as a whole, and not only in part of provisions imposing UCMs. So actually, there are no problems with the application of law of friendly states, but there are such problems with the application of law of unfriendly states. Another interesting consequence is the qualification of force majeure cases by courts, the qualification of situations as force majeure. Actually, Russian courts, they adopted, restrictive approach to the qualification of force majeure. So usually they did not consider the UCMs and their consequences as force majeure circumstances, mostly due to the fact that they found out that actually the interested party to dispute didn't manage to prove that actually these circumstances totally removed their ability to fulfill their obligations under a transaction. However, in some decisions, courts took the opposite view. For example, in one case, the party managed to prove that the uniqueness of the equipment that was to be delivered to it, and the courts agree that due to the uniqueness, the similar equipment could not be delivered, could not be bought from a Russian company or from a company from friendly states. So I'll move to my conclusions. I intentionally put this picture on the slide because you can see that St. Petersburg is as miraculous, as beautiful as it as it had been before sanctions was adopted. Well, my conclusions are that Russian legal system has adapted itself to USM's pressure. Transformations of Russian law helped to mitigate the impact of the USMs on Russian economy. The very fact that consequences of the application of those two articles of Legal Voice Act have become the subject of the EU regulation is the evidence of their effectiveness as anti-USM's tools. The third one is that approaches of the courts to force majeure as regards cases where the UCMs and their consequences were referred to have actually sped up the adaptation of economy to UCMs because, I just imagined that companies that noticed that actually courts didn't frequently recognize such circumstances as force majeure. Well, they thought perhaps it's better to order goods from Russian company or from a company incorporated in friendly states, then try to maintain international commercial relations from companies from unfriendly states. So that actually sped up the termination of international commercial ties with unfriendly states and the emergence of similar ties with others. We also see that USMs, that is those adopted against Russia, deeply affected implementation of the right to effective remedies and fair trial, international disputes. Actually, it corresponds, our findings confirm the conclusions that were made in guiding principles on sanctions, business and human rights. And we see that actually this problem exists. And we think that potentially such measures might also affect the implementation of rule of law principle. And here I draw your attention to the jurisprudence concerning the application of decree number 79. So the influence of the UCMs on the rule of law principle was also mentioned in the guiding principles. However, we we came to the same conclusion, but a little bit from the other side. We see this influence in attempts, to pull political arguments in the proceedings. So thank you for your attention.
Thank you very much, Professor. I have a feeling that it was a large mistake from my side to put all professors in one session. We all are very much behind the time. However, I would ask for your understanding as we started a bit late. So we will stay during the lunch break a bit to be able to listen to our last panelist, and I already have 2 requests to ask questions. So without further delays, I'm happy to give the floor to Dr. Boyi, who will talk about the China's anti-foreign sanctions law as a remedy against UCM, so very much relevant to what has been just said as concerned the Russian law, so legal framework, judicial practice, and private law mechanism. So please, the floor is yours.
Thank you, Chair, distinguished colleagues, ladies and gentlemen. Thank you very much for the opportunity to speak. My name is Bo Yi. I'm a researcher at the Institute for the Development of Socialism with Chinese characteristics and the Institute for Human Rights, and associate professor of international law at the Law School of Southeast University in China. And I'm also a practicing lawyer at the Jiangsu Yiyou Tingyuan Nanjing Law Firm. My remarks today are based on my paper. And I have to note that this paper has another co-author. Her name is Zhang Lixiao. She is a PhD candidate in international law at Hunan Normal University. This paper examines China's anti-foreign sanction laws, or AFSL, as a remedial response to unilateral coercive measures and the over-compliance they produce. More specifically, my paper asks a practical question: when foreign sanctions and sanctions driving de-risking cause concurrent harm, what kind of legal remedy is actually available, and under what conditions can that remedy become effective? I would like to make one basic point at the outset. In sanction debates, we often spend a great deal of time discussing legality in the abstract. But for those who are directly affected, the more immediate question is different. It is not only whether a measure is lawful, it is whether there is any realistic peace to challenge it, to contain its spillover effects, and to obtain relief. In other words, the real test is the right to an effective remedy. This is also very much the logic of this session. The concept note places effective remedy at the center and links it to several connected issues: diplomatic protection, monitoring and impact assessment, the role of the United Nations, the possible role of the International Court of Justice, legal limits in the implementation of Security Council resolutions, and the obligations to ensure fair trial and effective remedy in sanction regimes. My first point is that the remedial defeats in sanctions environment is structural, not essential. At the background materials for this conference make clear access to justice, due process, and fair trial guarantees, and the right to an effective remedy are fundamental of the protection of all human rights. Yet, unilateral sanctions are often designed and imposed outside judicial procedure. The result is predictable. These things are hard to challenge. Evidence is difficult to access. Legal representation become costly, assets are frozen, and over-compliance by banks and business makes even lawful transactions difficult or impossible. My paper starts from the same concern. It argues that unilateral sanctions, secondary sanctions, and expanding destination practice have created serious barriers to access to justice in practice. This means not only that sanctioned parties suffer, but also that a much wider group of actors may be harmed by over-compliance: suppliers, banks, insurers, shipping companies, and ordinary commercial parties, whose transactions are blocked out caution rather than out strict legal necessity. My second point is that domestic law still matters, but only if it offers a real remedial design. This is where my papers turns to AFSL. I argue the anti-foreign sanction law should not be seen only as a geopolitical countermeasure. It should also be read as an attempt to create a legal avenue through which affected Chinese parties may seek judicial protection. The key provision is Article 12, which allows a Chinese party to sue an organization or individual that implements or assists in implementing discrimination foreign restrictive measures and thereby injures its lawful rights and interests. That matters because it creates a private course of action and links the language of suing to the language of judicial remedy. The most important example so far is the 2024 Nanjing Marine Court case, which my paper used as its central case study. In that case, a Chinese company completed its contractual work, but the foreign counterparty withheld payment because it feared the United States sanctions. The Chinese court accepted the claim under the Article 12, ordered pre-litigation vessel detention, maintained leverage through asset control, and eventually facilitated a mediated settlement after the foreign party applied for an OFAC license. I do not treat that case as a resolving every doctrine issue. It did not end in a final merits judgment, but it demonstrated something very important. Remedy becomes meaningful only when rights are tied to jurisdiction, procedure, preserve measures, and enforcement asides. My third point concerns diplomatic protection. The concept note asks us to consider diplomatic protection as a means of access to remedy for human rights violations. I think that's right, but only up to a point. Diplomatic protection remains important because many injured persons and entities do not have direct standing before international courts. In such situations, diplomatic protection can elevate private injury into the language of interstate responsibility. It can help transform which is often dismissed as a commercial dispute into what may also be a due process problem, a property-related injury, and denial to access to justice. At the same time, diplomatic protection cannot be the whole answer. It is discretionary, it depends on political will, and it does not replace domestic judicial remedies. So I would treat it as one layer of the broader remedy structure, not as a substitute for one. And my fourth point is about the role of the United Nations and the possible role of International Court of Justice. The relations remains independent in at least three ways. First, it provides a normative platform for clarifying due process, fair trial guarantee, license transparency, and the responsibility of state and abilities in sanctions environment. Secondly, through reporting and systematic work, it makes visible harms that are otherwise dispersed or abstract, especially harms caused by over-compliance rather than by the firm text of sanctions. Thirdly, it can help keep the discussion another in the rule of law rather than pure geopolitical rhetoric. As for the ICJ, its role is necessarily more limited. It is not a court of general human rights appear for sanction-related injuries, and private actors cannot appear before it directly, but it can still play an important role where disputes are framed between states, clarify treaty obligations, due diligence, state responsibility, and the legal boundaries of coercive economic measure. So I would not overstate the ICJ's practical reach, but I would not dismiss its normative value either. These of my final point, fair trial and effective remedy must be treated as minimal requirements, not optional additions. If sanctions regimes operate through presumption of wrongdoing, inacceptable evidence, high dislisting costs, foreign funds, and practical barriers to legal representation, then the problem is not only one foreign policy, it's also one of legality. Any serious sanctions framework, whether national or international, must be judged in part by whether affected persons have a genuine opportunity to be heard, to lodge a case against them, to seek review, and to obtain a remedy that is real rather than purely form. Let me conclude it in a very simple way. My paper is about China's anti-foreign sanction laws, but the larger issue is not only China. The larger issue is whether international law is prepared to take remedies seriously in sanctions environment. My own conclusion is that three things are needed. We need stronger domestic remedy avenues. We need better international monitoring and clear legal standards. And we need to recollect the language of human rights with the design of actual procedures. Because rights do not protect people by being declared. They protect people only when there is a formal process and standard of review, and a remedy that can actually be enforced. Thank you.
Thank you very much, Dr. Boye, for your presentation. I feel that I have fully failed to be a good moderator and timekeeper today, but all presentations were amazing, and I didn't feel to be authorized to stop them. Again, so using a bit of my moderating capacity, I will start with asking questions to two last presenters. So the first question is, we got good presentation, what the national law is doing to deal with private law cases. So it's mostly about businesses. Do you see any opportunities how national law can also provide a good remedy to those who have been affected by unilateral sanctions or means of the enforcement or over-compliance due to UCMs? So we need to protect individuals as well, and states also, I believe, shall do something to help their own nationals. And the second question is that, upon my own knowledge, I usually see that the majority of cases we address are private law disputes when we are talking about the business activity. So it's very good that you have mentioned the issue of countermeasures, and very good that you have mentioned international public law and human rights law. To what extent international public law is used in argumentation when sanctions-related cases are dealt in private law disputes? And with all that, I'm moving to people who have asked for the floor, so I'm happy to give the floor to the representative of Chile.
With the caution that I could be lost in translation because English is not my first language, I wanted to ask two questions to you, Special Rapporteur. The first one is, from your reports and what you have said now, I understand that you have made the point of the transversality of the impact of UCMs in different forums of United Nations. And within the principles that we are discussing, you have settled definitions of UCMs and unilateral sanctions. Also recalling that in 2020, Iran presented a proposal to discuss the definition. And after almost 50 years of this debate and 6 years that you have been in the mandate, do you think that now is the time to actually discuss the definition of UCMs in a much broader fora, like the General Assembly or something that could give a more consensus for the definition? Because as Chile understands, if we want to talk about effective remedies, the only way to do it is by having a binding and an operative definition of UCMs. With that, if we don't have that, we are going to be circling once and over according to what some countries understand are UCMs and others don't. And my second question is related to the last resolution that was adopted by the Human Rights Council. In the operative paragraph 27, it talks about the fact that the Office of the United Nations of the High Commissioner for Human Rights is going to collaborate and to ensure the operationalization of the monitoring tool. And in that regard, how do you envision that we have a more constructive governance in where countries, like for example Chile, could be part of this monitoring tool and propose different indicators to differentiate between specific measures and more generalized measures? Thank you.
Thank you very much for your question. I have a request from Andrea Diaz. Please take the floor.
Very much. Good. Excellencies, the Special Rapporteur, colleagues, thank you for giving me the floor. First of all, congratulations for the draft of the guiding principles, and also thank you for the kind invitation to the international conference. I would like to mention that I was quite surprised when I was reading the concept note that there's a mention that issues of responsibility for international law and human rights violation have not been in the focus of attention of academia. And I would like to begin by reassuring the Special Rapporteur that in academia we have been working hard in this particularly topic. This is my PhD thesis conducted at the University of Geneva and is entitled A Study of the Legality of Unilateral Coercive Measures under International Law. And it's particularly oriented to determine if we can legally qualify unilateral coercive measures as internationally wrongful acts under the law of a state responsibility. And I take also the advantage to thank the Special Rapporteur for the interview she offered me, and she was always available for my consultations, and her team in her office, and her valuable contribution is only in this book that was published last year in Switzerland, and we have a preamble also of Professor De Zayas, who is in the panel. And my intervention is going in that direction. I want to talk about the guiding principles on effective remedy and responsibility in the unilateral sanctions environment. And if you allow me to quickly read paragraph 20. I don't know if you have your own copies, but well, share responsibility for violations of international law and human rights that may result from the adoption, enforcement, or compliance with unilateral coercive measures. And then if we go particularly to paragraph 20.3, mention states and international organizations share responsibility for a single or multiple internationally wrongful acts when conduct consisting of an action or omission is, first, attributable to each of them separately, is the first element, the imputability to the state. Second, constitute a breach of an international obligation for each of those international persons. Second element that we need, the violation of a legal obligation. And third, contribute to the indivisible injury of another person. And here we introduce a third element, the damage. So we need the condition of a damage to a person to prove UCMs are internationally wrongful acts. And if you allow me quickly to go to the definition of injury that you included in the terminology section, injury includes any damage, including death, physical injury, deterioration of health status, material or moral harm. And my question is, if in the traditional approach that was adopted by the International Law Commission and the United Nations General Assembly in 2001, 25 years ago, when they adopted the draft articles of state responsibility, they decided to retain only two elements, the imputability to the state and also the legal violation, the violation of a legal obligation. Why? In the guiding principles, in the context of UCM, we decided to introduce the element of the damage, if at the time they decided intentionally to exclude the damage. Why? And this is my concern, and I would like to illustrate with a practical example. We have several types of UCMs. And for example, how can we prove the damage to a person in cases like closing a bank account, which is also causing a moral harm, but is a physical damage? We can say no. However, is a moral harm? And some argue yes. And I agree. As a previous former diplomat, I was also subject to such kind of situations. However, there's not a reliable method to measure and to quantify the level of frustration that can feel an engineer when they don't have access to software for their professional purposes. Or how can we measure the level of frustration of students, professors, experts, artists, that they don't have access to reliable websites for their academic works. So it's very extremely difficult to prove the level of frustration and the social and professional isolation that this UCM can cause. So just to conclude, I would like to say that from my perspective, it will be probably good to think about it if we should include the element of the damage as a condition to invoke state responsibility in the context of the guiding principles. And I put this in the table for the debate. And just to conclude my intervention, I would like to ask Professor De Zayas, if we have time. Yesterday, during the high-level segment, we hear interventions from the global north trying to justify the imposition of these unilateral coercive measures. My apologies. They mentioned restrictive measures or autonomous measure. So in your academic perspective as a former independent expert, how do you think is the narrative manipulated by some delegations in the global north? Thank you very much.
Thank you very much for your intervention. It's very good that developed documents are initiating discussion. And the broader the discussion is, the better. And I see I'm giving the floor to the South Center, but I would appreciate if you limit yourself to 2 minutes. We are very much beyond the schedule.
Thank you very much, Madam Chair. I'll be quick. At the outset, I would like to thank you, the independent expert, and the group of friends for the defense of the UN Charter, for the successful organization of this very important timely conference. Specific to the session right now, I would like to highlight the fact that in terms of effective remedy, there is a new process that we have seen at the South Center where a lot of individuals and companies who have been sanctioned or are being affected by unilateral coercive measures, they have taken recourse to what is called as investor-state dispute settlement under bilateral investment treaties, in which they are challenging the damage that has been caused to them due to the imposition of such UCMs. In 2025, around 28 investment disputes, investment claims were filed against imposing countries under investment state arbitration, with the claims for damages around $62 billion. We have seen in the past that investor-state arbitration has been used by investors from the global north to target countries in the global south for their policy actions. And now this is a phenomenon that we are seeing in reverse, where sanctioned individuals and companies are taking recourse to ISDS. So I want to ask the panel to perhaps reflect whether such recourse to investor arbitration in private panels could be a mechanism for effective remedy to be raised. I understand it's very limited the number of people who could use it, but is it a possible avenue for seeking redress? Thank you very much.
Thank you very much for your intervention. I do not see anyone else willing to take the floor. Just as a sort of the prejudice, I would respond the last question, and the response is naturally yes. So it's necessary to, I was always advocating that it was possible to use all possible instruments which are available from the legal perspective. And take into account again that we are very much beyond the schedule, I would appreciate if the panelists will limit themselves to around 3 minutes for responses. So I'm giving the floor to Professor Strauss. No questions any longer. We are just final remarks and answering questions.
Okay. In that case, I will respond by saying that these blocking legislation, sometimes they're more effective than others. One thing that I would love to see it go further and actually become a deterrent to sanctions as opposed to countering existing sanctions, and that would be a nice direction for these to move to. And I think I'll just stop there.
Thank you very much, Michael. So Alfred, 3 minutes.
Yes, can I have a short?
I apologize. We go in the same order as we have people on the list, so apologies. It will come.
Thank you. I could speak for hours on that one.
3 minutes.
And in any event, you have the answers here, the human rights industry. What do I write there, among other things? That the arguments used by my dear country, the United States of America, in justifying its aggressive, regime change-oriented unilateral coercive measures against Cuba, against Nicaragua, against Venezuela, against Iran and other countries. The narrative of the European Union in justifying the unjustifiable, in justifying the debanking of European citizens like Jacques Beau, like 3 German journalists, etc., without a court hearing, without any chance to defend themselves. I mean, they're essentially being made non-persons. And these are such gross violations of the Charter of Fundamental Rights of the European Union, such gross violations of the European Convention on Human Rights, and if the case is submitted to the Human Rights Committee, the Human Rights Committee will find violations of Articles even 7, but it will find violations, obviously, of Articles 2 on remedy, on Articles 14, right to a fair hearing, Articles 21, Articles 22, Articles 25, Articles 26, discrimination, etc., etc. It's all so clear. It's been all so well documented by countless professors of international law, and I find that it is culpable. It is this kind of culpable blindness, the disregard of the empirical evidence that hundreds of thousands of people have died because of these unilateral coercive measures, which they like to call sanctions. And I refuse to call them sanctions because that is manipulation of language. We have here from the European Union, and I must say I am a believer in the European Union, in the original European Union, in the original thought of peace through law in Europe. And what do we witness? We witness here intellectual dishonesty taken to an Orwellian level. We're witnessing destruction of language, and it's something that we must push back against. And I said, my organization, the Geneva International Peace Research Institute, submitted a very strongly worded protest against the Council of the European Union concerning these so-called sanctions against 6 European citizens as completely incompatible not only with European law, but incompatible with general human law. I mean, it's an aggression against civilization. And I must say, think about it. I mean, put yourself in the position of Jacques Beau and what has happened to him, because Jacques Beau is integrity in person. I know him. I've known him for many, many years. I've read several of his books. And to have him sanctioned in this matter, it is totally unacceptable. Thank you.
Thank you, Alfred. Just want to say that your institution was not the only one. I sent a communication which is currently online, and Atiya joined me and 3 other mandate holders, but not about him only, but about all 57 persons, including Russian nationals and nationals of other countries. I believe we should not differentiate between European nationals and nationals from any other states. So now I'm giving the floor to Innokenty Karandashov. Please, the floor is yours for responses. 3 minutes, please.
Yes. Thank you, Alona. Well, first of all, we will say that there is no sole instrument that could actually ensure that the parties to disputes will receive a good remedy, at least when it comes to proceedings abroad in the states that adopted the USAMs. So, however, the targeted state may adopt some measures that actually can mitigate the influence of USAMs and the consequences of obstacles to obtaining remedies in unfriendly states. First of all, perhaps it may sound too radical, I would say, to freeze as much assets of companies that have any connections with unfriendly states as possible, because when UCMs are introduced, well, companies that feel that it's the countries to which they have links, they try to move away their capitals from targeted states. Because if, for example, the companies from targeted states will not have the opportunity to receive, a full relief from proceedings abroad, perhaps a government of targeted states may create some mechanism for taking compensation from these freezed assets. assets of private persons. Another possible measure is non-enforcement of foreign decisions and arbitral awards, where UCMs could influence the outcomes of the disputes. Yes, and the third one, I think, is it seems to me possible to conclude treaties where the implementation of UCMs against contracting parties will be expressly prohibited. I am not sure that this practice is widespread. However, for example, Russia has a treaty with Mongolia. It's a treaty concerning friendly relations and the whole strategic partnership between Russian Federation and Mongolia. And there is Article 4, which actually obliges contracting parties to stay from participation in some activities or supporting such activities that are aimed against the other side. Well, it's just, it's quite a general provision. However, I think that it may work as a prescription to the implementation of UCMs. But it's better to include more specific provisions in treaties.
Thank you very much. It might sound very reasonable from the perspective of national law. I'm just calling as an international lawyer to be very careful for application to these measures. Any measures taken upon my view as an international lawyer and mandate holder shall stay within the limitations of countermeasures, not to start violating international law on your own. And I'm giving the floor to Dr. Boyi, please.
Yes, thank you. Let give a very short response to the relationship between public law such as China anti-foreign sanction law and private law mechanism as a remedial tool against the unilateral coercive sanctions. As you know that the China anti-foreign sanction law provided a statutory backbone, but in practice the work of protecting commercial interest in sanctions environment falls largely to private law, to contracts, insurance policies, and the governance structures through which bids navigate competing compliance demands. What follows exam for category of private law tool that used alongside the China anti-foreign sanction law can materially improve the remedy position of affected parties. That is my short response. Thank you.
Thank you very much. And I would appreciate your patience for 3 more minutes. I cannot ignore questions being asked by Chile and by Andrea. As concerned the monitoring tool, we were developing that for 2 years. And we sent 3 requests to states for proposals, to indicators for structure. We tried to be as transparent as only possible, had 2 or 3 side events as soon as it has been launched. And the idea is, I believe that basically we did our best to have certain shape. Naturally, there is always a way for improvement. So I only hope that it will not disappear. To be able to talk about the violations and damage, we need to be able to identify them first, to register them second, and thirdly, to reveal causality link. And the tool intends to provide for the possibility to reveal causality link and to provide all institutions, not only UN, but also states, but including individuals, to tell their own stories. So I hope that if it develops and improves, I will be the happiest person. Now my main concern that it might disappear, because I can assure you it's an extremely complicated work, which we were doing, like starting to invent the tool from nearly zero. Then the second question concerning the definition, the answer will be yes or no, and no. So yes, there is a definition. I participated in 2013 consultations together with Alfred when the very need to address the issue of UCMs and to establish this mandate has been discussed within the Human Rights Council after the report of 2012 Alfred has mentioned. And there was a discussion about the definition of UCMs already. In my report in 2020, I proposed to make it more specific in comparison to the current resolution. And yes, I think there is a way forward, as a scholar and expert, I like the definition I proposed, but I'm a scholar, so it's opening the floor for discussion. However, when we come to the issue of remedy and responsibility, no, we do not need a definition. For the issue of responsibility and remedy, we need to be able to establish whether international law has been violated. If there is a violation, people shall already be entitled to get remedy and to get responsibility. So there are many issues like international terrorism. There used to be lots of treaties without any definition of terrorism, but still states were working in the area. Same way, yes, if your human rights are violated, you shall get access to remedy. If international law is violated, the state shall get access to remedy, and the issue of responsibility is on the table. And it brings me logically to the question by Andrea. The issue was, in developing this document, the intention was to talk about responsibility and remedy, not in the cases when international law has been violated only, but to provide remedy and to start the issue of accountability in the situations when human rights are violated. Indeed, draft articles on responsibility and the International Law Commission intentionally excluded the issue of damage. But human rights are violated so frequently, and people do not have any remedy. So therefore, in the purpose of these guiding principles, and we developed a commentary, by the way, all the comments and proposals are welcomed because it's only a draft of the commentary, to help states and people to protect their rights when they just do not have food or do not have something else, or do not have access to equipment, and they feel that their rights are violated. But they know nothing about international law, and by the way, do not care whether international law was violated or not. We need to provide them with remedies and to find a way to show the algorithm how to hold perpetrators responsible. So with all that, I apologize that we are so late, but I believe that the issues we discussed were extremely important. So now we have a lunch break, and I would like to thank all our panelists, both in the person and Innocentii Karandashov online, for the work they are doing, and I'm looking forward to receiving their chapters for the book. I believe it will be a very interesting one. Thank you very much. Just apologize. Our next session starts in 1 hour exactly at 1:40.
Good afternoon, everybody. Welcome back from what was a very brief lunch. As you will notice, I'm not Alina, so I will be chairing this session. Can you hear me? Is that okay? Yes, thank you. Alfred should be sitting down soon. Alfred, please. Alfred, thank you. Okay. Always good to start with a bit of a joke and loosen up the brain cells. It is the last afternoon of what has been a fantastic day and a half, I have to say, and truly enjoyable. So it is my honor and my pleasure to be able to chair this particular panel, which is all about the things I love the most, which is about money and finance and how it all plays out, and taxation and illicit financial flows. And so this is about the financial dimensions of unilateral sanctions or coercive measures, whichever way you look at it. And before I introduce my two speakers, and I have a third one who will be online later, one of the things that I think is so critical in the conversation that we are having, and it is something that has been resonating with many of the people I've been speaking to during the coffee breaks, and that is that there is already a substrata of international law that is not clear for everybody, which is already being dealt with and or undermined or discussed or changed, whether it is a rules-based order or a rules order. But when you come into the spaces of international finance, there hasn't really been an international financial architecture or fiscal architecture. And if there is no real fiscal architecture, then what does that mean in human rights terms? And so there is no access to financial information as a matter of right. So you will hear a lot of human rights conversations about access to information, but when it comes to access of fiscal information, there comes another impediment. But there is, at the level of corporations and individuals, a level of secrecy provisions, patenting of financial structures and systems. And so suddenly you have another area of law that comes into play for us. And then if we add into that what we call a risk appetite, which I've already mentioned from the floor, which is the fear of being shut down or closed down. And so what you have is stakeholders that come from countries that are seen to be less powerful, have this additional layer of risk analysis or assessment. And if you broaden that into the push for regionalism in different parts of the world, then you will see attempts to put in fiscal infrastructure, for example, at the African Union level, is met with a downgrading through credit rating agencies of African-level institutions as a result. And then comes this conversation about a single currency. And there's a lot of politics going on right now about currency, the pushback on currency. There are now predictions online saying that we will not have a single currency dominating the world in 5 years. But I think it may be shorter than that. And does that not add an element of direct fear and concern? Now, not just for the business community or individuals, but actually for everybody even working on a global level, because we actually do all rely on that one currency more than we even realize. And so what is this sort of redefinition of settled terms that then comes into play? And so what we see in fiscal spaces is that English language words, I'll give you an example, the word consensus, now takes on different meanings. You will talk about a consensus, but you will have minority positions. But that if you use an English language narrative in finance or in the language itself, then consensus has only one meaning. Everybody's got to be in agreement. But this is not what we are seeing on the ground. But it is in this sort of trap in human rights of immediate realization of human rights and then progressive realization of human rights that the whole financial conversation becomes so important. Because if you don't have enough money to buy ballot papers or clear ballot boxes, then your civil and political rights are equally challenged. On the other hand, if you're at war and your banking system doesn't work, then again, how are you realizing rights? So humanitarian context becomes so interesting. Sanctions and UCMs now adding on this additional layer. And that takes us into the issue of stolen assets. And the Human Rights Council did ask me to draft guidelines on the repatriation of stolen assets. And the link for that into the humanitarian spaces and on countries going under UCMs and sanctions is often the fact that these take place just before or during conflict. And so suddenly you have this very strong financial line coming through, and it has an effect on the ability of not on that country to recover and continue, but actually it loses physical currency on the ground to even operate. And then you have this movement of countries into barter trade. And the immediate examples that have come to mind over the years include Egypt's loss of money when Hosni Mubarak was being disposed, right? And very recently, if you look at the issues of Palestine, you have constant sweeps into the money-changing agencies on the West Bank, where they actually physically extract currency notes, right? And so these are all these processes that are in play in all of these different parts of the world. But that is my very broad introduction to two fantastic speakers, hopefully followed by another speaker online. And I'm going to start first with Dr. Leila Latif. And it is my pleasure and honor to introduce Leila, who I have to say on a personal note, was the first, in the first class I ever taught at the University of Nairobi almost 20 plus years ago. And it is a pleasure and an honor to be on a panel and to chair it while she speaks. And Leila is going to talk about technological coercion at the new frontier of UCMs. Leila, the floor is yours.
Thank you very much, Professor Waris. It's indeed a pleasure to be seated on the same panel, discussing important topics that are coming to the fore, not just on UCM, but how it also implicates the tax systems, the debt world, and also problems with illicit financial flows and the sort of impact it has on African countries, because that's where we focus on. So it's a pleasure to be here, and I also want to extend my thanks to Professor Alina Dohan for inviting me for this conference together with Professor Waris. There's a lot that I have learned just sitting in this room and listening to the different conversations. So since yesterday, we got to hear about how UCMs are contrary to international law, to international humanitarian law, to the UN Charter, and also the norms and principles that govern peaceful relations between states. I also got to hear about the ripple effect on the provision on public services because of these UCM measures, in particular the healthcare sector, and that came out to be very, very strong yesterday and even today. And we also heard about the secondary restrictions that result by the sanctioning state going forward. And I want to take those three lessons and I want to contextualize that within the semiconductor industry, which is really, really important as we are thinking about digital transformation. So the semiconductor industry, the extreme ultraviolet lithography machines that are required for the manufacture of advanced AI chips, as well as the entire cloud computing digital infrastructure that is important to see how countries are beginning to transform themselves. And I want to now place this in the current situation where we have the US and China trade war. So three things have happened. First is that the US has imposed restrictions on any country that decides to export, re-export, or even transfer advanced chips to advanced AI chips to China. And they've done that through their domestic legal systems by having their export administration regulations, the foreign direct product rule, as well as their entity list, which prohibits export, re-export, and transactions involving not just advanced AI chips, but also the computing software that is required as related infrastructure to support the development of semiconductor industries. Then the second thing that has also happened is that under the risk of adverse trade consequences, the US has also structured a deterrent framework by which it has prohibited the Netherlands, as well as Japan, to also not export part of these advanced chips to China. Now, European countries together with the US are part of the Wassenaar arrangement, which is simply where they decide the kind of export controls and restrictions they're going to place when it comes to dual-use goods and technologies. But when you look at that list, it does not mention the semiconductor manufacturing equipment, and it does not mention the advanced AI chips. Right? So we're already seeing that this is a sort of a unilateral trade restriction. It's an export restriction that is taking place, but it's also having an impact on Africa. and the direct impact is with DRC. So there's already an arrangement, a pressurized arrangement by which the DRC has been drawn into this political pressure by the US not to be able to supply critical minerals to China. So what does that mean going forward for heavy investments of China into our industry, in particularly Kenya, DRC, and other sub-Saharan African regions, whereby we are relying on Chinese infrastructure? Then the second thing is also there is the Clean Network Initiative, which is the US-based Clean Network Initiative. And through that Clean Network Initiative, there's pressure by US companies and the government to African governments as well as Asian governments not to invest in Huawei infrastructure for purposes of developing their digital public infrastructure. So you talk about healthcare systems, you talk about education systems, and also when you talk about the design of data centers that are going to take place on the continent, we cannot use Huawei under the US Clean Network Initiative. So what this means for me as a tax expert trying to understand how UCM is beginning to crop into this space as well, is that I'm beginning to see the weaponization of technology with the threat of exclusion. And I have two direct examples for you. One of them is Ethiopia and the other one is South Africa. So Ethiopia decided to, it decided to open up its telecom market, right? And what it did is that it embedded it on the Huawei infrastructure. And at that particular point, Huawei was listed as one of those entities that are under sanctions under the US Foreign Direct Product Rule. So one may argue and say, this doesn't affect or impact Ethiopia directly, because it's not Ethiopia being mentioned on the entity list, it's Huawei. But the fact that an entire country is relying on the Huawei infrastructure, which is on the sanction list, means that Huawei firm and the producers of that particular infrastructure cannot access advanced chips going forward because DRC cannot supply those critical minerals to China going forward, which then means the Huawei infrastructure is going to be prevented from being upgraded. The network effects are going to be impacted. So the future of Ethiopian telecommunication markets becomes uncertain. How is that going to affect how trade is going to take place within that particular economy as well? So that's something that I'm also trying to think about, and hopefully I can have your comments also help me unpack this going forward. The other example is the one on South Africa. South Africa was considering the use of Huawei for purposes of their 5G rollout. And immediately they made that declaration, the US responded to South Africa telling them that if they use Huawei for the purposes of developing their DPI, which is their digital public infrastructure, then the US would not share intelligence and security cooperation with South Africa going forward, which then meant South Africa decided to let go of Huawei, and then it introduced AWS as part of helping them transform their DPI. AWS is Amazon Web Services. And if you look at scholars like Nick Coldry and Mejias and Sushana Zuboff, all of them have been implicating US tech firms by basically saying majority of these firms exist for purposes of digital surveillance and data colonialism. So what's happening here is that we're getting African countries through the US pressure to now go and rely on US tech companies at the expense of losing our behavioral profiles, our public data to systems that we cannot control going forward. But the bottom line is that these export controls, within the semiconductor industry, it's basically also going to impact the future development capacity of African countries. And Professor, if you allow me a few more minutes, it's just to talk about the digital tax framework that we have. So many countries are digitalizing and their tax systems are being digitalized, right? So say that you're using this digital platform using the Huawei infrastructure. And now Huawei is on the sanctions list. What does this mean for a country like, say, Ethiopia that wants to run its entire tax administration, mobilization, and efficiency through the Huawei enterprise? Because of the sanctions and the fact that Huawei cannot upgrade its system anymore to become more effective, it means the Ethiopian government would not be able to have an efficient, effective tax administration system. it will not be able to collect enough revenue because their system is not being upgraded to be able to check tax compliance going forward. And I think to some extent this is also going to touch on your principles of fiscal legitimacy, which we'll be able to talk about after this panel. So what then happens if you're not collecting enough revenue, you do not have the budget to be able to continue financing education and health going forward. So it's a problem. So in as much as I know we've been having like really good discussions on UCM, I want you to also look at it from the perspective of technological coercion that is taking place through, bilateral arrangements that are ongoing between the US and African countries and the future impact it's going to have going forward. And on the basis of that, as I conclude, I'd also like to speak about something that we're doing at the House of Fiscal Wisdom, where Professor and myself are, trying to lead a project called Project Terra. As you can see it, Project Terra is all about technology, efficiency, and regulatory risk assessment. There are three things we're doing here. We're trying to understand the design of algorithms and how these algorithms are embedding gender bias in how tax policy is being formulated. And we're going to be looking at the design of apps to try and come up with insights and evidence to show how this is basically happening and to counter that. The most important thing that we're doing next is to create a regulatory sandbox. And this is where the idea of UCM becomes really, really critical to our work at Project Terra. When we're trying to understand how data centers are going to operate on the African continent. Now, if a data center's infrastructure is going to be empowered by who are we rather than Amazon Web Services, what kind of impacts are our local investors going to face? And that's one of the things we're going to be studying as part of the regulatory sandbox. And then the final thing we're looking at Project Terra is to map out the fiscal incentives that are provided to technological firms to be able to make the argument, how do we tax the digital products going forward? So I know I've tried to combine a lot of tax with the UCM framework, but here the issue is we're technologically advancing and we're advancing at supersonic speed. But what we need to keep in mind is that even there's a lot of coercion happening within this space, and we need to also flag it up as we discuss the guiding principles going forward. Thank you very much.
Thank you very much, Leila. Truly exciting work, but I also keep thinking that this conversation around weaponization becomes so important because fields that we never thought before were being used as a tool are now being used as a tool. And how do we now look into digital systems to make sure that that weaponization doesn't increase? But without much ado, I move over to the famous or infamous Professor Stephen Dean, a good friend as well. Delighted to have him here. Steve's work went viral with me some years ago when we talked about the 10 truths or the 10 fallacies about tax havens. And one of the things we talked about was racism in the international tax system. And Steve has since then published a very, very good book, well worth reading, on racism and international tax law. And I know he's going to touch a little bit on it. But the groundbreaking work that it has done specifically is that in financial spaces, everybody presumes that it is this neutral, well-organized, self-regulated space, right? This is how people see the financial system. You go into the bank, you sort yourself out, you know? That's how there is this image. But the reality on the ground is very different. And it excludes people of different shapes and sizes and countries, including those under sanctions and UCM. So it's, I'm sure it's going to be also equally exciting. Steve, the floor is yours.
For making this conference happen. It's been really exciting, and to really get a sense of how the work that T and I have done has is really situated in this larger context of UCMs. You know, an acronym I wasn't aware of until yesterday, so that's very exciting for me, if not for the world. Okay, so I'm going to try to start my slides. I think I know what button to push, but I'm not sure. Hope I didn't blow anything out. No, that didn't work. Is it? Oh, yeah. Yes. There we go. Yeah, perfect. Oh, residents. Okay. Thank you so much. I was afraid I would press the wrong button. All right. So the project, the paper that I'm going to contribute to this volume is telling a story.
So it's telling a specific story about the way that specifically race played out in the context of proposed sanctions being proposed by the OECD a while ago. But it's, the afternoon, it's been a long couple of days, so I'll start with a nice picture, which actually maybe isn't so nice, but I'll explain what this is. This picture, I'll show you the context in which this is. So the OECD, about 5 years ago, proposed a global tax reform. And the global tax reform was designed to modernize what it claimed was the 100-year-old system that could not be expected to survive in the rigors of today's rough and tumble world. And they explained with a picture in their brochure what the problem was. And you can see, so this is the image that I showed you. This is just embedded in that lower picture. Many of you have probably heard of the global minimum tax, and this is explaining what the global minimum tax is for. And it's basically showing that the problem that the world is facing is tropical islands, right? This is the reason we can't have nice things, because tropical islands apparently are stacked with US dollars and gold coins. This is, of course, profoundly nonsensical, given that the global minimum tax is focused on corporations, and whatever you think happens in tax havens on the individual side, gangsters hiding money, they certainly do that. Corporations don't hide money. All the executives would be fired immediately if they underreported their profits, so they do not hide income or profits. They can misreport it, but they don't hide it. It's not hidden. It's not a secret. So what the OECD proposed was a global minimum tax, which has been criticized by many, including in a work by the South Center, showing the impact that it would have on the global South, that would favor the global North. Unsurprisingly, the OECD proposed a system that would favor the global North. Who could have guessed that? But the story that underlies this recent proposal that I'm going to talk about today is different. So everybody knows these are the founding countries of the OECD, not covering the entire world, excludes quite a few countries. You can maybe find some of your favorite on that list. But that is the organization that quite recently proposed this really quite radically regressive system. I'm going to show you another map. So the story I'm telling you today really starts in 1960, which is the year two things happened. So one, that was known as the Year of Africa, when much of the continent was decolonized. So these are two maps from the CIA library. The color coding isn't quite right. So the dark gray on the left and the light gray on the right are independent countries. So you can see that 1960 was really a year when a lot changed. Much of the continent changed from other colors to gray. And another thing happened in that same year. In fact, on the same day, December 14th, 1960, it was both the day that the UN issued its proclamation on the Declaration of the Independence of Peoples, and the day that the OECD Charter was signed. I'm not sure who chose the day first, but I do not believe in coincidences to that degree. Really quite entertaining. So the OECD did quite a few things, some of which I discussed in the book that Atia very generously mentioned, described. But one thing it did much later, after it had sort of ensconced itself as sort of the global tax policy shop, was in 2000. So in 2000, and this is the part where maybe folks in the room will start understanding what was happening. So the OECD issued a blacklist, created a blacklist of what it called tax havens. And you can see that this is an article from the New York Times describing it. So the basic idea was that these countries that are listed here were identified as tax havens, and the OECD called for sanctions to be imposed on these countries if they didn't do whatever the OECD wanted. And I just want to highlight two things about that list. I know there's a lot of, it's small type, it's far away, you can't necessarily see it all. But I want to highlight one country that is on the list and one country that is not on the list. So one country that is on the list, and again, this is 2000, Liberia was placed on a list of countries that the OECD proposed be sanctioned for being a tax haven. And this was, of course, during its second civil war, when no European or North American would put anything in Liberia that they ever wanted to see again, right? The idea that a country in the midst of a brutal civil war should be subject to sanctions for being a tax haven. And of course, why was it a tax haven? They looked at its laws and said, well, you guys don't seem to have an operating income tax. You're not sharing information with us, so you must be a tax haven, so we have to impose sanctions on you so that you will develop a sophisticated income tax that just completely nutty, but that was their proposal. And one country that you will not see on this list, can anybody guess what country I'm thinking of that's on this list? Not you guys. You guys know. And I'm offering hints. We're in it. Right, so the country that is not on this list in 2000, incredibly, on a list of tax havens 2000, I'm not making this up, this is truly what happened, was Switzerland. Just incredible that this was the proposal that the OECD issued was that a country like Liberia should be subject to sanctions. And again, I'm not making this up, sanctions on Liberia during a civil war, but not Switzerland, which was clearly and obviously and historically a tax haven. So how did this happen, right? So part of the story that I tell in the book is how the UN had been the place where global tax policy was shaped in the 1950s. This made the UK and the US very unhappy because Global South was becoming more powerful and threatened to shift things in a way that would be favorable to the Global South. US and UK didn't like that, so they shut down the UN's tax operation and ramped up what was then the OEEC, the Organization for European Economic Cooperation's tax operation, and in 1960 upgraded it to a global organization by adding the US and Canada. Because of course, if you add the US and Canada to Europe, you get a global organization. And they basically spent decades creating tax policies that favor global north, again, which are too complicated and boring to go into right now. But if you're really curious, you can read the book. So a big shift in policies that used to favor poor countries to policies that favored rich countries. Of course, it was in the first part of that period, the poor countries were Europe, so it was easier to favor them. When the poor countries became, well, a lot of the countries listed here, it became a little harder to be generous to them. So how did this happen? It's important from my point of view to look at this not in this sort of pure sense that Atia described, but looking at it from a perspective of race. So there was an article in the International Herald Tribune around the same time that talked about the fact that the noose was tightening. I'm not making that up. They quoted an OECD spokesman saying, why give aid to people who are behaving like gangsters, proposed lots of other sanctions on them as well. What happened was that, quite unfortunately for the OECD, they proposed imposing sanctions on the U.S. Virgin Islands. So the U.S. Virgin Islands don't have their, basically a U.S. colony, they don't have voting representatives, but they do have members of Congress. One of them, Congressional Delegate Donna Christensen, whose name I love, was a member of the U.S. Congressional Black Caucus, and she enlisted some of her colleagues to push back against these proposed sanctions, and eventually persuaded then President Bush to withdraw support from these sanctions, which really was quite a moment. The unfortunate part is that, as Stephanie Geringer has noted, that the European Union quite recently has reintroduced the idea of the blacklist and has reproduced some of the outdated and biased patterns of assessment that the OECD had unsuccessfully tried to enforce. Of course, maybe I'm wrong. I do not believe there is an EU Congressional Black Caucus. Maybe that is the problem. Maybe if there were, we wouldn't be doing this. But it's important, and I joke because it is so painful, to understand that what is purported to be neutral and free of bias, in this instance was just spectacularly and awfully biased, and was so biased that it actually persuaded a right-wing organization like the Heritage Foundation to team up with the Congressional Black Caucus to defeat this effort. So I will end there and just say that if you have questions, I'm happy to talk about them. That's the book. But I'm so grateful to be here, grateful to everybody for all that I've learned, and to especially to Atia for making this happen. Thank you.
Thank you very much, Steve. I can't help but forget the fact that there was a conversation within the US where a very famous Treasury official, when discussing amendments to global tax systems, actually said, we need to keep the jungle back. And you know, yesterday, the Chinese representative said, people are taking us into life in the jungle. And I found it so interesting that, you know, this concept of where is the jungle, right, is also debatable because...
And isn't the jungle good now? Isn't it going to save us from global warming?
Yes, and your picture is a picture also of a jungle. So, you know, so the jungle is something really resonating in our tax circles, which is a very strange concept to be able to deal with, like I said, when it was considered always to be neutral. But without much ado, down to the last member of my panel, it's by video, is Professor Dmitry Galushko. Yes. And he's a professor at the International Law Department at the Moscow State Institute of International Relations, and has published widely on issues of not only international law, but international economic law, as well as integration law. So I think it's going to be a very interesting angle into the conversations we're having now. Please.
Good day, Your Excellency, distinguished colleagues, ladies and gentlemen. I'm glad to be here. My report, I would like to start from a very simple observation. Over the last decade, we all have witnessed not just more sanctions, but a qualitative shift in the way states use law to govern the global economy. Financial relations, payment systems, access to technology, all this is no longer only about markets. It is about power, security, and in many cases, survival. In this new reality, unilateral restrictive measures have moved from the periphery to the very center of international economic governance. They are used to discipline, to deter, but also to redesign global flows of capital, goods, and technologies. And this is inevitably raises the question, what does this mean for financial security and for international law as a system? Initially, it's crucial to distinguish between two different phenomena. In a strict legal sense, sanctions are enforcement measures adopted collectively by the United Nations Security Council under the Chapter 7 of the Charter, in response to threats to peace, breaches of the peace, or acts of aggression. They are embedded in an institutional system that, at least in principle, provides collective deliberation, procedural safeguards, and a degree of accountability. By contrast, unilateral restrictive measures are measures introduced by individual states or groups of states on the basis of their domestic law without or beyond authorization by the Security Council. They may include financial restrictions, trade bans, sectoral measures, listing of individuals and entities, and extraterritorial enforcement. In the legislation and practice of many states, we can observe a troubling trend of terminological substitution. Unilateral restrictive measures are routinely and incorrectly labeled as sanctions. This is not a harmless linguistic oversight. It functions as a deliberate legal strategy to legitimize economic coercion outside the framework of international law, undermining its main principles. This terminological shift is not merely symbolic. It carries concrete legal consequences. When states impose unilateral measures and deliberately call them sanctions, they attempt to appropriate the language and legitimacy of the United Nations system. In doing so, they substitute collective, institutionally grounded measures, which are objective by design, with their own subjective assessments of facts and threats. The result in practice is the gradual erosion of the foundational architecture of contemporary international law, where coercive measures must remain the exception, applied only through universal mechanisms, not at the discretion of individual powers. This terminological distinction is therefore not a matter of diplomatic politeness. It is a precondition for any serious legal assessment. If we call every unilateral measure a sanction, we silently legitimize practices that may have no basis in the Charter or in customary law. The widespread, unqualified use of the term sanctions for such measures blur the line between collective enforcement under the Charter and unilateral instruments serving particular foreign policy agendas. It facilitates the false impression that these measures enjoy the same legal pedigree as Security Council sanctions, and in doing so, it contributes to the erosion of the very distinction on which the Charter system rests. Traditionally, financial security was treated mainly as an economic issue about stability of public finances, resilience of banks, control over inflation, etc. Today, this understanding is no longer sufficient. Under conditions of geopolitical tension and growing disintegration, financial security is increasingly defined through law, through the ability of a state to protect the core functions of its financial system from external legal pressure that is exercised by means of unilateral restrictive measures, consequently secondary restrictions, export controls, and over-compliance. In other words, when we speak about financial security in the context of unilateral restrictive measures, we are dealing not with abstract indicators, but with the stability of banking systems, the availability and cost of credits, the function of essential public services, and the everyday economic rights of millions of people. In other words, a law has become a key channel through which financial weakness is created, and at the same time, a key instrument through which states try to restore or construct financial sovereignty. What does it mean in practice? For targeted states, large-scale unilateral measures affect almost every dimension of financial security. They can block access to reserve currencies and international payment system. They can freeze sovereign and quasi-sovereign assets. They can disrupt trade finance and long-term investment programs. They can destabilize the national currencies and undermine public trust in financial institutions. But the impact does not stop there. Third states, banks, and companies that are not themselves targets are still forced to navigate the risk of secondary restrictions and reputational damage. The result is overcompliance, a tendency to refuse any transaction that might even hypothetically be connected with a sanctioned person, sector, or jurisdiction. In humanitarian terms, this leads to exactly the problems that are discussed at this conference: blocked payments, delayed deliveries, collapsing supply chains, even when formal exceptions exist on a paper. In systemic terms, it leads to the fragmentation of global financial markets and to a crisis of trust in the predictability of international economic and financial law. Let me now turn to how major powers use unilateral restrictive measures not only to respond to perceived threats, but also to reshape the international financial landscape in ways that weaken the financial security of others and at the same time strengthen their own. In this regard, the United States occupies a unique position in the global financial system. The dollar remains the dominant reserve currency. Key payment and clearing infrastructures operate under the United States or allied jurisdiction. The National Security Strategy of 2025 explicitly frames economic and technological leadership as pillars of national security. Within this framework, unilateral restrictive measures, export controls, and financial surveillance are treated as legitimate tools to counter threats, but also as instruments of economic governance. Financial American sanctions, they combine broad framework of statutes allowing the executive branch to expand or adjust measures rapidly. A distinctive feature is the extraterritorial application of these measures and the use of secondary restrictions against third country actors. Banks and companies outside the United States face the risk of penalties, a loss of access to United States markets, or reputational damage if they engage with listed persons, sectors, or jurisdictions. In practice, this means that unilateral measures can undermine the financial security of targeted and third states alike, while simultaneously reinforcing the centrality of the United States-centered financial infrastructures. The United Kingdom's approach, especially after Brexit, is often summarized by the formula economic security is national security. London has gained more autonomy in designing national restrictive regimes while remaining closely coordinated with the G7 partners. The National Security Strategy of 2025, called Security for the British People in a Dangerous World, directly states that sanctions enforcement are going to become increasingly important. Consequently, the United Kingdom's financial sanctions regime under their national security undermines core principles of British justice through three systemic flaws: an absence of due process and a rule of law failings, low evidentiary threshold, and lack of transparency. They argue that sanctions can be imposed on a reasonable suspicion standard, far below criminal evidentiary thresholds, without adequate judicial oversight or transparency, as decisions rest largely with ministers and rely on undisclosed intelligence. Moreover, the limited right to appeal requiring individuals to challenge designations before the same authority that imposed them compound the due process deficiencies and raises serious rule of law concerns in the United Kingdom's national security framework. This approach employs financial restrictions to safeguard the integrity of the United Kingdom's economic system, while exerting leverage over external actors, linking their access to British markets and financial infrastructure to adherence with the policy objectives shared by the United Kingdom and its allies. The European Union's model of financial security reflects its supranational nature and the logic of the single market. In recent years, the Union has advanced the concept of strategic autonomy, treating financial security as a precondition for protecting its internal market and the euro, and for aligning its financial capacities with its foreign policy objectives. Restrictive measures are adopted collectively at the EU level, but implemented through national legal systems. In parallel, the European Union is developing defensive instruments. For example, a regulation on protection against economic coercion by third countries, a modernized blocking statute shielding EU operators from extraterritorial measures, and etc. This model pursues three core objectives: promoting competitiveness, mitigating external risk, and reinforcing partnerships with like-minded states, while using restrictive measures to influence third state behavior and to protect euro-oriented financial infrastructure and the Union's fiscal and technological interests. Over time, the European Union has also strengthened its enforcement architecture, including through directive on minimum criminal penalties for sanctions violations and through more robust national implementation frameworks, building on its control of key financial nodes such as SWIFT and Euroclear in Belgium. Yeah.
Just take a minute to just wind up, please.
Yeah. I'm finishing. Thank you. And what does this mean for international law? The first is conceptual and normative. We need clearer criteria to distinguish lawful countermeasures and legitimate regulatory acts from unlawful economic coercion. Without this, the line between domestic jurisdiction and the prohibited threat or use of force by other means will remain blurred. And states will continue to rely on unilateral measures in ways that erode the authority of multilateral institutions. The second is institutional. We require effective mechanisms of responsibility, remedy, and redress for the negative human rights and financial impacts of unilateral restrictive measures, including those arising from overcompliance by private actors. This is directly linked to access to justice, due process for listed persons and entities, and the possibility of lifting measures that are no longer justified or that have disproportionate humanitarian effects. The third is systemic. Financial security has become, as it Just 1 minute, and I'm finishing. Sorry. A lot of thoughts to share with my colleagues. Has become an essential dimension of international peace and security. Debates about sanctions, humanitarian carve-outs, asset freezes, debt, and digital currency are not merely technical. Dear colleagues, unilateral restrictive measures will not disappear in the foreseeable future. On the contrary, they are likely to remain one of the main instruments of economic governance, unfortunately becoming the new normality. The question is whether we can civilize this practice. And in this context, the present conference itself and the guiding principles that are being discussed are of particular importance. Thank you very much for your attention.
Thank you, Dimitri. I'm going to eat into your question time. So I hope you will not mind, but it's a pleasure. One of the things that occurs to me when you have, with the input that you've put onto the table for us, is the issue about the centrality of money. And that when we're looking at tax and illicit financial flows and debt transactions, but also when we're looking at currency transactions in that whole process, the coercion comes because we've given power over money to a specific space. And so then how do we then, disengage from those spaces? But the other thing that your conversation has triggered for me as I wait for people to ask for the floor, of course, is so often in fiscal spaces we deal with regulations or guidelines or models, but you will never hear us talk about laws or regulations that are binding. And yet at the same time, the fiscal space is so fraught with spaces where we are implementing without very little thinking around whether or not we should be doing it, or there is, again, the fear factor that starts to pop up. So the floor is now open for questions and comments. If you have a flag, if not, feel free to raise your hand. Okay, thank you. So before we go there, we'll just go online to the first intervention, who is Augustin Mulikuza on behalf of the Democratic Republic of the Congo. Augustin, the floor is yours.
Hello, I'm sorry yes, I'm Augustin, I'm in DRC, in Bukavu. But I speak small English. Can you please my intervention in French?
Unfortunately, we don't have a translation right now. Are you able to give us your comment briefly, and then we can try and summarize? Or can he text it? Can he write it in the chat box? Augustin, are you able to write it into the chat box, and then somebody will quickly try and translate? And we'll come back to you?
Box?
Ah bon. Augustin, est-ce que c'est possible de faire la traduction, mettre ça en ligne dans le chat, et on va trouver quelqu'un ici pour faire la traduction pour vous, après?
Tout à fait.
Ok, merci beaucoup.
Je vais le mettre dans le chat.
Super, merci beaucoup, Augustin. The floor is yours, madame.
Thank you, Dr. Waris. So, thank you for giving me the floor again. I wanted to do some comments regarding your book, Financing Africa. Sorry, my apologies for being late because we were supporting the delegation of Cuba in the side event. However, I had the opportunity to read your book, and I have to confess that I found it difficult, all the technicalities of the topic, because I'm not expert in tax law, and how to find the link between the fiscal dimension and the unilateral coercive measures. But finally, thanks to your book, I could clarify many points in how targeting revenue sources and also the fiscal institution can be economic coercion. That's why I consider the book, it's very important and highly recommended for those involved in the topic of UCM. Also, I consider that an effective analysis of remedies and responsibility must therefore address how states can develop fiscal response that maintains sovereignty and help build resilience against economic coercion. I know in your book you mentioned there is not perfect fiscal system because every tax system has many dimensions, including volume, composition, rates, coverage, timing of collection, modes of collection, and it's nearly impossible to choose theoretically the best system. However, I would like to ask you, and my apologies if you already mentioned during your presentation, which do you consider are the main elements, based in your experience in Africa and around the world, that a fiscal system in a state should consider to have? Thank you very much.
Anybody else would like the floor? South Center, please.
Thank you, Chair, for giving us the floor. Thank you to all the panelists for the very insightful and interesting presentations, and especially to Professor Dean for the shout-out to our work on International Tax Cooperation. We really appreciate it. I want to highlight one other research that we have been doing at the South Center, which is regarding the impact of unilateral coercive measures on a very important source of financing for development, and that is remittances. And remittances happen to be one of the lifelines for financing in Global South countries. There are some countries, developing countries and least developed countries, where 30 to 40% of their GDP depends on remittances coming from outside, right? And many of these remittances come from workers who are working in countries that are targeted by these UCMs. When these UCMs happen, they are meant to target the economic system of a country. And the justification that is given is that it is only meant to address that particular country. But then when you see the impact on remittances, there are clear extraterritorial impacts on people and families and the vulnerable people in other countries, which are frequently the poorest and the most vulnerable countries. For example, Nepal. If there are workers from Nepal who are working in a country that is targeted, the families that are left behind, they are unable to get the money that is required. There is also a humanitarian and emergency context impact here, because unlike humanitarian assistance and development aid, which is already declining, we have seen that remittances actually go up during times of crisis and during times of natural disasters. When UCMs are applied, there are no exceptions for these sort of financial flows to come in. So one of the most strongest lifelines for financing in developing countries is usually ended up being blocked by these UCMs. And there are no exemptions and there are no mechanisms in place. So that is what I wanted to highlight. Like, even though there is this entire mechanism for financing development, UCMs are actually a very significant barrier to them, and there are no mechanisms in place. So even when you have targeted exemptions, these are simply not viable. And I will stop there. Thank you very much.
Thank you. About remittances, something I've just said in the side of it also is that if remittances become sort of the go-to way of, I mean, if the receiving country was under, you know, under sanctions, and we would think of remittances as a way to deal with it, this kind of puts us in a situation where this may become the go-to way of dealing with the situation. And when this happens, it may be argued that that is now established practice, and therefore sort of the nations don't really have a reason to have authority or autonomy or some financial flow claims that they could make. This would further undermine the nations. Thank you.
Thank you very much.
Thank you very much. Sharof Aziz of Justice for All International. I have a very quick question regarding these legally binding instruments which are currently being developed. I mean, the process goes, in fact, in parallel with this event. So my question is basically how your mandate and the mandate of the unilateral coercive measures are being engaged and to provide some input to avoid this negative impact on the entrepreneurs when it comes to the proliferation of all kind of legally binding instruments regulating business, and especially when it comes to small and medium-sized entrepreneurs. Thank you.
To ask each of the speakers to do is to please take about 5 minutes to comment on the diverse questions they've received, but also to give us a parting shot. And I want to add 2 questions, one for the two of you, of course. The first is there's the World Internet Council. And I remember in 2009 that there was a massive debate between France and the United States over control of the World Internet Council and how to access the servers. And when there was a deadlock in the negotiations on access to the servers, which were housed only in the United States, that is when France implemented its first unilateral taxation on digital goods. And we've come a long way from then, but it would be interesting if, as you answer the question, you can reflect on all of those changes and this very clear connection between digital systems and what is happening in digital systems, and how tax is almost the reason for why so many of these challenges are happening. So tax doesn't seem to be the symptom of the problem, but actually the driving force sometimes behind the scenes. And Steve, you know, there's the Bank of International Settlements, of course, there's the OECD, there's FATF. And when we talk about racialization, I mean, just the physical location of where all of these entities are, who peoples them, who are the researchers in those spaces. I mean, are we saying that has an element of racialized or discriminated elements in it? Is there something we can bite into in those wider spaces outside tax? And, you know, that jungle conversation, you know, continues to resonate in my mind. And then for Dimitri, it's really what is also that center focus of currencies and financing tools, and how do you see currencies playing a part in either helping or hindering international economic law issues that you discussed with us? So I'm going to start in the same order again, Leila, and then over to Steve, and then Dimitri.
These remittances I can't answer. Okay. All right. Thank you so much. So it's an important question, Professor, that you've asked me. The World Internet Council and how it led to access to servers, and then France coming in to introduce its unilateral measure. So I'm going to speak from the perspective of global taxation, because that's where our expertise lies, to be able to now relate it to UCM going forward. So when you look at, so basically all public services are being digitalized. Right? We're all accessing, we want to apply for your passport, you want to do a transfer pricing assessment, you want to monitor the problem of tax evasion at the borders. All that is happening, you know, through apps, through softwares on our phones and our laptops. But when you look at the infrastructure, the back-end technology, none of it is African, it's all foreign, basically either, if it's not Chinese, it's Dutch. If it's not Dutch, it's largely the US. And then when we try to think about the tax element of these particular models, there are no rules that exist at the moment. And that's why in August, we'll be going back to the UN in New York to be able to now negotiate what is the position on taxing these digital business models and having a framework for global taxation of technology going forward. But in the event that this happens, what has been happening at the local domestic level is that countries have been implementing unilateral measures. Now, they're not coercive, they're just unilateral measures for purposes of taxing digital business models that are operating locally in our countries. So you have the platform, and then you have users who use that platform. The users generate revenue for the platform operators that sit in New York or Washington or in Ireland. They're generating the profits. Those profits are not being taxed anywhere in the world. So countries have decided to come up with unilateral measures. And then what we saw is that the US coming in to impose tariffs on all those countries that have now come up with unilateral measures to tax digital business models at the local level. So that's the form of reaction that we are seeing in the tax world. And similarly, just like unilateral coercive measures happen, the US is seeing the taxation of digital business models at the domestic level as a coercive measures that then prompts them to introduce the tariffs going forward. So this is a discussion, Professor, that's still open, and we're going to see if we can make some progress in August, and then by 2027, if there will be some sort of a treaty framework on how to regulate this space so that unilateralism is done away with. And then just like Professor Dimitri was speaking about the fact that multilateralism is being eroded. But we cannot have that happen in the tax world, because then it creates so much of complications as to who gets to tax which digital business model and how do we apportion the revenue going forward. So I'll probably just leave it at that, Professor. And I think my parting shot would simply be, we've introduced Project Terra. It has been funded by Illuminate, and we'll be happy to hear you give feedback on it, or to just work with us as partners and stakeholders to see how the regulatory sandbox plays out, and if that could potentially lead to what Professor Strauss was speaking about this morning on methodologies for monitoring. Let's see if we can get the regulatory sandbox to also help us monitor how UCM affects the establishment and running of data centers on the continent going forward, and by the continent, the African continent. Thank you.
Right. Thank you very much. I just want to check if we got the question from the Congo. All right. Thank you. Steve, the floor is yours.
Thank you. Excuse me. Thank you. I think, I wanted to start with by addressing the jungle. The jungle. So the actual what you're recalling was somebody who had been a negotiator in the global minimum tax precursor from the Biden administration, was a few years after this in a closed room session that I happened to be part of, explained that what they were pushing for was to keep the jungle from growing back. And I really couldn't quite understand, that's not true, I did understand, but I couldn't quite believe that he would say this in a, even a private space. But just to understand what has been happening in tax and the ways in which race has been weaponized to disenfranchise a big chunk of the globe, and the impact that disenfranchisement has on, many even beyond those disenfranchised countries. So the story I tell in the book is about why we can't tax multinationals, which of course leads us to what we're just hearing about. The system that the OECD created was a system that effectively sabotaged the corporate income tax around the world. And they essentially decided that if these newly independent countries were going to tax their multinationals, they would rather nobody be able to tax multinationals than to share that power with the world. It's really, I think, a cautionary tale about what happens when you sort of center power in one region or one country. It's not just bad for those who don't have the vote, although it is bad for them. It can also be bad for even those that are relatively powerless in the relatively powerful places. It's a way of allocating power that can be really, really harmful. I think that it's just, and taking a step back from the details of what we're talking about, it's important to understand that the ability to tax is incredibly important. If you don't have the ability to tax, you don't have the ability to fund schools, hospitals, all those needs that help drive the push to independence in much of the world. If you have the right to build schools and hospitals, thanks to independence, but your ability to fund those things is taken away by the back door, that is going to really weaken these institutions and sort of remove sovereignty indirectly, even though it's been achieved in a direct and formal sense. I just think that it's I think everybody in the room would agree that tax is not their, except for us, not their favorite thing to think about. But I just want to encourage you to understand how powerful and important it is, and the ways in which unilateral coercive measures have really shifted the power to tax away from those who need that power the most, and leave them, unfortunately, vulnerable, ironically, to unilateral coercive measures. Right? You're vulnerable because you don't have the resources, and you can be threatened more easily with the loss of further resources because you don't have resources. It's all kind of a mess. But just don't forget about tax. That's all. That's my parting shot.
Thank you, Steve. Yes, the three tax nerds in the room are resonating right now. I'm just going to read out the translation of the comment from the gentleman from the DRC, Augustin Molekuza, before I go over to Dimitri, which is that I congratulate the intervention on the lady who spoke on friction, and in particular on the DRC, I believe that is Leila. The impact of the unilateral sanction greatly affects humanitarian actions, and monitoring mechanisms must be defined by those responsible in order to find lasting peace in the east of the DRC. Humanitarian actors face obstacles in intervening. Those responsible for crimes are on the lookout and act freely in already fragile areas. The number of deaths increases day by day, and no humanitarian assistance reaches the injured or disabled anymore. The financial capacity of national and international organizations is becoming less available. I propose a swift intervention by those responsible to monitor the actions in collaboration with members of the government and local non-profit organizations. Thank you. Thank you, Augustin. We really appreciate your intervention. Dimitri, if you're still with us, you have just 2 minutes to please give us any answers and, of course, your parting shots.
Yeah, thank you for your question and your comments, dear colleagues. Regarding currencies nowadays in the modern financial infrastructure, it's becoming really, really crucial. And from one side, from those superpowers that I have mentioned in my report, they are becoming a tool for coercion. And from other side, national currencies, they're becoming for targeted countries, they're becoming one of the main tools of insurance of their sovereignty and defense from those coercive unilateral restrictive measures. And in this regard, for sure, we can see some dangers for universalism, as I have mentioned in my report. Yeah, because from one side, those unilateral restrictive measures themselves, they possess this danger. Because all those issues of disintegration, fragmentation, they enter these processes, a very dangerous process to the system of international law. From other side, in terms of defense from those and remedies, effective remedies from those unilateral restrictive measures, national currencies, they become crucial. For the defense of national interests of targeted countries. I mean, not those rumors and discussions about the single currencies. Nowadays, in this modern contemporary tensions between the states, it's almost impossible. But those mechanisms, in particular within BRICS, we see mechanisms of payments in national currencies. And now we see a lot of international agreements between the countries regarding payments in national currencies. In terms of restrictions regarding access to international reserve currencies like dollars, euros, pounds of those states that I have mentioned in my report. And for sure, this is about what? This is about, from one side, as I have said, about coercion. From other side, it's about defense. But in taking this in totality, we should speak about potential risk of disintegration, international disintegration, and fragmentation of that universal legal order that is under the United Nations system. Thank you.
Thank you very much, Dimitri. So the questions that also came to me were very interesting, and thank you very much. I mean, we're going into the book launch in a little bit, and so I will, of course, talk a little bit more about it. But I will tell you that I don't think the answer is a blueprint. I don't think the answer is just to have one approach. I think it is really about principles and then layering improvement upon principles as you go forward. Different countries are different. In the African continent, for example, some will have a constitutional protection. Others will go as far as to have principles within their constitutions on justice or fairness. And so one of the things I think is to take what I call the principles of fiscal legitimacy, which of course Leila mentioned as well, which is accountability and transparency and responsibility, effectiveness and efficiency, and then of course fairness and justice. And these 7 principles, if we build on them, is really putting those markers in place to take it forward. But I always tell people that we can't compromise on the fairness and justice. So there's almost like a basket, right? Every time you look at an efficient system, it's also got to be fair and just. You want to look at a responsible system, it must also be fair and just. And I think that that fairness and justice is the lens of that particular country or community. For me, that is what it's about. It's about the human beings on the ground. And so that would be what I would say. We had the questions on remittances, both very important and coming in from very different angles. People on the ground on the one hand and entrepreneurs on the other. I've been part of the working group that helped draft these regulations that we are discussing, of course, under the very able leadership of Alina. And I will tell you that we had intense conversations and debates about all of these issues, and we believe you can inculcate many of your conversations into it. But I would like to add in the layer of the fact that about a year ago, I sent a letter on the implications of remittances and the issues around debt, tax, and illicit financial flows on remittances to the UN General Assembly for them to actually find ways to sort of ring fence and protect remittances. And my argument there was that remittances below a certain amount, for example, should not attract taxes and certainly should not attract bank charges. And because very often there are so many of these embedded that by the time the amount of money reaches the ground, it sometimes is halved. And the issue around the legality of remittances also becomes very important. Many years ago, I did research on Somaliland. And actually, there is a famous court case that went all the way up to the House of Lords for their money exchange company. It's called Dahabshil. And the reason it's very interesting is because the House of Lords ruled that the financial system that this company was using, which is what we call hawala, which is what works in humanitarian spaces, right? It's what works in countries that are under sanctions and UCMs, because somewhere along the way, the world decided there was only one financial system that is legitimate, which meant that everybody else's financial systems are seen to be illegitimate if you cannot track and trace it within the other system. And I would really recommend reading that court case because it talked about how remittances are being moved across the world, and they were being shut down for anti-money laundering. But then the House of Lords ruled that there was actually not a problem, and the money was actually legitimate remittances. And I think that that's really important. And this had a direct effect on entrepreneurs as well, because it was entrepreneurs who were now receiving money back and forth in the middle of these allegations, for example, of piracy and piracy money and terrorism financing that were rolled up all into that. And with that, I have no parting shot because I continue into the next session. But I want to thank you very much for your very active engagement, both online and here. And I look forward to continuing with you as we go forward. Thank you very much, and a round of applause for my lovely panel.
Okay. Good afternoon to all of you. Thank you very much for staying with us. My name is Jose Francisco Calitzay. I am the permanent representative and the ambassador of Guatemala to the UN in Geneva. And I've been asking And I don't know why I accepted to moderate the launching of this wonderful book, Financing Africa, that you are seeing there. So, first of all, because I don't know anything about financing, I don't know anything about taxes, and really I know a little bit about Africa. Of course, generally, you know what is happening in Africa, but deeply, we cannot say that we know Africa. And Atia, when she asked me to be the moderator, I accepted because I know her. I don't know, I'm not going to say how many years. I'm just going to say that I know her in two, we can say, fields. In academic, I think that she is a wonderful academic. And of course, as an expert, independent expert, in a human rights defender, as well, one of the best human rights defenders that I have met in the system of United Nations. And of course, I think that yesterday I was telling her, with this book, when I started to read it, I said, oh my God, I am not going to understand anything. But the way that she wrote it, oh my goodness, is something that you will love it to read. The way that she wrote it is something that you are going to read. It's like you are going to read poems. It's a poetical way of writing the reality of Africa. And of course, it brings us hope and bringing us reality, but it's also bringing us challenges. So thank you very much, Atia, for asking me to be here. And of course, I'm not coming here to make comments on the book. I'm just coming here to moderate the presentation and the launching of the book. You know, I think that you already know Atia. I don't need to introduce her. And of course, we have with us Dr. Laila Latif, that also you have already know her. She has been introduced her already. So I will not do that work in this moment. So I'm just going to ask, I don't know if Atia, you will be launching this first, or we are going to receive some comments from Dr. Latif. And if that is the case, Dr. Latif, please take the floor in this moment. And thank you very much again, Atia, for this opportunity.
So thank you very much. I think I'm having the most difficult task here to engage the author, who's a professor and who's been my teacher and who's a very good example for women on the continent and globally when it comes to tax issues and human rights concerns. So it's really a privilege to do this, honestly, and emotional as well. But I suppose I'm just going to start off by asking questions to the author. I know this is outside the context of UCM, so we're getting into tax, like we said, the topic that we love the most, but I think you will be able to now link it to the broader conversations around UCM. So, I mean, I think the first question I probably want to ask you, Atia, and it's a question that bugs me, and I think it should bug all of us, is that the fiscal systems that we are in today, especially on the African continent and in the global South economy, who are they really built for? That's like the pressing question I want you to start answering before we get into the depths of the book, please. Yeah.
Shall I?
Yeah.
Okay. So I always think it puts people into a very interesting power position when the student is now handling her teacher. Whereas before the teacher was handling the students. So I think this is going to be a lot of fun. And Francisco, thank you so much, really. It's such a pleasure. I have to tell you that first, when I wrote this book, it was initially rejected as an academic book because of my use of proverbs and poetry. But I wrote the book for my continent. And in my continent, it's all about oral tradition and literature. And so there was such difficulty finding data. It took me 15 years to write this particular book. And as I started to see how difficult it was, I also started to resonate with my people and my continent, because when we don't have real examples, we resort to allegories and we tell stories around it. And so you often hear me use proverbs, because that's what works when we don't have data to sort of back it up, as it were. And I do write poetry as well, so I thoroughly enjoyed throwing in some poetic references into it. I throw a challenge to professors of literature to use my book in their classes. It hasn't worked so far, but who knows, it might work. We might get tax across to the people working on English literature one day. But if I talk about Leila's first question, I'm looking forward to the others as well. They say that 90% or 80% of many African countries are informal economies. But what does that mean when we are talking about a tax or a fiscal system? It means that 80 or 90% are not on the system and not engaging with the legislation that we are talking about. So you want to talk about tax law, and when you have a look at the book, you will see that less than 1% of people in Senegal are registered for direct tax, and 0.3% of Malawians are registered as direct taxpayers. So then where are these 90% of people over the age of 18? And when you're doing that maths, and for me this has been what really resonates for me with Alina's work on UCMs, is that many people use UCMs and sanctions are actually not using legitimate systems very often. And if we talk about the fact that these African countries have 80 to 90% of their economies not logged and registered on the system, it means we're, of course, economically, we're much bigger giants than we look like, of course. But at the same time, it means we are bypassing systems, right? By force, not by force. Of course, that is debatable. But then why are we bypassing them? And what does it mean that we are bypassing these systems? And so it means that this 80% of the population that is looking at the laws and the constitution and legislation is actually now not being forced, like through UCMs and sanctions, to not use the system, but are actually choosing to not use the system. And so does that mean that that choice is because the system is oppressive or is not reliable, or we don't like it, or we don't understand it? And so that's also what triggered the writing of the book, because when I was writing the book, every time I would be in the international spaces, people would tell me, oh, it is, and this direct quote, this is the dark continent. Of course we don't understand. There is no material on this. And so what was starting to happen as I continued to move in these international global spaces is I would be sitting in a room burning while somebody's talking about my country, and it has no correlation to what my country actually looks like. And when you would go into the IMF and renegotiate loans and tell them that their assessments were incorrect, for example, they would tell you, but where is the book? Where is the publication, and where is the data? And so this was it was a struggle, but this is the sort of UCM, I guess, connection to how I got there. Thank you.
Excellent. So I think you can also start thinking about questions you want to pose to her if you've already read her book or are intending to read the book. So you may have heard her mention something like a legitimate system. And I want to question you on that. What's a legitimate system, and what makes a system legitimate? I know you've drawn out principles on fiscal legitimacy, about 7 of them. And there's one particularly interesting one, justice. And you link that to Ibn Khaldun's work, who's one of the African scholars who existed way before Adam Smith, who talked about the canons of taxation. So we already had people discussing this in your decolonial work that you're also doing. So what's the legitimate system, and how does the principle of fiscal legitimacy that is embedded on justice, right? What does it mean? And in my view, I think that is really missing from legislation, from the international order, from what you talked about earlier, the models, the regulations, and the rules. So why is justice missing from this legitimate system? And if it's missing, are our systems really legitimate?
When I went into my first year of law school, one of the first classes I went into was a class that said, law is not just, law is nonsense on stilts. If you come from a Commonwealth tradition, this is your first class of law that you literally go for. So if law is not just and law is nonsense on stilts, then where does that conversation come from? And those were British scholars that helped set up our system. And then when I tied that with the fact that when the colonial masters, in that case the British, landed on the East African coast, the first thing they did, and this is a fact, right? They actually put up a big notice board, right? A physical notice board. They put it like bang into the ground on the beach. And they said that traditional laws are, these are the words, repugnant to justice and morality. So that stayed in place, and in many African countries was only reversed sometimes even in the 80s and the 90s. So what you have is an entire population of human beings who have basically been told that everything their grandparents are doing, everything their parents are doing, probably what includes my upbringing, right, is inherently against justice and morality. And so when I came to look at these fiscal systems like taxation, then how did they introduce taxation into the African continent? So there was already a traditional tax system. And the traditional tax system was your chief would get some of the harvest. They're doing the administrative role that they're doing. You would have the young people being part of a warrior clan, for example, so they are giving you your state security, right? But this is based on need. So traditional African systems, some of which have had incredible civilizations, Great Zimbabwe, West African ones, of course, we cannot forget Egypt and the rest of North Africa. When you will look at these, you will already see active systems. But for some reason, the conversation was given like a full stop and a cut. And then suddenly you have this, we are now introducing taxation to you because your system is repugnant to justice and morality. So you're undermining everything that's existing, all the civilizations that were there, and then you're bringing in this new idea. And then you're already saying the new idea is unjust. So you're even turning around and saying, well, if you don't pay your it used to be 2 rupees hut tax, for example, or 2 shilling hut tax, or head tax, or a poll tax, as it were at that time. If you're not paying it, you were taken to give compulsory labor to build the road system, right? And you were taken away always just before harvesting season or planting season. So, you're not just destroying the way people think or function, you're also destroying their livelihoods so that you force them into this capitalistic system. And as we continued, then they started to set up bigger and bigger plots of land, confiscation of land from individuals, traditional land was taken away. And then I've never forgotten this. They only removed it off the books a while ago, which was, that coffee was not indigenous to, for example, East Africa. Ethiopia had it, but Kenya certainly didn't. But you could be jailed for 20 years if you cut down a coffee bush. And these laws stayed even after independence. And the reason I talk about coffee is because who hasn't had a cup of coffee today? Or has not looked at a cup of coffee today? But if you're Kenyan and you're a little bit older, then I have that history, that people were starving, but that was the law, right? And then you're adding in this balance of payments thing, because it was done so that we could have global trade, so that we could have dollars, another conversation we've been having, because how else will we then buy other stuff? But at the same time, we're being told you can't cut down the coffee bush, even if you're starving. I mean, for me, these are the sort of the juxtapositions of justice that I continue to grapple with as well. Thank you, Leila.
So there's a lot of history that we're learning today about coffee as well. And unfortunately, we still have Chapter 2 of the Laws of Kenya, which is our Judicature Act, that still has that provision about repugnance to justice and morality. So all laws that are not, So we still maintain that colonial mentality, unfortunately, which then takes me to the question of colonization. And you touch about colonization in your book. And you also mentioned that the definition of tax has colonial has a colonial imprint, right? And that's the system of taxation that we have is also modeled on the colonial legislature that we had generally for most of the sub-Saharan African countries going forward. So if the design of our fiscal system has a colonial nature, how do we argue and say that that sort of a system continues to produce fiscal legitimacy for us on the continent? And how do you think that is shaping out at the global field as well?
So thank you very much for that. So the arguments that we always make from human rights is that when you look at a country's legislative system and its human rights system, then we have to have this really wonderful balanced space. But when you take the same conversation into the international spaces, then my question is, are we doing one adult, one vote? And no, we're not. Okay, are we doing one country equal vote with another country? And no, we're not. Because the power play that now comes into it reshifts everything. And if I go into the conversations around taxation, and I alluded to it earlier, the word consensus. When you come from a continent where the languages internationally are not our indigenous languages, it is already this additional layered struggle that we're working at. It's not Shona, and it's not Kinyarwanda. We have to deal in English and French and Spanish, and it's not Swahili. And so what I started to notice was there's almost, and I want to say it is not deliberate, I hope it isn't, that there is a misuse of the words that have been taught to us as people that were colonized by different spaces. And the word that always comes to mind is consensus. When there was the multilateral tax treaty being debated at the OECD, the agreement was, when I was part of the subcommittee, was that the agreement had to be by consensus. And then fast forward 15 years later, they come to a conclusion, and one of the countries, and I'm very proud to say Kenya, my country, rejected that particular multilateral instrument. But then they said it's been passed by consensus. And in my very informal spaces, I said, so what are we Kenyans, chopped liver? Clearly, we didn't count in that whole conversation, and we weren't the only country. There were 5 or 6 others. Sri Lanka was there as well. And so this was across multiple continents that there was a rejection. Yet the narrative and the language that came out of the OECD was that it was by consensus. And so if that's what we are talking about, then let's look at the breakdown of the debates and the discussions and how that worked. And even in the breakdown of the debates and the discussions, what you started to see was the countries that had previously colonized certain states were the ones engaging with those same very states at the international level. Of course, because the language barrier is there, right? The English speaking hanging out with the English and the French speaking with the French. And so consensus was trying to be pulled together on that basis and in those spaces. But then if I come back into, so what is this African fiscal system that I'm trying to map out, then suddenly you realize, and I thought that this was so valuable, that as long as you had a debt agreement with the IMF, you couldn't write your own tax policy. And so, I don't know if you've seen national budgets, but the joke about national budgets is that's what members of parliament used to hold open their doors because they're so big and they don't know what else to do with them. But these budgets, if you're in any country in the world, will have a 3 or 4 page summary right at the top, just saying, and here's what our national tax policy is for the next, X year. But if you have a loan from the IMF, you've basically handed over that sovereignty or independence because the only entity allowed to write your tax policy is actually the IMF. And then that's when you start to see demonstrations around the world happening with people not understanding why their countries are making decisions or rolling out policies like increasing of value-added taxes on food, when they know very well that people are starving, right? So that's, your human rights sort of angle starts to come in there as well. And so there's so much, packed into that. And I couldn't see a way through from a national level system across into the regional spaces and then across into the global spaces that would even allow me to say, okay, I can see coherence in the way people are talking and seeing their spaces. And I can see that for example, as a Kenyan, that what my country is deciding is clearly visible and implementable at these other levels. Yeah.
So I hope you have your questions ready for the chair to start taking them, because I think the explanation that you've given, it's making sense to me to understand why African countries and even other global southern nations continue to expand the bracket of indirect taxation, because that's the only way in which we can raise revenue. I mean, there's a chapter in your book, and it's really nicely titled, where you speak about the makers, implementers, and interpreters of fiscal system. I really like how it's coined. So could you just tell us about who these three entities and individuals are, and how did you coin that phrase, and what does it mean?
So thank you, Leila. When this, the question you asked earlier is like, who's really in control and who's doing it? And so I'm a human being. And I'm going to look at a law, whether it's a law at a global level or one at a regional level or national level. And then I'm going to say, oh my God, okay, so this is the rule. But then I'm going to ask myself, but who made this rule? And why did they make it? And what was the purpose? Is it still relevant? Has anyone tried to change it or fix it? Did they succeed or not, and why not? And the reason I say that is it also comes from my very human rights approach to the work that I do, which is that we can talk about the creation of states and the existence of states, but we also know countries are fighting for self-determination, right? So the state is an entity, but the human beings that are inside the state is a different entity. The human beings inside an international organization is a different entity. We've been talking about arbitration earlier. So the people making those decisions, those are human beings. And I remember, again, common law is always very interesting, that if the dog bit the leg of the judge, there's actually a case like that. And they made a different decision than if the dog had not bitten their leg. For all the dog lovers, I apologize. Then, is that not a change in justice and law and all the rest? And let's go back to who's the maker of the law? Was it the dog that bit the judge, or is it the judge? Because of the level of influence, right? I'm giving you a very silly example, but for that very reason. So who is the person? And why have they made those rules? And so for me, who's the maker of the law? So if I look at a constitution, the structure of a constitution and of a written constitution is a build-up at a global level. But if you go down into ethnic and traditional communities in Africa, then there wasn't a written constitution, but there was like a culture and tradition of how we lived our lives, right? So that's very different, right? And that is still in place. So there are still makers of the law, who are the chiefs or the barazas and the groups of elders. And then in the other time, and then if you move into like the real life and what we live in this modern age, and you have a tax dispute, then who's the interpreter of the law? And suddenly you're going for an international arbitration where it's people who've never been to your continent making a decision about an agreement between two countries, or a company and your country. And I'm thinking, but why are you interpreting our law? And what's the validity of that? There's so much conflict of interest in this space. And then if I look at who the enforcers are, and then this is about the UCMs also and the sanctions that we've been talking about, because it is a company that is afraid somewhere that is enforcing. And I'm constantly struck by the fact, and this was something I only discovered in January during one of our working groups. And I don't know if you know this, but the United Nations has a department on sanctions. But that department on sanctions actually seems to be implementing UCMs. And so how is it that a multilateral entity that is a global civil service also is implementing Security Council authorized sanctions, but in order to facilitate its work across the world, is actually also implementing things that we are discussing and debating and we're not clear on. And so for me, these are the reasons why I pushed for the book. Yeah.
Great, so I think I'm going to end here and then hand it over to the chair, just with the last parting shot. There's also a Liberian proverb that says, if your house don't sell you, the streets won't buy you. So you started off by saying that, you have been attending global forums with IMF, and you've been criticizing their methodologies, and they'd come back and say, where is the data? Where is the book? I think the book is here, because she talks about 54 African countries. and she maps the tax data around it. And I think that's like a really valuable resource for us going forward. And I'm not sure, is there part 2 coming on? Okay, I hope so. So back to you, Chair. Thank you.
Thank you very much, Doctor. And I think that now is the time for you to participate, asking questions, or if you have an idea or you have been already read the book, you can ask something about it. And yes, please, Professor.
It's really just a wonderful, wonderful thing to have in the world. I have mine here, brought it with me from Boston. I know this is a different question than was asked earlier. So not what a tax system would look like in a perfect world, because we don't have one. What if the opposite of what happened actually did happen? So instead of the OECD taking over, what if the African Union had designed a global tax system? What might that look like?
If there is another question, we can get 3, 4 questions together. Por favor.
¿Español o en inglés? En inglés, okay. Thank you thank you very much. So just before we made a side event with the permanent mission of Cuba, and I was a panelist as well, and I talked about the necessity to decolonize the human rights, decolonize the international law, because of course we have a role on the international level, but unfortunately these roles are in general instrumentalized by some countries we know. And yesterday, of course, when we listened to the European Union, the comment they made, it was the example of the new colonialism and the instrumentalization of the international law. So what can you propose regarding that? And of course, how can we do for the European Union understand that maybe the world changed, and that evidently the unilateral sanctions, the blocus, are not an option to apply to some countries who at the end put on the table the biggest human rights violation we can know around the world? This is the question I have for you. Thank you.
Thank you very much. Another question or a comment? I see none, so please, Atia.
Thank you very much. I should hope that the African Union would not do what the OECD has done to the world. When I look at the choice of some of the wealthiest nations to form a regional bloc to do something, I think it was okay in its sense, as long as the regulations were only for them and internal to them. For them, right? They're helping to build and grow and form this bloc. But I think by the very same line, if we are to talk about justice and fairness, then they should not visit upon the rest of the world the political and financial weight that they've now engaged in. And so I think it's important for the African Union to also try and build the more vulnerable countries in the space and try and document. I think it is so interesting that 2 countries I could not get data on were Zimbabwe and Somalia. Because of sanctions and unilateral coercive measures, their data was not accessible. So I think even if data is not accessible at a global level, I think the African Union at minimum should be able to sort of bring their spaces closer together. And I know they're doing a lot of things to do that. But I think that in the world we're living in, there's a need to have a certain amount of protectionism for the weakest every single time, while always having a hand outwards to the rest of the world. And I think that that's one thing that the OECD has been unable to do, that I think Africans, as I think we can honestly say, we are one of the only continents that have never attacked another continent, I think is a really important position to be standing on. A continent of truly peaceful people. and being able to understand how truly peaceful we are in the world that we're living in right now becomes so incredibly valuable and important. And thank you about the necessity to decolonize human rights. This is a struggle I continue to have with people that work in human rights. I cannot talk about the progressive and immediate realization of human rights as being two separate things. I think some countries don't have the right to vote, and it's because they don't have money, right? So the reality on the ground, that budgetary reality, is a very real reality. But we are still using this Cold War end where civil and political rights were separated from economic, social, and cultural rights. And then if I draw into that the tax conversations that we're having at that point in time, the decision was actually to then move taxation into the OECD. And it was very deliberate because the timings of these resolutions were almost identical, I think the same day or a day apart. And so you may be seeing only the human rights part of it, but when you layer on the tax part of it, you realize that decisions were not just being made in one space. Decisions were being clearly split apart in multiple spaces. And so has it been instrumentalized? Well, I think member states were using their political priorities and very effectively using them. And the biggest challenge that continues to face developing countries is sometimes you don't have people in the room to even know what's happening. And if we remember in the 40s and the 50s and the 60s, even up to the 80s and the 90s, there was no internet. There was no digital conversations. Nobody could be streaming in onto those debates and discussions. And only 40 plus countries were actually independent, which meant countries were even representing their imperial collaborative groups of countries, right? So there was an invisibility about these countries. And of course, Steve's mapping showed you that 1959 into 61 was really the changing point. And so I think that there has to be a recognition of that. But as regards these guidelines and rules that now certain blocks of countries are rolling out, I think they are very useful. I think that they came into the room. I was very grateful for that, and I did mention that yesterday. But I think they should allow us to pilot it. I would like to see their data going into the monitoring tool that has been developed by the rapporteur on UCMs. I mean, let's actually see the data, and let's actually see the information. Come back and tell us that we've missed out certain questions or issues so that we can have this open understanding. I've already spoken to some of the member states, asking them if they would allow me to pilot the laws and understand whether they are tax, debt, or IFF-related repercussions in these UCMs that they are rolling out, so that there's a better understanding. But I will tell you, for me, and I know Alina has also said this, that we've taken so many steps forward since the conference we had last year, because I was also there. And there are so many more people in the room, and there are so many more member states in the room. So it means that there is appetite for conversation, and there is appetite for discussion. And so we have to make sure that those doors are kicked wide open. But I think sharing of data is going to be the really critical step. But I also think, before I give it back to the chair, that on financial issues, there is a bigger and bigger proportion of financial transactions. And I did a report on digital financial transactions and human rights for the Human Rights Council 2.5 years ago. There are more and more financial transactions, either in bitcoins or other forms of online currencies. We are now seeing some very fantastic transactions on NFTs, the non-fungible tokens, right, that really don't make logical sense to me. There's a very famous NFT, which is a picture of a Kenyan athlete winning a competition, and it was sold for $1 million. And this is just a digital NFT. It was unprecedented. But trying to unpack and understand that there are some of really, really large financial transactions just not happening in this formal system that we're talking about. And then if you throw in the fact that I spoke earlier about the fact that we have informal economies or shadow economies, we have the entire tax haven system, but we're still not very far away from the era when people would walk across borders with briefcases of money or kilos of gold. I mean, we're not so far from that. So while we are talking about these formal spaces, we mustn't forget about these very large informal spaces that are continuing to become more and more important and more informal. I hope that helps. But back to you, Che.
Thank you very much, Atiya. And I think that you have been working the whole day. I believe that you are not only tired, but hungry also, because you had not having the chance to have a bite. I just wanted to end this activity, a wonderful presentation of your work, sharing one idea that I found in the book that shocks me because it's reflecting not only the reality of Africa, it's reflecting the reality of many of the continents. And it's many tax laws appears to be accident of history and or reflection of external pressure rather than being integrated into a coherent vision of the state. So I think that with this idea, I just wanted to leave you to reflect on the reality that we are living in our continent. So thank you very much, Atiya, for this work. And I think that you have done also a wonderful work translating the book into the official languages, six official languages. Six African Union languages.
So we have Swahili, we have Portuguese, we have Arabic, French,
Spanish and English. You can see the great, giant effort that she has done. And I also saw in the book that was a hard work to find an African editing house, a publishing house. So I think that this work has to be worth it because it's heavy work. So please, if you don't have one, I think that, I don't know if you are selling them, giving away.
We have some to give away.
Okay, so as you hear, there are some books here that you can take it with you. So please do it, and you will have an idea of what is happening in Africa. So thank you very much to all of you for your presence.
Good afternoon, everyone. I fully understand that after 2 days, everyone is tight, but we still have one more session, and I'm looking forward to the amazing presentations by our very qualified and professional speakers, as well as a very intense discussion with questions and answers. Our last part is focusing on the issue of responsibility. We have discussed humanitarian elements and threats. We have discussed the access to effective remedy and access to justice. And now we will try to discuss the challenges to make the perpetrators responsible and accountable for human rights violations in the unilateral sanctions environment. I would like to remind that we developed guiding principles on effective remedy and responsibility. It's very good that one of our panelists, one of our participants raised some issues relevant to responsibility. Indeed, we discussed a lot how we shall address specifically the responsibility for international law violations, responsibility for human rights violations, and even responsibility for violations of human rights when states are announcing that they intend to implement sanctions of the UN Security Council, but do it much beyond their real authorization. Take into account that some of our panelists recently have been appointed as the chair of Coordination Committee of Special Rapporteurs. I would like to thank George for being able to escape from the meetings of Coordination Committee and to join us during this session. And therefore, without further delay, I would like to give him the floor to discuss the impact of sanctions on the international order. So, George, please, the floor is yours.
Many thanks, both for the invitation and for organizing this very important event. You know, Alena has made an one-woman show in many things during her mandate. I have heard praise for her in many different instances, and of course, it is justified. I wanted to excuse me. I want to apologize for being just for the time of the presentation with you. As Alena has said, without me knowing, I was not warned that they are going to propose me for the post of the chair of the Coordination Committee. I have been elected. It is my obligation to chair the meeting. So I have insulted both you and them, you by coming for too short time, and them for escaping for the time that I'm here. So apologies again. It is obvious that the unilateral sanctions represent a kind of invisible siege at the international order. Financial embargoes, blockade. What's happening in Cuba, it's not an embargo. Secondary sanctions, weaponized tariffs, or this seem to become the coercive instrument of choice in the 21st century. And yet, in the discourse of international law, they remain curiously under-theorized, insufficiently challenged, and almost entirely unaccountable. That's why this session is a very timely one. Of course, the legality of sanctions outside of the Security Council is obvious. But there are not only procedural reasons in order to judge the legality or illegality of sanctions under international law. We have also substantive obligations that must be met in order some kinds of sanctions to be considered legitimate. International human rights law is clear. The right to health, to food, to education, to an adequate standard of living. These are legally binding obligations, and any sanctions that harm people and violate these rights should be considered illegal under international law. The evidence is overwhelming regarding the humanitarian impact. You remember how many thousand children have died in Iraq. In Iran, now, sanctions targeting oil exports and the banking system have generated persistent fiscal compression, limiting the government's capacity to fund public health infrastructure. It is obvious that sometimes sanctions are used as a Trojan horse for regime change, to create such economic destabilization so as to persuade the population to go against their government. This is clearly the case of Cuba. In over 6 decades of economic blockade, which the General Assembly has condemned every year, most recently by a vote of 187 to 2, now the situation is almost unbearable. No medicines, no food, no electricity. And of course, these are not side effects of the sanctions. These are exactly the intended consequences. Now consider a different context, the so-called Liberation Day tariffs of President Trump. Lesotho, one of the poorest nations on earth, faced a 50% tariff. Cambodia, 49%. The Lao People's Democratic Republic, 48%. These countries did not harm international trade, did not harm United States, they did not choose poverty. Their trade deficits with the United States reflect simply the unaffordability of American goods for their populations. Yet, they were punished, as though they were adversaries. This is not trade policy, of course. And this is not beyond the scope of international law. We're not speaking just about morality. The ILC articles on state responsibility are unambiguous. Foreseeable harm cannot be laundered through privatized enforcement. When states mandate banks, insurers, and shipping companies to comply with sanctions, and those actors over-comply, suppressing even lawful humanitarian trade, responsibility is not attenuated. It is diffused and multiplied. I had the odious privilege to be in the government of Greece during the austerity measures. What they have imposed to us by the IMF, by our creditors, falls into the same scope I have described before. We lost about 30% of our GDP. The European Committee of Social Rights has in main decision said that these measures were contrary to the European Social Charter. And of course, international creditors did not give a damn about that. This is not about poor countries. This is not about let's say, international trade or international environment. This has a clear impact on the way that the new multipolar world is shaping form. Let me begin with the legal framework. The International Court of Justice, in this famous case, Nicaragua versus United States, affirmed that coercive measures designed to deprive a state of genuine freedom of choice in its internal and external affairs constitute prohibited intervention under customary international law. Contemporary sanction regimes, particularly when reinforced by secondary sanctions, meet the Nicaragua threshold by design. Their explicit purpose is to constrain sovereign choice and even facilitate regime change. Sanctioned states frequently invoke the doctrine of countermeasures to justify the coercion. But international law is precise. Countermeasures must be proportionate, temporary, and directed at inducing compliance with international obligations, not because a powerful country does not like the political regime of a small island some miles in the south of its territory to imply that what it is doing is just countermeasures. And these, let's say, countermeasures, by definition, by international law, they cannot affect third states, they cannot affect civilian populations, or violate peremptory norms, including the minimum core of human rights obligations, the human rights I referred to initially. Comprehensive financial sanctions, lasting decades, affecting entire populations, cannot plausibly satisfy these conditions. The Liberation Day tariffs go further still. They were not even framed as responses to internationally wrongful acts. They were justified as correction to trade imbalances through emergency powers doctrine, placing them entirely outside the countermeasures framework, completely outside international legality. A domestic court has already noticed, as you know, on 28th of May of 2025, the United States Court of International Trade ruled that the President has exceeded his statutory authority in imposing these tariffs. The international law analysis leads to the same conclusion. However, my most important issue and the basic message of this speech is that sanctions is a way to hollow out sovereignty. First of all, fiscal sovereignty, and then political, popular sovereignty. The result is a form of fiscal compression that transforms governance itself. Governments are forced to shift spending away from development, climate adaptation, and social protection. And this is not just the result of sanctions, this is also the results of the programs that the IMF imposes to the Global South. And not the Global South, Greece, my country, was a victim of these policies. And this is the quiet violence of economic coercion. It does not leave visible wounds like a bombardment, but it hollows out the state from within. What then is to be done? The law of state responsibility is clear in its logic, but unfortunately not yet in its enforcement. Where sanctions are found to violate the principle of non-intervention or to breach extraterritorial human rights obligations, the legal consequences follow. First of all, there is an obligation for cessation of the wrongful conduct, full reparation for quantifiable harm, including lost public revenue, increased debt servicing costs and damage to public infrastructure, and guarantees for non-repetition. And reparation must reflect not only aggregate economic loss, but also the differentiated social impact on vulnerable populations, women, children, patients, smallholder farmers cut out from export markets. This is maybe the most important work that Elena has done, trying to formulate concrete ways to, first of all, to follow, to monitor the situation, and then to propose remedies. But of course, guarantees of non-repetition require a structural reform of economic governance. There are studies that say that a citizen of Ethiopia has 185 less votes than a citizen of Belgium in the IMF and the World Bank governance structure. Economic governance must change, and we should defend, of course, the whole United Nations system, but we should also try to democratize it. Elena has many times advocated for concrete safeguards beyond these structural reforms. But it must be clear that we need also a structural response at the level of the main bodies of the United Nations. We are moving, we are already, not just we are moving, to a multipolar world. But multipolarity needs multilateralism. Already, the economic changes, so the material conditions for this change are present. The GDP now of the BRICS nations is higher if calculated with purchase price index than this of the G7. We have already alternative financial architectures in the making, the New Development Bank. It is very logical, this transformation movement, to begin at the regional level or at the inter-regional one. But finally, we must have change at the level of the United Nations. Another example of this necessary change is the effort to impose to the multinational companies at least some fiscal obligations. The discussion under the United Nations Tax Convention, for which Atia is an expert. I'm concluding by saying simply that we are at the end of an era. The raw force that the United States is demonstrating, both when materially, genetically, bombards nations like in Iran, or when they undertaking an economic warfare, all this is not a sign of force. It's a clear sign of decline of the American hegemony. A hegemon who enjoys legitimacy does not need to go to raw force or coercion. And it's exactly now that we have a change of paradigm that all of us must undertake the task of transforming in a more democratic and inclusive way the economic governance, but also the whole institutional framework of the United Nations. Many thanks for your attention.
Thank you very much, George. Take into account that you are to leave, I will break the procedure and will ask people to ask questions if they have any at this moment so that they can benefit from your presence. Are there any questions from the ground? As people are still thinking, I will start.
Okay.
Then, take into account that we are talking about the international order. What I have observed as a special rapporteur are several tendencies which make me really concerned. The first one is the concept of maximum pressure campaigns and qualification of states in certain, I would say, blaming and shaming way, like state sponsors of terrorism, pariah states, axis of evil, and many other elements. What do you see as the possibility to draw attention from my perspective, full illegality of these qualifications, and what can be done within the UN, these steps UN doing to enhance the respect to the rule of law as well as to maintain international order. And I have one more question. You have mentioned that many instruments have been used as many tendencies or many types of activities have been used as an instrument to change regime, for example. One of the concerns I had is humanitarian assistance. So yesterday, during the higher level segment, it was mentioned that many of sanctioning states are main donors of humanitarian assistance. However, there are multiple challenges. And what I have seen, for example, in Venezuela, was an attempt to deliver and distribute humanitarian assistance outside without any connection with governmental institutions as a means to demonstrate that the institutions cannot help you. So you can only get something if you cooperate with opposition. Upon my view, from the perspective of UCMs, is a clear attempt to manipulate humanitarian assistance, and it's in breach of the principles of humanitarian action, but would be good to know your opinion. And we still have a question from Atia.
Okay.
Atia, please, the floor is yours.
And of course, always happy to have you talk about democracy and international order. You and I have been liaising on issues around taxation, for example. One of the things about unilateral coercive measures that I think is quite interesting is how we've had a series of unilateral withdrawals from tax or tariffs over the past year or so. And from the perspective of, democracy and international order, what do you see is the weakening in the system because of these, these changes in tariffs, the increased debate on it as well? And do you see this sort of progressing further into other areas of finance as well? Thank you.
Excellent questions. Of course, we are very much like-minded, so it's easy to ask questions and for me to respond because we have the same mindset. But it's not just us. It is the facts. I have included in my report, demonstrated exactly what Alena said, how humanitarian aid has been used as a weapon to manipulate political behavior. A very famous case in the United Nations. EMN has voted in a vote, very probably, if I remember correctly, related to the war in Iraq, against the United States. And the ambassador of the United States has approached the ambassador of EMN, and he told him, this is the most expensive no that you have casted. And immediately after that, the American aid to EMN has been cut. This is a very clear example, and maybe exactly because of the blatancy of the American ambassador, obvious. But maybe not so transparently, it is clear that a big part of the humanitarian aid is tunneled not to satisfy humanitarian needs, but clear political objectives. Regarding now the impact, I'm generally and always optimistic. Violating the rule of law, violating international legality, saying blatantly that international law is irrelevant. Marco Rubio, at his hearing at the Senate, said it even more clearly. He said that the current international order is not just obsolete, it is a weapon used against us. And look now, the United States have not lost the war in Vietnam because they have lost a lot of battles. They have not left Afghanistan because they have lost battles. They have lost the acceptance and the legitimacy of their presence there. The genocide in Gaza has left Israel much more isolated than in the past. And this is not without consequences, although political time sometimes is much slower, not for us, for the victims. The same thing happened in the apartheid of South Africa. So there are very clear material consequences from the violation of legal obligations. The issue that was touched by Attia demonstrates exactly how there is a clear battleground between not just multinationals, but also countries that want to defend the privileges of multinational companies. The discussion in the OECD is very characteristic. There was an effort during the Biden administration to have some kind of agreement of a minimum tax of 15% of multinationals. When President Trump came to power, basically he pulled the United States outside even of this very, very inadequate agreement. Therefore, we must protect the United Nations system despite its weaknesses and shortcomings. The UN Tax Convention that is now discussed at the United Nations would not be at the hands neither of multinationals nor of powerful states. And a final reason for optimism is exactly that the international law in general is evolving to more democratic, to more, let's say, inclusive orientations. The right to self-determination, was not included initially at the United Nations Charter because the British and the French empires rejected the idea. It was the anti-colonial struggles of the 60s that imposed this right to the two covenants of 1963. We are again before such a transformational moment for the United Nations and for the global international law, exactly because of the decline, the relative decline, of the American hegemony. These changes do not come by themselves. They come as a result of struggles and confrontation. But they need also theoretical analysis, and that's what Alain and this important event aim to do, and I think you, as participants, managed to do in a very, very important way. And with this, I must again apologize to you and leave for my other obligation where they're going to be even more angry towards me. Many thanks.
Thank you very much, George. Thank you for coming and presenting. So good luck with your new duties.
Thank you.
And with all that, we are moving to our next speaker, Mr. Mohamed Kanfar and Alexander Hofer. As I understand, they participate half in person, half virtually. So please, the floor is yours.
Thank you. Is this on? Yes. Esteemed colleagues, ladies and gentlemen, both here in the room and joining us online, good afternoon. As this is the final session of the conference, allow me to thank you all for your perseverance and for choosing to stay and to join us for this session. A special word of gratitude goes to Professor Dohan, not only for your kind invitation, but also for all the great work that you've been doing throughout the past 6 years. Like a classic work of art, the full significance of your contribution will only be appreciated in the years ahead. Thank you for your profound dedication, and we wish you the very best as your mandate comes to an end. Today, my colleague, Dr. Alexandra Hofer, and I will raise the question of responsibility for the so-called unintended consequences of UMCs and sanctions in relation to food security. Throughout this conference, we have heard compelling evidence about the devastating impact of sanctions and UMCs, particularly when imposed on entire societies, as is the case of Iran, Venezuela, and Cuba. The evidence presented here confirms what many scholars, practitioners, but also affected communities know very well. Sanctions do kill. Take the case of Syria, for example. Even 1 year after sanctions have been lifted, their effect continues to permeate every aspect of life. For years, Syria was more or less under a de facto embargo. It became the third most sanctioned country, trailing after Iran and Russia, and the country was effectively cut from the global financial system, and any form of engagement, legitimate, humanitarian, life-saving, became highly toxic. Sanctions against the country was even made worse by the practice of overcompliance and de-risking. In practice, this meant that the access to water deteriorated, medicine could neither be efficiently produced or imported, and humanitarian organization could not properly function in the country or respond to the crisis. This was quite evident in the COVID-19 pandemic, when the WHO reported that there were delays with the imports of vaccines, and during the earthquake which struck Syria and Turkey, when people died, literally people died under the rubble because sanctions and UMCs prevented the timely delivery of emergency assistance. Importantly, and here we go back to the issue of food security, sanctions significantly undermined food security across the country. Within just 1 year of the imposition of Caesar Act, an American extraterritorial sanction regime, the number of food insecure people doubled from 6 to 12 million people. If we think in terms of operational chain, the one that outlined yesterday by Professor Majid Zada, sanctions disrupted every stage of the food system. They impeded the country's ability to import food, as banks refused to process transaction, and shippers refused to send the goods to the country. They also crippled the domestic ability to produce food, among others by preventing the import of fertilizers and pesticides. Hyperinflation further eroded the purchasing power of ordinary civilians, leaving millions unable to provide for themselves and increasingly dependent on humanitarian assistance. Let me be clear here. While we do not attribute these outcomes solely to sanctions, it's clear that sanctions did compound an already dire situation and contributed to a systematic collapse in food security for millions of people, pushing the country to a near status of near mass starvation. While unfortunately the impact of these sanctions did not receive the level of global attention one might have expected or hoped for, knowledge of their consequences did reach policymakers. As early as 2012, US officials were receiving reports warning of the potential effects of sanctions on food security. Over the years, the impact was documented in multiple studies, raised in public and policy forums, and occasionally surfaced in the media. Yet, rather than addressing these concerns, the policymakers chose to double down, expanding and tightening the sanction regime. The quote-unquote unintended consequences of sanctions in this case cannot be attributed to oversight, ignorance, or negligence, but rather the willful and deliberate weaponization of the suffering of millions of civilians, children, women, and the elderly for geopolitical purposes. In 2020, in boasting about degrading Syria's economy and prohibiting the UN from carrying out any significant work in the country, the US Special Envoy James Jeffrey explained the rationale of his country behind the sanctions on Syria. In his own words, and among others, it was to make Syria a quagmire for Russia. If this was indeed the strategic logic, then setting aside the moral question, this raised a series of pressing issues about the issue of responsibility and accountability. What does this mean for responsibility? How can sanctioning actors be held accountable for the foreseeable harm of their sanctions? And how does international law engage with these questions? To answer these and to reflect on these questions, I want to invite my colleague, Dr. Hofer, to join the presentation and provide some of her reflection.
Thank you very much, Mohammed. I'm sorry to only be able to join online. Based on the program, I can tell that I have missed, unfortunately, a very rich discussion, and I am especially sorry to be missing, I think it's the last event, if I've understood correctly, that Professor Doğan is organizing on this important topic. So with the time remaining for the presentation, I will address the questions that were raised by Mohammed, which is, how can sanctioners be held accountable for the foreseeable harm? What essentially does international law provide on this? And to answer this question, I would like to go back for a moment to Venezuela's referral to the International Criminal Court, I believe it was in 2019, in which it claimed that the United States sanctions against it constituted crimes against humanity. You may be aware that last March, the prosecutor concluded that there was not a sufficiently solid factual basis to proceed with an investigation and closed the situation in Venezuela. Although he did acknowledge that sanctions can lead to humanitarian harm, on the basis available to him, he was not satisfied that the criminal law standards of causation and intent were met. And apart from the statement that he has provided that has been published on the ICC's website, I am not exactly able to tell why he thinks those standards were not met. But in any event, even before the prosecutor closed the case, there were some in academia who were quite skeptical about Venezuela's referral. Notably, an article was published in the American Journal of International Law addressing this very issue. So the first question perhaps that arises is whether or not the US sanctions against Venezuela are unlawful. After all, if they're not, then they can very well not constitute crimes against humanity. And we would be particularly interested in knowing whether or not these sanctions would be responsible for human rights violations. Although in this room, to use the term that was previously used, we might all be like-minded and find that it is easy to argue that sanctions do violate human rights. Unfortunately, this is not an opinion that is universally shared. And it can actually be very difficult to make this case, especially if we adopt a more, let's say, doctrinal, well, not doctrinal, but perhaps a more rigid perspective of international law. So one of the first hurdles is often to argue that the sanctioner owes extraterritorial human rights obligations to the sanctioned state. So the idea is, why would the United States of America be responsible for respecting human rights obligations in Venezuela if the Venezuelan people are not under the US's effective control? The other issue is that the United States is not party to the Convention on Economic, Social, and Cultural Rights, which is, of course, perhaps the most relevant one when we're talking about how sanctions affect the standards of living of the civilian population. And another issue is causality. So you need to be able to establish a causal link between the sanction and the humanitarian impact. And this can be difficult to establish, especially when sanctioners hide behind the so-called unintended consequence of their measures, or when we are dealing with private companies over-complying or de-risking from a sanctioned jurisdiction. Nonetheless, as the late Professor James Crawford acknowledged, measures taken in the framework of interstate relations should not be such as to threaten the starvation of the people of a state. And he based this on Comment Article 1, Paragraph 2 of both the International Covenant on Economic, Social, and Cultural Rights, and the Covenant on Civil, Political Rights, which states that in no case may a people be deprived of its own means of subsistence. And if we're talking about the right to life, or inflicting a situation of malnutrition on a people, then it is also relevant to consider Article 6, Paragraph 1 of the ICCPR, which includes the obligation to not cause widespread hunger and malnutrition. According to the Human Rights Council, for sanctions to breach Article 6, Paragraph 1, starvation and malnutrition need to be a direct and foreseeable consequence of sanctions. And based on this, it has been concluded that international law does impose a limit, which is that in what some authors have called in extreme circumstances, where unilateral sanctions rise to the level of depriving a people of its own means of subsistence and threatens the starvation of the people of a state. And sadly, it would appear that Syria is such an extreme circumstance. As my colleague Mohammed noted, already in 2012, US policymakers were informed that the restrictions imposed on Syria would lead to food insecurity. Rather than make any amendments to their measures in order to prevent this, they steadily tightened the screws on the country in order to achieve geopolitical ends. It could therefore be concluded that the US sanctions against Syria were unlawful because of the direct and foreseeable widespread harm that they caused to the Syrian civilian population. Unfortunately, because of the many structural limits that exist under international law, notably, for example, the difficulty in Syria being able to effectively invoke the United States responsibility before the International Court of Justice, for example, and having a judgment that would potentially force the US in offering reparation to the Syrian people, they are unlikely to receive any form of justice. And it is also unlikely that US policymakers will feel any remorse for the harm caused. As far as they are concerned, the sanctions were a success because they enabled them to achieve their geopolitical objectives. And I think that it is fair to say, and I think that other speakers during this event would agree, that US policymakers continue to pursue these objectives elsewhere. I don't know if you noted that during the latest Davos meeting, US Secretary of Treasury Bessent stated that President Trump's maximum pressure sanctions against Iran had successfully triggered popular protests. So in his view, thanks to the sanctions, in December 2025, the country's economy collapsed, and this is why people took to the streets. So for him, this was economic statecraft. No shots were fired, but the US was able to influence Iran's internal affairs. So the question perhaps, and this is something that we have to further explore, is if we acknowledge that starvation and malnutrition can be direct and foreseeable consequences of sanctions, could this amount to a crime against humanity? For this to be the case, we would have to demonstrate that the US deliberately targets the civilian population to achieve political goals. Because for there to be a crime against humanity, the civilian population needs to be the target and not the accidental victim of the policy. And the other question is about what would be the level of individual responsibility under international criminal law that would apply here. So international criminal law has different forms of liability that range from being the direct perpetrator to an accessory. And so this requires, I would say, or we would argue, unpacking how sanctions are adopted and implemented and seeing to what extent this can fit within the framework that has been devised under international criminal law, which generally focuses on crimes that are committed through the use of force of weapons. So this is just, let's say, a thought experiment at the moment and things that we will continue to look into in the future. Thank you very much.
Thank you very much for your presentation. And with all that, I'm giving the floor to our next panelist, Professor Pouria Askari, who unfortunately, due to the prohibition of flights to and from Iran, was not able to arrive. And therefore, he will make his presentation via video statement.
Let me begin by sincerely thanking Professor Duhan for her kind invitation and by apologizing for not being able to join you in person. As you know, my country is currently facing a war of aggression by the United States and Israel, and I was therefore unable to travel. Nevertheless, I am grateful to the organizers for kindly allowing me to join you through this pre-recorded video to share the main highlights of the paper that my co-author, Mr. Matin Amiri, and I have submitted to this important conference. Our paper is entitled The Application of Extraterritorial Jurisdiction in the Context of Unilateral Coercive Measures. Dear colleagues, by way of introduction, allow me to recall that the imposition of unilateral coercive measures with extraterritorial effect, commonly referred to as secondary sanctions, has increasingly become a focal point of criticism in contemporary international legal discourse on sanctions. Critics contend that the exercise of extraterritorial jurisdiction by a state often constitutes an overreach infringing upon the sovereignty of other states and undermining the principle of territorial integrity, which remains a cornerstone of international legal order. Secondary sanctions exert pressure on entities in third states to comply with restrictive measures. In this way, the domestic policy objectives of the sanctioning state are projected extraterritorially, extending their reach well beyond national borders. When a state unilaterally extends the application of its laws beyond its borders through secondary sanctions. It challenges established norms of jurisdictional restraint, particularly where such measures affect third country actors or foreign nationals lacking a meaningful nexus to the sanctioning state. In our paper, we first examined the legitimacy of the extraterritorial application of jurisdiction and then addressed its connection to the use of secondary sanctions. In the next few minutes, I will discuss the nature and legitimacy of extraterritorial jurisdiction within the contemporary international legal order, and subsequently explore the relationship between unilateral coercive measures, particularly secondary sanctions, and the extraterritorial application of jurisdiction. Ladies and gentlemen, as you know, wider jurisdiction, including legislative competence over the national territory, is a subject of domestic law. Exercising jurisdiction over another state's territory is governed by international law. Sovereignty is inherently connected to territory, which establishes territoriality as a core principle of jurisdictional law within the existing international legal order. The prefix extra reflects the understanding that sovereignty is fundamentally territorial and that the exercise of extraterritorial jurisdiction constitutes an exception requiring special legal justification. Jurisdiction may be exercised through prescription or enforcement. The prescriptive jurisdiction refers to a state's sovereign authority to prescribe laws and regulations to persons, property, or conduct, whether inside or outside its territory. Enforcement jurisdiction speaks of the territory in which states may enforce their laws. The Permanent Court of International Justice, PCIJ, in the renowned 1927 Lotus case, adopted a permissive approach to prescriptive jurisdiction, but emphasized that the enforcement of extraterritorial jurisdiction is not permissible. The UNGA's stance on the extraterritorial application of jurisdiction is also important. In a resolution addressing human rights and UCMs, the UNGA, and I quote, condemns the continuing unilateral application and enforcement by certain powers of unilateral coercive measures and rejects those measures with all their extraterritorial effects. End of quotation. In 2025, the Special Rapporteur on the negative impact of UCMs on the enjoyment of human rights endorsed this position. Professor Duhan held in the UN Guiding Principles on Sanctions, Business, and Human Rights, and I quote, states and regional organizations shall not exercise their jurisdiction extraterritorially, contrary to the principle of sovereign equality and of non-intervention into the domestic affairs of states. End of quotation. Strong statements like those found in the above-mentioned UN documents opposing the extraterritorial application of jurisdiction pose a significant challenge for legal scholars seeking to conclude that there is an opinio juris among states regarding the permissibility of such jurisdiction over the sovereignty of other states. The difficulty arises since current international law firmly upholds the principle of non-intervention, and this principle does not authorize states to unilaterally apply their national laws to regulate foreigners and their activities in the territory of other states in a variety of aspects. Doctrinal approach to this matter also supports this conclusion. Now let me move on to assess the relationship between secondary sanctions and the application of extraterritorial jurisdiction. Your Excellencies, the reason why the term secondary sanctions is often associated with extraterritorial jurisdiction and then referred to as extraterritorial sanctions is of considerable significance. The core of the link between these two notions lies in the function of secondary sanctions. It can be argued that secondary sanctions are designed as complementary tools to reinforce and maximize the implementation of the sanctioning state's foreign policy by blocking alternative channels through third countries. This reinforcement is typically supported by fines and penalties imposed on foreign individuals and companies. Thus, if extraterritoriality were omitted from secondary sanctions, their employment would be ineffective. In other words, most secondary sanctions cannot function without extraterritorial reach, as they are designed to target entities outside their territory to weaken the sanctioned state's access globally. When it comes to sanctions imposed by the United States of America against many states, including my country, Iran, these measures exert pressure on foreign actors to align their policies toward targeted states with U.S. objectives through natural and legal persons who are subject to the extraterritorial legislation. The foreign actors referred to here primarily include European and Chinese individuals and companies that have seen their trade relationship with targeted states curtailed as a result of U.S. unilateral coercive measures and their extraterritorial effects. Therefore, it is not surprising that the European Union and China has condemned the extraterritorial application of third countries' legislation, imposing restrictive measures. Another aspect of general practice that clearly illustrates states' stance on extraterritorial sanctions is the adoption of blocking regulations. The states concerned about the application of extraterritorial jurisdiction has made its way into their domestic laws, as some of them have enacted blocking statutes in order to combat and or neutralize the extraterritorial application of a foreign law, which maximizes its scope of enforcement beyond the recognized jurisdiction under international law. Enactment of such normative regulations is mainly for public policy, to preserve their sovereignty and to compel the companies under their jurisdiction to avoid complying with extraterritorial measures by imposing mostly financial penalties. The imposition of blocking regulations by states can be understood as one of the most important signs of a state's taking a stand against the extraterritorial application of jurisdiction in the form of secondary sanctions. Dear colleagues, as concluding remarks, let me emphasize that despite some controversies, extraterritorial jurisdiction is generally viewed as impermissible under international law, except where clearly authorized by established norms. This is reflected in the practice of states and international organizations, as we have discussed in the paper, including domestic laws, UNGA resolutions, and statements by the UN Special Rapporteur on UCMs. Opposition to extraterritorial sanctions is so pronounced that even sanctioning states, including European countries, do not endorse them. This stance stems from the recognition that extraterritorial jurisdiction threatens sovereignty and violates the independence of other states, and is evidenced by the practice of challenging secondary sanctions inter alia through the adoption of blocking regulations. I sincerely thank you for your kind attention and wish all participants a most productive and enriching conference. Thank you.
I would like to thank Professor Ascari, although he is not present here. He used to be a very active participant of the events organized by the mandate and development of the guiding principles on access to effective remedy and responsibility, and assisted a lot to develop the commentary to these guiding principles. So for me, it's really pity that he is not able to participate, but I really appreciate all efforts he did. With all that in mind, we are moving to our last panelist, Dr. Natalia Moroz, who will talk about the reputational harm to states caused by unilateral coercive measures.
Dear colleagues, it's my great pleasure and honor to be here and share with you the results of my research on the topic which has already been mentioned, reputational harm to states caused by unilateral coercive measures. Reputational harm with respect to states is a very topical issue, but which has not received so many attention in academic publications, unfortunately. The term reputation in relation to a state is not well defined in the theory of international law as well as in practice. In a broad sense, state reputation means the collective perception, esteem, or image held by other international actors regarding its character, reliability, and behavior, particularly its compliance with international agreements and norms. And it is evident that state reputation impacts trustworthiness, negotiating power of a state, and also its inclusiveness in international relations. International relations based on the UN Charter exclude any reputational pressure. As it's stipulated in its preamble, the peoples of the United Nations are determined to practice tolerance and to live together in peace with one another as good neighbors. However, this goal is often neglected in unilateral sanctions environment. State reputation can be hampered in unilateral sanctions environment in many ways, and I will discuss three possible angles how these two topics are interrelated. First of all, building bad reputation of some states is used by other states to justify imposition of unilateral coercive measures. Some states have been qualifying other states as belonging to the axis of evil, rogue states, failed states, strongholds of tyranny. There are also other degrading characteristics such as failed states, allegedly incapable of exercising state governance within their borders, and also the characteristic that has already been discussed during this conference is a designation of a state as a sponsor of terrorism, which is made unilaterally. All such qualifications are used as a pretext to introduce unilateral coercive measures against states. And such designations also significantly aggravate already existing unilateral sanctions regimes. Let me provide just one example. Just in 2 months after the implementation of the decision with respect to the designation of Cuba as a state sponsor of terrorism, more than 45 banks from several countries interrupted their operation with Cuba. The UN Special Rapporteur on the negative impact of unilateral coercive measures on the enjoyment of human rights emphasized, among others, that the designation imposed actually led to different adverse effects on the country's ability to meet the needs of its population. In particular, it further undermined Cuba's trade relations by expanding the scope of forbidden actions and the list of prohibited items, raised uncertainty and fear, which led to a compliance with sanctions regime by all those actors who wished to enter into or maintain relations with Cuba, and undermined Cuba's access to credit and other development and emergency resources from international financial institutions, including the World Bank and the Inter-American Development Bank. The maximum pressure campaign against Iran, carried out by the United States, was aimed at destabilizing the situation in Iran. It actually led to serious consequences with respect to the enjoyment of the right to health, the right to education, the right to work, and actually many other basic human rights. The aforementioned practices constitute a breach of the principle of sovereign equality of states. But it's also a violation of the obligation not to intervene or interfere in any form or for any reason whatsoever in the internal and external affairs of other states, which requires to abstain from any defamatory campaign, vilification, or hostile propaganda for the purpose of intervening or interfering in the internal affairs of other states. As it was reflected in the general commentary to the International Covenant on Economic, Social, and Cultural Rights, sanctions hinder the ability of states to meet their obligations under the Covenant. But also, this obligation not to intervene into domestic affairs of any state presupposes the obligation to combat, within their constitutional prerogatives, the dissemination of false or distorted news which can be interpreted as interference in the internal affairs of other states or as being harmful to the promotion of peace, cooperation, and friendly relations among states and nations. The principle of non-interference into domestic affairs constitutes a fundamental principle of international law that was emphasized in a series decisions of the International Court of Justice, and it also constitutes a peremptory norm of international public law and prevails over any other international obligations. In fact, degrading characteristics of states were often given to a number of states in colonial era. For example, the phrase civilized nations, also known as civilized peoples, civilized countries, has long served to distinguish European states from states not thought to possess similar legal systems or values, and only civilized nations were permitted to have a voice in the formation of international law, and only civilized nations were expected to adhere to its tenets. Where a state was not possessed of a civilized nature, it was considered to be the legal object of colonization. Of course, the phrase is discredited today and widely considered to reflect an embarrassing disregard on the part of Christian European states for other legal and social traditions of the world. While the phrase continues to be found in certain treaties and, well, in particularly the statute of the ICJ, it's now primarily understood to include all nations. Therefore, any unilateral negative qualifications of states as the grounds for the adoption of UCMs is a discriminatory practice, which manifestly contradicts equality of rights and self-determination of peoples, enshrined in Article 1 of the United Nations Charter. In accordance with the Declaration of Principles of International Law and Friendly Relations, states are obliged to bring to a speedy end to colonialism, bearing in mind that subjection of peoples to alien subjugation, domination, and exploitation constitutes a violation of the principle, as well as a denial of fundamental human rights, and is contrary to the Charter. It should be also noted that the principle of equal rights and self-determination of peoples is a peremptory norm of international law from which derogation is not permitted. While certain states are given negative characteristics, the states introducing UCMs, on the contrary, often qualify themselves as democracies, which can unilaterally apply measures against other states, governments, or specific persons and organizations to restrain or modify unwanted behavior or policies in order to promote national security or foreign policy objectives. However, there are not such legal terms as rogue states, failed states, strongholds of tyranny. Therefore, such unilateral characterization of states constitutes the manipulation with non-legal concepts with the aim of non-compliance with international legal obligations arising from peremptory norm of general international law, the United Nations Charter, and other international obligations introduced in international treaties and customary international law. In this regard, it should be noted that states are obliged not to recognize as lawful a situation resulting from a serious breach of a peremptory norm of general international law. Thus, even this long-term unlawful practice of the adoption of unilateral sanctions at this pretext does not change its qualification under international law and does not give rise to the formation of international legal custom on this base. Certain types of campaigns aimed at creating negative image of a state may also constitute a violation of obligations to refrain from propaganda for war and to refrain from advocacy of national, racial, or religious hatred. Based on the Article 20 of the International Covenant on Civil and Political Rights, states are obliged to adopt legislation prohibiting propaganda for war and to refrain from any propaganda of this kind. The need to refrain from such propaganda is addressed in a series of resolutions of the UN General Assembly. Maximum pressure campaigns, reputational risks, and many other elements create an environment of uncertainty and fear and result in overcompliance, with overall humanitarian impact with spillover effect in the direct neighborhood, the regional, and even the international context, which can't be considered as something unfriendly or just, let's say, an insulting or which is, do not qualify as compliant with the norms of diplomatic ethics. As it was emphasized, it constitutes a violation of a serious international obligations, including deriving from the peremptory norms of general international public law. Secondly, states' reputation can also be hampered as a result of the adoption of unilateral sanctions. The fact of the adoption of unilateral sanctions against a particular state itself is used as a presumption of wrongfulness of state conduct. Individuals and companies are listed by sanctioning actors on the grounds they are associated with the government, benefiting or supporting the regime, doing business in the country, or being a family member of senior state officials or businessmen. Such reasons appear to be oriented towards conveying an unfavorable image of each sanctioned individual, harming their rights, and in particular the right to reputation. The use of information and communication technologies to exert political pressure and as a consequence to expand discriminatory practices against states and their residents is further enhanced by conducting information campaigns to put pressure on legal entities as well as entities of third states, with the aim to make them cease their activities in states under unilateral sanctions. For example, within the framework of the Leave Russia project, pressure is being exerted on companies to cease their business in Russia. The maintenance of list of good and bad companies serves this very goal. The designation of the Xinjiang branch of a large textile group in China caused broad reputational damage to the whole group, with the consequent financial implications resulting in the closure of businesses and factories located in several countries in South and Southeast Asia, thus affecting the enjoyment of human rights there, in particular when it comes to social, economic rights, the right to development, and other basic human rights. Thirdly, unilateral coercive measures have become an important trigger in assessments of reputational risk by businesses, often resulting in excessive over-compliance due to the uncertainty of regulations and applications and the likelihood of high penalties, which is often misinterpreted by sanctioning states as freedom of business decisions. The perception of Zimbabwe as a whole, as a designated country, created reputational risks for Zimbabwean companies and nationals and impeded them from opening or holding bank accounts, which had reportedly occurred in Switzerland, the United Kingdom, and the United States. Banking services were also affected by delays, as transfers could be stalled for long periods or cancelled. Dear colleagues, in conclusion, I would like to emphasize that the adoption, implementation, enforcement of unilateral sanctions and overcompliance with them cause a wide range of reputational issues for states that could be seen from different angles. On the one hand, damage to reputation is often made to legitimize the adoption of unilateral coercive measures, which constitute violation of the principle of sovereign equality, non-intervention into internal affairs, equality and self-determination of peoples, peaceful settlement of international disputes. Such practices are not just unfriendly rhetoric, but they constitute a violation of principles and norms set forth in the United Nations Charter. Therefore, such conduct entails international responsibility. Reputational damage to states caused by unilateral coercive measures, their implementation, enforcement, and overcompliance can also be viewed as moral damage, which is subject to separate redress. On the other hand, unilateral sanctions produce huge reputational losses for the residents of states. In this regard, it should be noted that any omissions with respect to reputational pressure exerted on ordinary people, businesses, academic institutions, humanitarian organizations, lawyers, constitutes a violation of the principle of due diligence, which also triggers international responsibility of sanctioning actors. For that very end, every individual and every private entity whose reputation is damaged through the adoption of unilateral coercive measures, their implementation, enforcement, or overcompliance shall be provided with access to a fair and public hearing by an independent and impartial court to protect their rights affected by these measures and to seek redress. Thank you very much for your attention, and if you have any questions, I would be pleased to answer them. Thank you once again.
Thank you very much, Professor Maros. Our last panelist is not here, so therefore we have heard, I believe, 4 amazing presentations. As you see, there are only 2 of us sitting here, but upon my knowledge, Alexander Hofer is online. So basically, I open the floor for questions to 3 of us. Yes, please go ahead. Yeah.
Very much, Special Rapporteur, for giving me the floor. I have a quick comment and a question for Dr. Alexander Hofer, if she's still online. Actually, there is a majority of scholars, professors, experts, supporting the idea that we are witnessing the emergence of an opinion juris condemning the imposition of unilateral coercive measures. And I had the pleasure of reading the article, the research paper published by Dr. Hofer. The name is The Developing Divided on Unilateral Coercive Measures, Legitimate Enforcement or Illegitimate Intervention, published in the Chinese Journal of International Law in 2017. And actually, if you allow me to read in the article, Dr. Hofer conclude that the resolutions adopted by the United Nations General Assembly regarding unilateral coercive measures do not satisfy the required criteria for establishing the formation of an autonomous customary norm prohibiting economic coercion or even an emerging prohibition. So just to quick go back, the International Law Commission in 2018 adopted draft conclusions on the identification of customary international law and mentioned that we need only 2 elements to prove that a general practice of a state could become law, a customary international law, just by practice, and that resolutions adopted by international organizations may provide evidence for determining the existence and content of a rule of customary international law or contribute to its development. So in the last or first edition of this International Conference on Sanctions, and I remember a group of professors, including Professor, that was the previous speaker, Professor Puri Askari. He also supported the idea that we are witnessing this emergence of an opinion juris condemning the unilateral coercive measures. And if you quickly allow me, for example, to look at these unilateral coercive measure resolutions adopted by the United Nations General Assembly, we have two main resolutions adopting like 42 years ago this exists. And the first resolution is, for example, one that is promoted by the group of 77 states in China since 1983 to the present. So we have a graphic, and if we see the blue line is, we see a trend, like gradual increase in votes in favor for this resolution. So we can say that this resolution is a proof, is an evidence that we are witnessing an opinion juris, not just because we have an objection from the European Union and other delegations from the global north. We are gonna stop telling that we can witness that exists an opinion jury. So I just want to double check with Dr. Hofer if she still has the same opinion like she provided in the paper in 2017, or if she changed it. Thank you.
Thank you very much. At the moment, we are collecting questions, and I will give an opportunity to all panelists to respond afterwards. So Professor Strauss was first, and then I will give you the floor.
For those really interesting presentations. I wanted to ask Professor Maros about this idea of defamation of states by the sanctioning that harms their reputation. Because defamation is something that is very irregular in terms of national laws. Some countries don't allow it against, well, some countries allow it only for natural persons, others for legal persons. The concept does not seem to have developed very much in the international law sphere. It's been incorporated into General Assembly resolution about the non-interference in the internal affairs of other states, but it doesn't seem, as far as I know, to have gone any further than that. But I'm wondering what the options might be for a state to claim damages as a result of defamatory reputational harm through sanctions.
Then, thank you very much, Michael. So, Riza, please, the floor is yours.
Excellent panel. I really enjoyed the discussions that I have heard. My point is a comment, it's not a question, and it is related to the second talk, which given by Mohammed and Alexandra Hofer. And I have heard this yesterday from your side, and it is about causality. And I want to say that basically I'm an epidemiologist. I'm working with the data. And I work on the 20 years data of 28 indicators, both nationally and subnationally. I'm getting back to the first chapter of the Professor Goodman book, which is excellent, which is discussing the preference of the cross-national studies versus national studies. The problem is that there are plenty of biases and methodological challenges that we cannot look at the causality in single country. If we want to look at causality, we should look at it at the cross level, cross-national countries. We cannot look at the, let's say, causality in one country. And I want to say that if we go with the, let's say, looking at the exposure, looking at the confounder, looking at the latency of appearing, let's say, something, because, you know, the time that we have sanction, it does not reach to the, let's say, food insecurity. It takes time to bring it up. Therefore, we should think on causality in cross-national studies, not in the national studies. In that book chapter, it is mentioning that if we want to look at mechanism, national level data can work. But if you're looking at causality, we cannot make it.
Thank you very much, Riza, for your comment. I saw your hand, but Alfred was first. So Alfred, really, the floor is yours. Not 1 hour.
Discipline. A question to Professor Maros with regard to Article 17 of the Covenant on Civil and Political Rights that prohibits unlawful interference in the honor and reputation of people. And you also mentioned Article 20, which is the one that prohibits propaganda for war and that prohibits this kind of xenophobia, Russophobia, Islamophobia that we all know. Now, I don't know of any recent case before the Human Rights Committee in which individuals have invoked, not states, individuals. The states can invoke the interstate complaints procedure, but under the optional protocol, every individual can present a case to the Human Rights Committee for violation of his honor and reputation. And I mean, I already have proposed to Jacques Beau to make a submission to the Human Rights Committee, but of course he's now going, his lawyers are going first to the European Court of Justice in Luxembourg. So he won't be going to the Human Rights Committee anytime soon. But I was thinking of all the others. You have the Swiss anti-colonial advocate Nathalie Yam. You have the French-Russian businessman and geopolitical analyst Xavier Moreau. You have the German journalist Hussein Dogri. I mean, and his case is really urgent. I mean, it's really awful what has happened to this poor German, born in Berlin, of Turkish parents, and an honest journalist. I read much of Hussein Dogrin, and he, together with Alina Lipp and Thomas Röper, these are the 6 Europeans who have been targeted by these draconian sanctions from the Council of the European Union. Of course, all of them could present cases to the European Court of Human Rights, and they could present cases to the Human Rights Committee under Article 17. But do you know any precedents of anything similar to this being submitted to the committee or to the European Court of Human Rights?
Thank you very much, Alfred. And I saw the request to give the floor to Ali Pustizadeh. Please, the floor is yours.
Thank you, Madam Special Rapporteur. I wanted to make a brief statement on behalf of the International Justice and Human Rights Clinic at the University of British Columbia School of Law, based out of Canada. First, we'd like to thank the Special, yeah, this is a UBC fan. We'd like to thank the Special Rapporteur for convening this discussion and for welcoming a range of perspectives into the room. We also wanted to express our gratitude for your years of service to the mandate. And a little background, since 2019, our organization has worked on designation submissions to Canada, the United States, the EU, and the United Kingdom, as well as reform to Canada's sanctions regime. We also submitted input to the Special Rapporteur on the earlier draft of the guiding principles on sanctions, business, and human rights. And over the past 2 days, we've heard serious concerns about the misuse of sanctions, including overcompliance by financial institutions, impacts on the right to health, and the politicization of unilateral coercive measures, at times to the point of overuse and abuse. These adverse impacts are very real, and we believe that the mandate is right and correct in naming them. With this in mind, we'd also like to respectfully offer some observations that may be useful to the discussion around responsibility of states. One central observation is that state responsibility, we find, is best understood as multifaceted, that states have a responsibility to act when human rights violations occur and where action lies within their power to prevent them. International law also recognizes that responsibility doesn't end at condemnation. Rather, it includes taking lawful measures to prevent and respond to those grave violations, including genocide, war crimes, and crimes against humanity. In the view of many states, including Canada, autonomous sanctions are one of the tools that they may use when ordinary mechanisms of accountability have failed. And at the same time, there's no question that those sanctions are often an imperfect tool. Their use, regardless of underlying justification, does not diminish the responsibility of those states to prevent adverse humanitarian impacts. The obligation to act against grave abuses and the obligation to mitigate harm arising from those measures have to operate concurrently. And from our observations over the past 2 days, discussions have largely isolated these two realities. And a complete account of responsibility in sanctions environments, in our opinion, must hold them together and recognize that they both exist in the real world. In our work, we've seen that sanctions, when lawfully designed and surgically targeted, can serve a legitimate purpose. And the guiding principles exist because these measures are a feature of state practice, at least for now. And given that reality, the question, in our opinion, is how these measures can be designed and implemented in ways that are consistent with international law. In our view, that means further dialogue on how to make humanitarian carve-outs actually deliver on their purpose, how to prevent civilian harm, and how to address overcompliance and its effects on the rights of due process. And we appreciate that the guiding principles have helpfully addressed many of these concerns. And we believe that continued discussion on how states can actualize both their duty to act in the face of those violations and their duty to mitigate the harm of their measures would be especially valuable moving forward. Our hope is that future conversations will hold both of these realities in view, that states have an obligation to not only respond to grave abuses, but they also have a concurrent obligation to do so in a way that doesn't promote further human suffering. Thank you for allowing
Thank you very much for your
participation.
intervention. And I saw the last hand, and I will close the session of questions with that, please.
This is really more a confession than a question or a comment. Dr. Moroz, when I saw the title of your paper, I assumed it was referring to the reputational harms to the people, to the countries imposing sanctions, not to the countries that have sanctions imposed on them. Do you think that there is any movement in that direction? That there are more reputational costs to deploying unilateral coercive measures, or is it we're still operating in a world where it really is costless to the nations that are imposing them?
Thank you very much for your question. Because before I give the floor to our panelists, and before my final remarks, I will just say I recommend to check what they write in internet about me and about Francesca Albanese in X, in BBC, Deutsche Welle, and something else. So from the perspective which is reflected there, I'm like a devil being fully bribed by a number of states and being biased by the very fact that I was born in Belarus and still keep Belarusian nationality and work at the Belarusian State University. So reputational risks are unfortunately very, very high with that, and take into account that we are pretty much beyond the time and need to finish by 6. I would appreciate if our panelists keep within 5 minutes in their responses so that I have a bit time for final observations as well. So Alexandra, I'm giving you the floor.
Okay, thank you very much. There was a lot, I think, that was brought up in the Q&A, so I don't know if, or even the comments. I would like to react to the comments. I don't know if it's appropriate to do so. I do, however, want to take advantage of my time and say that I also really enjoyed Professor Moroz's presentation, because indeed looking at the reputational damage that is caused by sanctions when we frame states as rogue actors or sponsors of terrorism is an understudied part of unilateral coercive measures. With regard to my article published in the Chinese Journal of International Law, well, thank you for reading it and for, taking it very seriously, I think. I wrote that, 10 years ago? And I think that a lot has changed, especially in the literature. I think I stand by the conclusions I came to then, but my thinking has changed quite a bit and it's evolved. So that was 10 years ago, and I've written a lot in the meantime. And one of the things I found is many of the resolutions, one of the reasons I argued that they're not sufficient to say that a norm has crystallized under customary international law was because I found that they were worded very vaguely. and of course, that might not be a shared opinion. But in the meantime, I think that there has been further work, especially by the Special Rapporteur on unilateral coercive measures, that addressed some of the questions or uncertainties that I had when I was reading those resolutions about 10 years ago. Just maybe very quickly on Alfred de Zayas's comment or question, I think there was a case, if I understood your question correctly, I believe there was a case in the Human Rights Committee against Belgium by a couple that had been sanctioned, I think, by the UN Security Council, and it was about how Belgium had implemented the sanctions against that couple. Somebody else in the audience might be more aware of the details. I would have to dig a bit to remember. I can't remember the name of that complaint. But just on the sanctions you mentioned adopted by the EU against Hussein Drogu, Jacques Beau, or Alina Lip, I'm actually hosting a webinar at Utrecht University about those restrictions and how they put fundamental rights under pressure, notably the freedom of expression, of course. If anybody's interested, please send me an email and I can send you the link to attend the webinar. I don't know if there were any other questions or comments for me, so I will leave it at that. Thank you very much.
Thank you very much, Alexandra, for your presentation and responses. I'm giving the floor to Dr. Moroso. Natalia, the floor is yours.
Well, when it comes to the damage which could be claimed when it comes to reputational issues, well, as I've commented in the very beginning of my presentation, whereas this looks a bit unclear how to qualify such practices, we already have certain prohibitions within, for example, the prohibition to intervene into domestic affairs of any state, as well as to refrain from any discriminatory practices that, in fact, deprive the peoples from their right to self-determination. And I would like to comment a bit on that. It's more about my thoughts, not about the things that I'm already sure about. But when it comes to certain violent behavior, which we usually have at domestic level, we tend to talk about dehumanizing language, which usually precedes to the commission of violent crimes. Sometimes it does not provoke them, but these kind of crimes are always accompanied by such language. And of course, when it comes to genocide and other types of atrocities of this kind, they are also every time are accompanied with this dehumanizing language. And this kind of characteristic given to states looks like as desovereigning language, depriving them the right to have any protection, even to decide whether they are the state unilaterally give them this characteristic. And from my perspective, this is a manifest violation, not only the right to self-determination, but also other collective rights, such as the right to development. Because this practice, which is used as a pretext to introduce unilateral coercive measures, in the end deprives the peoples from their rights to benefit from cultural, economic, and social development. When it comes to other possible regimes, as I've said before, it's also possible to consider that when it comes to different types of reputational damage caused to businesses as well as individuals. When it comes to the reparation for moral harm. And there is also a very interesting international instrument, which is called the International Convention Concerning the Use of Broadcasting in the Cause of Peace. There are not so many state parties to it, but however, it can be used and recalled in order also to see at certain obligations deriving from it. And of course, broadcasting is probably not so often used, but anyway, the internet is also a tool of the providing such possibility to disseminate certain type of hate speech, and so it should also be used from my perspective. when it comes to costs, indeed there is a very unclear situation for many people which are not facing these reputational challenges, and unfortunately the grounds to introduce unilateral coercive measures, restrictions in these situations are even not substantiated well, because as far as I know, the people were sanctioned because they shared opinion the same that their government expresses, because they criticize the adoption of unilateral coercive measures, or they even attend certain conferences, even without any regard to the opinion that they are going to share them. Therefore, from my perspective, all the mechanisms that are applicable here, starting with the regional level, and then the thing that already has been reflected in the comments of the Special Rapporteur, should be used in order to seek for redress and to obtain adequate and practical reparation for the harm caused. I'm really sorry because we don't have the possibility to develop this discussion more due to the restriction in time, but probably if you have any comments with respect to the commentary, which also addresses this issue, the commentary to the guiding principles on effective remedy and responsibility, it would be just great to receive them and to discuss all the opportunities how to improve them. Thank you.
Thank you very much, Natalia. Just would appreciate if those who have commentaries will forward them within 1 week, because my mandate is expiring. 2 words. I'm giving you the floor, because I have already took a deep breath to make a final statement.
No, just to clarify, because it was just mentioned, the case concerned is the Sayadi et al. Against Belgium. And the views of the committee was adopted in 2008. It is true the committee did find a violation of Article 17 because of the interference in the private and family life of the Sayadi family. On the other hand, they didn't go into the reputational damage. They went into the damage to their business. They went to the fact of violation of Article 12, because they couldn't move. I mean, their freedom of movement was strictly restricted. In any event, what makes the case important is not that. Is that Belgium said, oh no, this is a UN sanction, so Human Rights Committee has no jurisdiction. And the Human Rights Committee said, sorry, I mean, you did not exercise due diligence. You stupidly put that man who was guilty of nothing without any due process. You put him on a list, and then that list was just simply taken up and added to the sanctions list of the Security Council. There's no way that the guy could get off the list. And so you bear the responsibility for all the damage that this man suffered. But it's very clear language, especially by Sir Nigel Rodley in his concurring opinion, and by Yuichi Iwasawa, the current president of the International Court of Justice, used to be a member of the Human Rights Committee. And both of them argued something extremely important. The United Nations Security Council is not above international law. It has terms of reference, Article 24 of the UN Charter, and that means they cannot adopt any decision or resolution that goes against the purposes and principles of the United Nations Charter. They must abide to the object and purpose of the Charter. They cannot do something that is going to have major human rights impacts on people. So basically, Sir Nigel Rodley and Yuji Iwasawa essentially said these UN sanctions are ultra vires. Thanks.
Thank you very much, Alfred. You know, I will probably start my final remarks with saying that there are different criteria to identify the success of the conference. And I believe that very fact that at 5:47 Friday evening, before Orthodox Easter, people want to take the floor, to ask questions, to do comments, is a large criteria of success of the conference. The objective of the conference itself was to draw attention to the problems and to initiate further research and further discussions. Naturally, we all just scrap the surface. There are many elements which shall be discussed. And I hope very much that we will continue doing this work, to continue research, to continue exchange opinions. I hope very much that the tradition to organize conferences focusing on different legal aspects, or probably not only legal, of UCMs will continue, and the books will continue to be published. Just for our authors and participants, I would like to thank all of them and to remind that we are waiting for them to send articles to Olga, or probably to update articles and send them to Olga, those who haven't done it yet. Yes, I need to be like very time constraining because we all know that sometimes it's possible to collect chapters for 10 years without any success. But my objective is to have the proper result because we need to encourage other people to think. I believe that one of the very huge positive elements of this conference is that we managed to bring together people from different countries and different groups. What makes me very upset in general when I read books about sanctions is that in the majority of cases, they are mostly written by scholars coming from one group, either the group which imposes sanctions or the group which is under sanctions. For the second time, I do my best to encourage everyone coming both from countries imposing sanctions, countries under sanctions, those who have not been affected by sanctions to come together and to discuss. Because the international legal norms are the same for all of them, and the standards are the same. And I strongly believe that scholars can find solutions because we do not dispute that international law shall be observed. No one doubts. Unfortunately, what I see is the fact which has been mentioned by Natalia and which I reflected in my report about the impact of unilateral sanctions on the right to education and to the right of everyone to benefit from the results of scientific research, is that surprisingly, but not only scholars and people coming from the countries under sanctions, but those coming from countries imposing sanctions become more and more targeted because they are threatened to face negative repercussions. They are already explicitly sanctioned, even, as it has been said, just for coming to the conference. 4 years ago, when I was organizing at least small side events, not a large conference, I was really shocked when one of the scholars from Switzerland asked me who are the people, from what countries are people which will come to the side event. And when I mentioned that they come from Cuba, from Venezuela and Iran, he said that no, I cannot come. We are prohibited to participate in the same conference with Cubans or with Venezuelans. And I believe that is the point. When scholars cannot discuss. And that is the point. If we do not discuss, if we do not have dialogue, we might we agree or disagree with each other, and that's fully okay. That's how we find a solution. And isolating scholars from one group from scholars from another group, that is a way where violations are emergent, where fear is emergent, and where international legal order is undermined. That's why, although I will be very honest, I do not agree with every single word said by all the participants, but that's my position as an expert. They might disagree with what I'm saying, and it's, again, fully fine. That's how we find the solution. Professor Desires was advocating for advisory opinion for I do not know how many years. I'm very much against that, but it doesn't mean that we cannot...
Well, I don't trust the judges of the International
You see,
Court.
that's what I mean.
The criminal court, not, but the ICJ, yes. Iwasawa is a good man.
So, but it doesn't mean that I do not invite Professor Desires to every event I'm having and to the expert consultations, because we have extremely intense and very positive inputs. I was benefiting a lot from his participation, and same way as participation of many other experts, not all of which agreed with my position. I remember we had a British scholar, and we were shouting with him at each other when negotiating the guiding principles on sanctions, business, and human rights, and it was a very, very good experience. I would like to comment about a few other elements which probably I would propose to think about for the future research. Causality link has been very frequently cited as one of the problems. How can you prove that the damage which is caused is due to sanctions and not due to something else? And I believe the problem is not so terrible. The problem is that, that people do not want to see this causality link. If you do not want to see the facts and you do not want to see causality links, you won't see it. Sometimes it's very easy. A state used to pay for medicine to provide it free of charge. You cannot deliver it either due to direct prohibition or because of the fear of businesses or because of the prohibitions to pay to deliver to ensure people are dying. Very straightforward causality link. And that's why we get the point of shared responsibility, because people, states, businesses try to shift responsibility to each other, and when everyone is shifting to each other, it looks like no one is responsible. If economy of a state is affected and the state is not able to finance social programs to provide assistance for disabled individuals, for small children, to ensure school education, and, for example, literacy rate is decreasing, there is clear causality link. So it's not so complicated. We just shall wish to have a look at that and to recognize that it exists. Another point which I want to mention is that probably sometimes we need to look from the broader perspectives at the problems which emerge. I have heard today a couple of very interesting phrases, the question about whether the customary norm can be, whether denial of UCMs shall be qualified as opinion juris. Or how shall we treat, and that was already my thought, how shall we treat the immunities from the perspective of qualification of states as sponsoring of terrorism, denying immunity because the US legislation claims it to be a criminal charge instead of civil charge, which is not falling under the limitations of the Convention on Judicial Immunity of States and State Property. I believe that sometimes we look from the wrong perspective. We just follow the logic which is proposed for us. If we look, for example, at the issue of opinion juris in that case, I have only one question. Do we need to prove it? I believe we don't. Natalia has already responded. We have fundamental principles of international law which prohibit states to violate international law, which prohibit states to intervene into domestic affairs of state, and which request states to settle their dispute by peaceful means, and which request states to respect sovereignty of each other. Why shall we prove the existence of a new opinion juris in the situation of fundamental principles of international law? They are already peremptory norms. Same way, for example, comes to the need to prove whether state assets of the assets of central bank shall be immune or non-immune, shall be affected by the civil suits or criminal norms. Do we need to do it? From the perspective of the principle of sovereign equality of states, states are immune from jurisdiction of each other. Par in parim non habet imperium, we all know that for thousands of years. The very fact that there are exceptions from immunities when a state behaves as a private entity, this is the exception. So we shouldn't put the whole pattern upside down. We shall try to look broader, because unfortunately what I see, people who are drafting unilateral sanctions, they try to do it very clever. They use terms we know. They use these terms in the misleading way. They use term due diligence, but not as due diligence under international public law or international human rights law, but as due diligence to implement unilateral sanctions. And as a result, we all know the word. If we check online, we get lots of references to due diligence, and we do not doubt that it exists, but it's another due diligence. It's a misuse and misinterpretation of already existing norms. So therefore, when we're talking about responsibility, unfortunately, the law of international responsibility shall be viewed much broader than it is today. Yes, we all are aware about draft articles on responsibility of states, draft articles on responsibility of international organizations, but there is also responsibility for damage caused. There is also responsibility for violation of due diligence obligation of states to make sure that all private actors under their jurisdiction and control do not violate human rights. There is a due diligence obligation not to commit omissions which will end up in violation of international legal norms. And therefore, I believe we shouldn't allow ourselves to be misled and talk responsibility as retortions and countermeasures. And responding to the last questions, it's very easy to respond theoretically, it's very hard to implement it in practice. If we need to find what measures can be taken and what can be not, the response is very, very simple. States shall check whether measures they are taken will violate any single obligation in force between them and a state they plan to put pressure on. Step number 2, states shall check whether measures they plan to take fully conform criteria of countermeasures. Point number 3, states shall check whether they will not cause higher human rights damage. That's it. If these criteria are not observed, states cannot act. Hopefully, what I was calling for 6 years was, please start to behave in accordance with international law. Please start to behave in accordance with the principle of humanity. My mandate will be over very, very soon. I hope, however, that the legitimacy of very obvious approaches, humanity and respect to the rule of law, will stay and develop further. And therefore, finishing the conference, I believe that the conference was of large success for all of us. I benefited a lot of the opinions and of experts and the discussion we had for 2 days. I hope not only me. All the time, I want to thank all panelists, all people who came and participated in the discussion. But I want to thank all people who participated in the organization of the conference, because I can assure you it's a nightmare task. And multiple times I was willing to shout and not to do any conference. I want to thank also not only people who are present in the room, but I all want to thank my consultant Olga, who is participating online, because she did lots of work to help us to organize a conference, and she is in charge of the book. I want to thank all experts who helped me to draft guiding principles in one position or another, as well as all those stakeholders who ever sent contributions, when I was forwarded the call for contributions for thematic reports, country visit reports, or preparation of the document. As I said, we are still welcoming contributions for development of the commentary to the guiding principles, but we can accept it only within the very limited time because my term is expiring. And I would like to thank all those who, despite the very specific, quite often politically focused rhetoric as regards unilateral sanctions, we are open to discuss and to look for the solution. I will repeat once again what I said at the opening of the conference at the higher level segment. We can find a solution if we work together, build up a dialogue, and listen to each other. Thank you very much, and with all that, I call the conference over. Thank you.